No, that is special bench. Matter list is special bench.
That was for yesterday only, I think.
Monday, it was a default bail. Default bail.
Why don't you mention a writ petition also? Next. Senior bench. There is a senior bench. Please go to the senior bench.
Ship. I'm appearing for respondent number 2. Mention for item 21.
21.
Johnson.
You have informed the other side. At the request of the learned counsel appearing for the respondent number 2, who submits that the counsel for the petitioners have been informed. List the matter again on.
Lordship, interim may continue.
List the matter again on. When do you want it?
4 weeks.
September, first week or second week of September.
Shuddha. 22nd of September. Interim order passed earlier continues.
May it please your lordship. Also, I beg to mention item number 79, lordship.
79.
The motion matter, lordship, wrongly listed in the bail hearing column, lordship. 9.
It is with an office note.
Lordship, last occasion, matter was listed in the motion column. There was some typographical error in the translated copy of the FIR, and your lordship was allowed to file it
That motion law mati dibo.
after.
We'll call it up at the motion.
May please also. With a concern of the other side also, I will mention item number 18.
18.
18 also. Matter may list after 2 weeks also.
At the request of the learned counsel appearing for the
For respondent number 2.
respondent number 2 with prior information to the to the petitioner, list this matter again on 24th of September.
Lordship, with regard to item number 74 and 76 supplementary list matter, yeah, I may be allowed to go to the records.
Yes.
Meet pages. Meet pages, your lordship. I beg to mention item number 45.
45.
45 may be listed after 2 p.m. your lordship. Fix it for after 2 p.m.
Okay. First of all, First of all,
Yeah, please, your lordship. Your lordship, I'd like to mention an unlisted matter, your lordship.
Yes, next.
So paying for listing of criminal petition in the admission column, your lordship. Criminal petition in the admission column, your lordship. It was last listed on.
Yes.
Your lordship, the unlisted matter will be taken up at 2 p.m., your lordship.
Nothing doing.
Your lordship, because
There is a senior bench.
Lordship, the senior bench is not available today, lordship. We inquired with the court master of the court number 14, and he
Court number 9.
Not available.
not available, lordship.
So we are supposed to take it up.
Lordship. 21 is
Huh?
not sitting at, yeah, 24th, yes.
But there is no such notice. Notice as a
senior bench is not sitting today.
কি বলি মই ল'ব লাগে তো সিজনক তো এনেই পঠিয়াই দিলো মই court number 9 is not sitting till now perhaps they'll sit at 2. Okay, for listing, just for the time being, let me find out. Let him find out from the registry. We'll sit at 10:30. Division bench, so and so. The single bench of so and so will sit after. Division bench, single bench of so and so will sit after rising of the so and so. Single bench of so and so will sit. And they are just having division benches, and they will sit after the division bench. You have to make a mention there. These senior courts have a division bench. They'll sit after the division bench. Make a mention there. Get your matters listed. I'm not authorized to, sir.
There's a little bit,
Whatever I'm authorized,
there's a little bit urgency in the matter, your lordship.
You'll mention it before the senior bench. We can't help it. If the notice had allowed us, we would have definitely given.
May please, your lordship.
Hmm.
Item number 32 maybe.
32. Find out if that bench doesn't sit, we have got we have the authority to do it. We'll do it. 32, yes.
32 may be adjourned for the day, lordship.
At the request of the learned counsel for the petitioner, list the matter again on
10th of September.
10th of September.
My pleasure, lordship. Next to fix the matter, item number 62 and 63 after 2 or 3 days, lordship.
2 or 3 days would not be possible.
28 especially.
Muna say special act. So special matters can be mentioned. Special act matters can be mentioned. Ah, yes, allowed. When do you want it? Today.
And
At your risk, yes.
And UAPA.
At his risk. Special act.
Special act.
There was one more advocate who mentioned it first. If it is a special act, allow. Please call him.
Tomorrow.
Tomorrow. Monday. Monday, whenever you want. Special acts allowed. Huh?
That's it. 62 and 63,
Ah,
maybe picked after 2-3 days or any date.
এটা দিব পাৰিছো 22-23 2 or 3 কৈছে 2 or 3 থাকাটো 23 আছে 23rd
23rd.
yes
Highly advanced.
May I please, Your Lordship, I beg
23rd
to mention item number 41, AB Lordship. I have concerned other side Lordship. Kindly this matter September of 17,
September of 17 2017 is gone
17 of September.
okay 17th of September item 41 at the request of the learned counsel for the petitioner
May I please, Your Lordship?
Hmm.
With reference to item number 47, Your Lordship.
Hmm.
With reference to item number 47, case diary has not been arrived, Your Lordship, and I'm on interim. Matter may be adjourned. 47.
Current APP submits that the case diary is awaited list again on 18 September 2026
Interim till then.
the interim order passed earlier continues.
Oblige you.
May I plead, Your Lordship? Item 67,
Hmm.
seeking for adjournment.
At the request of the learned counsel for the petitioner,
Yes, yes, sir.
list this matter again on 24th of
Sir, the disputed amount has been already paid and the settlement agreement is in the process. Sir.
Ah.
Seeking adjournment for 4 weeks. 4 weeks.
24th of September.
Always.
Hmm.
May I please, sir?
Yes.
Item number 56, my lord.
Huh?
56.
Ah.
Petitioner already arrested him.
The learned counsel for the petitioner has submitted that the petitioner has been arrested during the pendency of this AB. Therefore, he seeks for a closure of the present petition with liberty to approach the appropriate forum with appropriate application. Full stop. AB accordingly closed with the liberty as prayed for.
My please, Your Lordship.
Ah.
My lord, for item number 78. My lord, 78, an additional affidavit is being
Yes,
filed,
yes.
my lord. regarding-
Yes, call for it.
Highly obliged, Your Lordship.
Hmm. Call for it.
May it please Your Lordship,
Huh?
I'd like to mention item number 53.
53. Yes.
My lord, I seek more 4 weeks time to take steps upon the private respondent. And my lord, there's certain personal difficulty. Can this matter be taken up after 2 weeks, my lord?
You are seeking 4 weeks to
4 weeks, my lord.
take steps and you want it listed after 2 weeks.
4 weeks, my lord, 4 weeks.
After 4 weeks. Ah. Learned counsel appearing for the petitioner has prayed for an opportunity to take fresh steps upon the respondent number 2.
My lord.
Prayer is allowed. The learned APP has submitted that the CD is available. The CD may be sent back for updation. Stop. List again on 30th of September,
My lord.
30 September 2026. Petitioner to take steps within a week
My lord,
as per the prevalent notification.
if interim may be continued.
Eh?
There was a previous interim order in this.
Interim order passed earlier continues. But if there is a other party, it must be a POCSO matter.
POCSO matter.
Why are you not taking steps?
My lord, it was given, but due to some clerical error, it was not taken. I just came to know, my lord. I'll take step within 2 days, my lord.
Okay, steps within 2 days, Kadiji, not 7. It will be 2 days.
I'm grateful, my lord. Much obliged.
Interim order continues, huh?
May it please, my lordship. I'd like to mention item number 33.
33. Yes.
He has not arrived, my lord. 33.
Learned counsel for the petitioner is present. Learned APP submits that the CD is awaited. List again on
No interim.
15th of September 2026. Any interim protection granted?
No, my lord.
Lordship, I
15th,
beg to mention item number 39.
39.
Yes, Lordship. In this matter, we are required to file some more documents that were not within our record earlier. So we just need some time. Can it be listed second weeks of September, 7th or 8th?
That week is full. Choose a date on the week after.
Any date, Lordship, 9th or 10th if possible.
15th,
11th,
this week already, several matters.
11th, Lordship.
14th.
11th, Lordship.
It is full, sir. We are having, we have already fixed around 15, 16, 20 cases. More cases will come from the registry. We are taking up 100 cases, 99 cases, 98 cases. Not possible. The last few cases we deal very unjustly. Not, we'll have it on 14th. List again on the 14th of September 2026, allowing the learned counsel for the petitioner to file an additional affidavit as prayed for. Obliged. Your Honor, counsel for the petitioner has submitted that he is under instructions not to present the present petition. Full stop. Any liberty wanted? We also praise for the liberty to this post court place. Full stop. BA is closed with the liberty prayed for. I'm obliged. Yes? Case diary was called for, sir.
Item 70. 70.
Withdrawal.
Yes.
The counsel appearing for the petitioner has submitted that he is under instructions not to present, not to press the present anticipated bill petition. Accordingly, the same is withdrawn, closed on withdrawal. Anything more? Yes, tell us.
Petitioner already arrested.
Huh? We have closed it. Petitioner would be at liberty to pursue such remedies as will be available in law.
That the petitioner has been arrested on 27th of July, my lord. FIR is a page plug 10.
Page?
10.
1182 and 109 is there, CD and medical report is there.
Heard, Mr.
Yes, Islam.
Yes, Islam Learned Council is paying for the petitioner. It is a bill, this is a bill application under so and so regarding PS case number so and so. Call for the case diary, list again on. Seat lege. 15th of September.
He's in jail, my lord.
Huh?
My lord, already, my lord, 32 days, my lord.
32 days, but next week or second week already full, man. Several cases, 7, 8, 9.
32 days.
Yes, what is the next number? 2. 15. 15.
Substituted matter, Lordship, Gauhati case, sir.
Heard, Mr. So-and-so, and counsel paying for the petitioner. Application 483 in connection with Nagaon PS case number so-and-so pending before the learned CJM. Call for the case day, call for the scan copy of the TCR list again on 16th? 16/16.
Obliged.
Wait, please, your lordship. My page 12 is the FIR, my lord.
You could well have obliviated some of the words in the
Yes, my
petition. Huh?
But my lord, here page 12 is the FIR, my lord.
I understand.
Here, my lord. my lord, someone, my lord, actually, my lord, as per my instruction, someone, my lord, has used my Facebook account. I am a person
Whose face was there?
my lord, my face was there, but my lord,
Who used it?
my lord, a person, he is arrested, my lord. Muxidur, my lord. Muxidur Rahman, my lord. He actually, my lord, I am a illiterate person, my lord. My lord, my academics is only till class 3.
Yes, sir. What do you say?
Modi ka I'll produce the CD, my lord, for that on 9, my lord. I'll produce.
9th. Okay. Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard learned APP, application 483, Buragaon PS case number so-and-so. Learned APP prays for accommodation to call for the CD list again on 9th of September along with the case diary.
Obliged, my lord.
List again on 8th or 7th.
8,
I
9.
am inside.
Huh?
8, 9.
8, 9. The case diary is already there. We'll call for the case diary otherwise. Same thing.
8, 9, my lord.
Otherwise, it may not require because my lord,
Oh, no.
allegation is my lord that I helped the accused.
Not after
I-
yesterday. We'll have it on the 8th. 8th, no? 8th. List again on the 8th of September 2026 along with that AB number and criminal petition numbers are there. Since the learned standing council submits that the
Along
case
with
diary
one-
would be available.
Criminal
1995 of 2026.
Okay.
AB.
Criminal
AB
AB
1995 of 2026.
when since the learned standing council submits that the case diary is available for that day. Yes.
Regular bail affixed, the FIR page 9 lordship. On the allegation in the FIR is that the petitioner involved with the theft of cow and he attempted to kill the ayol when he stopped the signal. This is an allegation lordship. Kindly see, nothing was 9 lordship. FIR.
FI page, huh?
Only allegation that they are involved with the theft of cow lordship, but such section is not added in this FIR lordship. And secondly, 109 is their lordship. 109, when they signaled the vehicle, he did not stop lordship.
No, he attempted to kill. That is the
This
first thing.
on the FIR lordship, but there is only recovery portion lordship. Kindly see page 10 lordship. FIR.
As a result, I jumped beside the road
Yes.
to save myself, sustaining.
This is only lordship. And lordship carried 10. Nothing is recovered except the cash money.
What should be recovered? Injuries?
No lordship. This is an allegation lordship.
When, sir?
Lordship entry may be given if something is there. Then
When
lordship.
arrested? When?
Lordship.
When were you arrested?
11/8 lordship.
11/8. When?
3rd date lordship.
14. That attempt, if it was not there,
Yes.
put heard Mr. So-and-so. Application under 483
Next week.
in connection with so-and-so PS case
11.
number.
11.
Learned no, call for the case diary list again on
11, my lord.
11th of September.
Madam.
6.
With the petitioner's counsel name, you have to give the PP's name also, huh?
Yeah, case of my lord, 118 subsection 2, Marpit case. So my lord, CD may be called for along with a medical report, madam.
Heard Mr. B.B. Gogoi, learned counsel appearing for the petitioner, also heard the learned APP. Application under 483, Choigaon PS case number so-and-so, call for the case diary, list again on
15. So I got 15, my lord.
15th of September 2026.
My lord, last it has came up on Wednesday, my last Wednesday, my lord. Lordship has fixed it for to take some instruction by the GST, my lord.
Who appears for the GST? What was that instruction we wanted, sir?
My lord, that grounds of error, they wanted to, my lord, take my, to
No,
provide.
someone will come, my lord. Vigo guys told me that the instruction is available.
After some time?
After some time.
May I praise the Lord? My lord, in this case is under section 22C, my lords. Petitioner is in jail since 20th of January 2000
26, my lord, more than 7.5 months, my lord.
Can call for the TCR for the time being.
My humble submission,
Ah.
I am not on merit, my lord, only on length of detention, my lord.
TCR will come. TCR will come.
Scan copy of the TCR. Heard Mr. A.H.M.R. Chaudhary. Learned Counsel appearing for the petitioner. Also heard Mr. Parashar, learned APP, application 483, special NDPS case number so-and-so. Learned Counsel has submitted that the court may consider the prayer for bail on the length of detention since the petitioner has been behind bars since 21/2026 full stop. Since the matter involves commercial quantity, therefore, this court is of the opinion that the scan copy of the TCR would be required before such an consideration is made. Accordingly, call for the scan copy of the TCR list again on
16/9.
16/9.
A short date, my lord.
Short date. Maximum 14/9. The other 2 weeks are full, sir.
14.
We have been requested not to fix anything. Okay. 7. Hatim Tai.
AB lordship.
Hatim Tai.
Lordship,
Did-
lordship, page 11 is the FIR lordship.
How is Hatim Tai caught? He's supposed to be a musician and all, is it not?
Page 11 lordship.
Stop firing off the cow was the bundle chopping the meat. AB.
AB lordship, my lord, admittedly, a cattle was slaughtered lordship for the purpose of lordship, death anniversary of the party of his father lordship.
Hmm.
My lord, considering the
Death anniversary of his father.
my lord, father of the petitioner number 1.
No.
The petitioner number.
Hatim Tai and his father were seen chopping the meat.
No,
You are not only butchering the cattle, you are also butchering the father of the petitioner.
lordship, father of the petitioner number 2 lordship. I have stated in paragraph lordship 3. For funeral rites lordship that was held on 7/8.
His grandfather.
Grandfather of the petitioner number 1. That will appear lordship and statement will be recorded lordship.
Why 325 or 325 and 35?
325
Yes.
is bailable.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP. Mr. K.K. Parashar, application under 482, Bilasipara PS case number so-and-so. Stop. The petitioner, the learned counsel for the petitioner submits that the petitioner would be willing to appear before the investigating officer to explain the circumstances and participate and cooperate in the investigation, full stop. The learned APP has submitted that an interim bail at this stage may hamper or tamper with the investigation, full stop. I am of the considered opinion that the appearance of the petitioners before the IO would help the investigation, and therefore the petitioner shall appear before the IO on or before the 7th of September 2026 to cooperate in the investigation, full stop. In the event of their arrest, they shall be released on bail on furnishing a bond of ₹5,000 each with one surety each of the like amount to the satisfaction of the arresting authority, full stop. Call for the case diary list again on
24th.
24th, full stop. It is provided that the petitioners shall not involved in any similar activity during the period of their bail.
Lots of it. May I please also. But FIR is 8, my lord.
Heard learned
12 of Fox is there, my lord.
Heard learned counsel appearing for the petitioner, also heard the APP. Then you say application under 482. Also 482, very difficult, sir.
My lord, correct.
482
It was
in
not
connection
that
with
also.
Fakirganj PS case number so-and-so. Call for the case diary. List again on, call for the case diary since the matter involves the provisions of POCSO Act. Notice on the respondent number 2 as per the prevalent notification. Steps within 2 days. Call for the CD list again on 16th of September 2026, along with the case diary and the status report and service of notice. Yes, next. Hmm.
Not 73 years old person before your lordship. Well, here, the informants are the lessee of the Silunibari daily market man. And when informant went to collect the tax, my lord, and there was, my lord, marpit there as per FIR, my lord.
What did you use?
And my lord, what happened? My younger brother is accused number 1 in the FIR, my lord.
Huh?
In the FIR, accused number 1 is my younger brother.
Okay.
In fact, I was not present.
Hmm.
Since I am the brother of the main accused, my lord, my name also has been included here. And they have mentioned 27% is present and other 30-40 also. And my lord, here the 5% already released, my lord, by anticipatory bail. And very unfortunate that I am 73 years old, ailment person. I did not came to the market of the relevant time, my lord.
Heard Mr. Enuddin Ladat Council.
Page 11.
Ah.
Specifically, he is accused number 4. Present petitioner is accused number 4.
Is it?
In page 10, my lord, page 9. Page 9, accused number 4, Umar Ali.
Yes, I have.
His name is there.
His name is there
Well,
and
I am submitting, my lord, only I am the brother. So my brother was involved in this case,
No.
accused number 1. So my name also, my lord,
My
included.
lord,
In
page
fact, I was
page
not
11.
present in the market, my lord.
Page 11, my lord.
73 years old person, my lord, such type of incident not possible, my lord.
Accused number 1, 2, 3, and 4, along with other accused.
They have written in the FIR, my lord. In fact, it will come in the case diary, my lord. Dada, it will also.
5% seriously injured.
5% already released on anticipatory bail, my lord. Because more than, they have mentioned here about 60-70% was present. My lord, regarding the high demand of tax, my lord, there was an altercation as per my instruction. No such serious, my lord, injury was there. 326 is the main section here, but the section is.
Sir, we are we have a very limited, we can read or we can listen. Heard Mr. Enuddin Ladat Council appearing for the petitioner, also heard Mr. K.K. Parashar, APP full stop. The present is an application under 482 in connection with non-looking PS case number so and so. The counsel for the petitioner has submitted that 4 persons, 4 of the accused in the present case, 5 of the persons, 5 of the accused in the present case have been granted pre-arrest bail by this court. Full stop. This court notices that the said bail was granted after perusal of the case diary, which indicated that the aforesaid petitioners were not implicated in the witnesses so far collected. Full stop. Call for the case diary list again on
15.
15th of September 2026. But Mr. Parashar, he's 73 years old.
But others, regarding others, there is not specific, specific.
73% old, my lord.
Your name is
73
there.
years old person.
They are very fit.
We tried to consider it, sir. We have tried to evaluate both your orders and that.
My lord, kindly may protect on interim, my lord. All element person, my lord.
No, if those are the things which are screamed,
In fact, my lord, CD will reveal no injury. my lord.
If there is nothing, we'll follow that order. When? 15th of
15 is some long, my lord, so
11.
11th of September.
11.
Is there not?
Yeah, please, my lord.
Ah.
FIR is at page 14.
Ah.
The allegation is that, my lord, petitioner has engaged two persons for illegal coal mining, my lord. And my lord, they slipped from the hill and they died, my lord. My lord, the petitioner is running a, my lord, coal industry.
Where is the permit?
My lord, page 20, my MSME registration certificate, my
Where
lord.
is the permit to take out coal?
My lord, there is an industry, my lord. They are not taking out the coal, my lord. MSME registration certificate is there.
Huh?
MSME registration certificate.
There is no permit required for carrying out coal.
No, I'm not carrying out coal, my lord.
Then?
There is an industry, my lord. The where the
Who was carrying that coal?
Well, the persons who were who died, my lord.
From where?
There is industry, my lord, and they inside the industry they were carrying the coal.
In the mining area,
That is not
situated in hilly region of so and so.
my lord. My case is that is not a mining area, my lord. I have an industry, coal industry.
Case diary will. MSME registration where?
Page 20, my lord.
Yes, Mr. Parasha, two persons slipped and fell. Custodial interrogation necessary. Not that he had pushed them or he was taking out coal. They were carrying coal. Industry. Huh? Heard Mr. A.K. Gupta, learned counsel appearing for the petitioner, also heard the learned APP application under 482 praying for grant of pre-arrest bail in connection with Margherita PS case number so and so. Please stop. The call for the case diary list again on 24/9/2026 full stop. In the meantime, it is provided that the petitioner shall appear before the investigating officer of the case to participate and cooperate full stop. In the event of their arrest, they shall be released on bail on punishing a bond of rupees 10,000. How many? One. Petitioner, huh? He shall be released on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the IO. You see, in the event of the arrest of the petitioner prior to the next date of listing, huh? You make that paragraph, you keep that paragraph ready for all AB that I grant. It will be the same paragraph everywhere, always. Huh? Yes, Mr. Bhuya.
Sir, my pleasure. I apologize, Lordship. Item 62 and 63. I thought that my colleague taken discussed with other side, but he told me that he has not taken consent and kindly matter may be come up.
Borua. Item 62, 63 mention কৰিছিলে এটা ঘূৰাই ৰাখক ইটো পাৰ্টি খবৰ দিয়া নাছিল সব মাতিব মেটাটো মাতিব উঠিলে দেখা যাব হ'ব
Okay.
yes
May I please, your lordship? My lord, this is a case, my lord, wherein the POCSO has been entangled, my lord. Although, my lord, from the records material, my lord, the available, my lord, my lord, understanding is that POCSO may not be attracted, my lord.
why
My lord, I beg to draw my lordship's attention, my lord, to the FIR is at page 20, annexure 1.
yes
With due respect, I beg to submit that on so-and-so at about 6 p.m. So-and-so month was returning home from her tuition classes at that time. The above name accused person lured and abducted my daughter from in front of my house by making the various false promises and enticing her with the sweet words, including an assurance that he would marry her. Later, upon learning that the accused person's family had come to know that my daughter was being searched for the assistance of the police, they brought my daughter to the police station and handed her over to the police. There was a delay in lodging the FIR. I was searching for my daughter. Therefore, I humbly request your good self to kindly take necessary action against the accused person in accordance with law. Now, my lord, I beg to draw my lordship's attention to the statement of the alleged victim, which she had deposed, my lord, during the course of the investigation, my lord. My lord, may I kindly turn to page 28, my lord.
Page 28.
28, my lord, this
Ah.
is, we have, my lord, we have also typed, but I am drawing this original one, my lord. The alleged victim states that on so-and-so at about so-and-so, while returning from her tuition, she eloped with so-and-so when she had known since last 25 days. She eloped with him and his uncle's house and stayed there for 4 days. They had physical relationship, my lord. Now, my lord, this physical relationship had been examined by the doctors, my lord, and therefore I beg to again draw my lordship's attention to the medical report, my lord, which is available. My lordships may be pleased to find. Starts at page, my lord. Page 24, annexure 2, my lord.
Ah, we have seen.
My lord. So, my lord, therefore, there is no, my lord, involvement of any, my lord, that this section 4 of the POCSO Act is required to be proved, my lord, that there is a assault of such nature, my lord. I am not uttering the word, my lord. Section 4 says the penetrative punishment for so-and-so assault. Now, this 4 is not.
You
present,
are?
my lord. I am the, my lord,
Person with whom eloped.
whom eloped, my lord. That's the issue, my lord. These are the.
We'll have to see the 164 and all.
My lord, my lord.
Not prior to that.
No, my lord,
Not
I am
prior
not,
to that.
my lord, I am not asking for interim also today because this is a matter of POCSO, my lord. This informant is required to be heard. My lord, in the meantime, charge sheet has been filed, my lord.
Ah.
Charge sheet has been filed. So that development is there. I have also annexed the charge sheet showing me as an absconder, my lord. So my lord can
We'll
call.
call for the TCR.
My lord,
Hmm.
my lord.
An heard Mr. A.R. Bhuyan, learned senior counsel, assisted by IS
R. Yasmin.
R. Yasmin, my lord.
RS.
My lord.
Full stop. Mr. K.K. Parasar, learned APP is present. Application under 482, Mayong PS case number so and so. Since the allegations involve the provisions of the POCSO Act, issue notice to the respondent number 2 as per the prevalent notification. Full stop. Steps by the petitioner within 2 days. Call for the case diary, list again on,
Lord, TCR
call
may
for
be-
the scan copy of the TCR,
Right.
list again on 18th of September
My
2023.
lord. Stop. Obliged.
May I plead your lordships?
Hmm.
This is the petition of 482. Under section 329, 64, 118, 117, 302 BNS Act. My lordship, kindly peruse the FIR, page 15. In this FIR, my lord,
Hmm. We are
the
reading.
Jahangir name is there, who is outsider of their family. The informant, my lord, Gulapi Bibi, is a cousin of all the accused, other accused, means 2 to 6, my lord. One is the father, sister-in-law of the accused.
Hmm.
2 is the aunt of the accused. All are, my lord, except Jahangir, they are cousins and they are staying inside same boundary, my lord.
Campus.
It is stated that in the affair that at 10:30, 10:30, accused number 1 came to her house, my lord. Then she shouted, my lord. When she shouted, she stated that the cousins were entered her house and beating her. How comes, my lord? Because someone is auntie, someone is a sister-in-law of their head.
They must have thought she.
And my lord,
calling-
and the incident took place 26/7/2026, but she lost the affair on 38/7/2003. It's a false case. Of course, Jahangir was there, but he is fled away because of their cousins, my lord. This is the case actually. They are not involved in this case because they won't be able to beat their own auntie and their sister-in-law, my lord.
Yes, sir.
Interim may go, my lord.
Sir,
for the
internal
case.
family.
This against Jahangir.
Jahangir, yes.
56 years, 57 years.
Yes, they are
Yes.
accused number 2 to 6.
They That they can explain. Okay, heard Miss K. Devi Learned Counsel appearing for the petitioner. Should we say along with? No.
No, I'm not taking till now.
No. And then can be there. Also
Next time,
heard,
next time.
heard, also heard the learned APP, Mr. K.K. Parashar, full stop. Petition under 482. Praying for
Gulabganj
rearrest
PS
bail
case.
in connection with Gulabganj PS case number
181.
181, huh?
Yes, my lord.
181 of 2026, full
2026.
stop. The learned counsel for the petitioner has submitted that the petitioners are the accused number 226 and they are the relatives of the informant. Full stop. The learned counsel submits that there is no allegation of any physical attempt on the. The learned counsel for the petitioner has submitted that the petitioners would appear before the investigating officer and participate and cooperate in the investigation process. Full stop. Learned APP has objected to the grant of an interim protection. Full stop. However, I am of the considered opinion that the petitioners should appear before the investigating officer and participate and cooperate in the investigation, since it has been stated that they stay in the same campus as that
Yes.
of the informant. Full stop. Accordingly, the petitioner shall appear before the investigating officer on or before 8th of September 2026 and cooperate with the investigation. In the event of their arrest prior to the next date of listing, the petitioners shall be released on bail on furnishing a bond of rupees 10,000 each with one surety of the like amount each to the satisfaction of the investigating authority oblique arresting authority. Full stop. Call for the case diary list again on 24th of September 2026. Uske upar when her submissions are there, you write that petitioner number 1 is a senior, the learned counsel for the petitioner submitted that the petition number 1 is a senior citizen aged 66 years and the petition number 3 is aged about 57 years and the petitioner number 2 and 4 are aged about 28 and 38 years and are relatives. Okay, na?
Yes, sir.
That is how you do it.
13 lordships kindly peruse the FIR, my lord. Actually, what happened, my lord, one person who is not related to the accused, my lord, he lost an FIR. The accused is petitioner is already married with the lady, my lord, and she is aged about 24 years. And in search sheet, it is shown that I'm absconder, my lord. The FIR was lost by someone who is a neighbor of the girl's house, my lord. Because of he did not see the girl long back, so he lost the FIR. This is the case, my lord. They have already married and they are staying together.
But he
peacefully.
already has a wife
Yes, my lord.
and now he has got a second wife.
No. Nothing. He married only that girl, particular girl, my lord. And in search sheet, it is shown that they themselves stated that she is 24 years old, my lord. Because she got date of birth is 31/1/2004 and registration 3/2/2004, and they have stated that her age is 24. 22 at the time of occurrence, my lord. I make a party to my wife, my lord, because they have shown that I'm a absconder. That's why, my lord.
Oh, you show us the sentence where they say that it is 24 years.
No, my lord, that the date of birth is, lordship, if you seen that her date of birth is, lordship,
2004.
31/1/2004. At that, yes, 4. The time occurrence as per FIR 22/2023.
At page 23. Date of birth is 2004.
4, yes.
Date of occurrence is
22
23.
to 23.
23.
Forcefully marry me, Malat page 19. But FIR lodged in subsequently, Malat. Marry in March 22.
22 and 2000.
No, 23 to
18.
Abhijugnama. Obhijugnama, it is stated that 2/2/2023.
But subsequent to that, my lord, forcefully married in March 2022.
22. So if she,
It's a presumption, my lord.
if born in 2004, in 2022, she would be 18.
18
Yes,
years.
in March.
Yes.
Date of birth is January. The wife is a respondent here. Huh?
Yes, yes, I'm
Yeah,
with the
no.
party because it's a section,
Charge-sheeted.
yes, charge-sheeted. Because it is read with 4 and 17 POCSO Act. That's why, my lord. And the FIR who filed the FIR, my lord, he is a unknown. He is a neighbor of the girls.
Heard Miss K. Deville on account.
That may be observed, my lord.
Yes,
regarding
yes,
the
yes.
age.
Everything
Everything
we'll
is-
mention it. Heard Miss K. Deville on a counsel appearing for the petitioner. Also heard Mr. K. K. Parashar learned APP full stop. This is an application under section 482 of the BNSS in connection with Agomani PS case number so and so. Full stop. The learned counsel for the petitioner has drawn my attention to the FIR lodged on 2/2/2023, where an allegation has been made that in the month of March
Yes.
2022, the alleged victim,
Yes.
whom he knew to be whom the informant knew to be a school-going student, had been married off to the petitioner herein. Full stop. The learned counsel for the petitioner has thereafter drawn our attention to the Caesar list, where the birth certificate of the alleged victim has been shown to be seized and her date of birth has been shown to be the 30th of January 2004. The learned counsel for the petitioner accordingly submits that there is every possibility that even if a marriage had been taken place between the present petitioner and the respondent number 2 in this bail petition, in the month of March 2022, the alleged victim would have crossed the age of 18 years and therefore she has prayed that since the petitioner and the respondent number 2 are now leading a conjugal life in accordance with law, the petitioner may be granted the privilege of a pre-arrest bail in connection with the trial, which will now commence due to the submission of the charge sheet. Charge sheet submitted.
Yes.
Due to the submission of the charge sheet. Full stop. The learned APP has submitted that the fact as to whether that the victim was a minor at the time of marriage or not has to be proved in the court of law, and allowing the petitioner a privilege of pre-arrest bail at this stage may result in influencing the respondent number 2, the victim. Full stop. Having regard to the date of birth of the petitioner, the date of the alleged marriage, I am of the considered opinion that the petitioner can be granted the privilege of a pre-arrest bail during the period of trial may be granted the privilege of a pre-arrest bail for the time being before the scanned copy of the TCR is produced by this court.
Yes.
Let us produce it. I don't know what more will be there. But she's not a minor now.
Now not my-
Granted fully. We will cut out that line. You see, in view of, in consideration of so and so, of her age and the date of marriage, I am of the considered opinion that the petitioner can be granted the privilege of a pre-arrest bail in connection with.
Agamuni PS case 26.
You say it is charge sheeted, so there must be some other number. Charge sheet number in connection with the trial which may commence pursuant to the charge sheet submitted in connection with Agomani PS case number 26 of 2023
87
before the court of the, in the court of the
session court. CGM. No, POCSO.
Should be before.
Special court, my lord.
Special
POCSO is there.
special
Special
judge,
court.
POCSO Dhubri. Stop.
Accordingly,
Accordingly, the petitioner on his appearance before the special judge POCSO Dhubri shall be released on bail on furnishing a bond of rupees 10,000 with two local sureties of the like amount to the satisfaction of the learned trial court. Full stop. Anticipated bail petition accordingly disposed of.
Oblige.
1/4.
That please the court, my lords.
Hmm.
Let's the allegations in this case, in this FIR, is that certain articles were recovered from the two accused persons' possession, my lords, and that these items are suspected to be stolen. Let's now, at the very outset, my primary submission would be, my lords, all these items that were recovered were never recovered from the applicant's house. They were recovered from the co-accused's house, who is already in custody. Secondly, my lords, the person, not only is the person in custody, but all the incriminating evidence and articles are already in police's possession. Now, there is nothing to tie the petitioner with these items in the first place. And secondly, more importantly, my lords, there's nothing, no material on record to show that there is a predicate offense or a predicate FIR or a predicate complaint that says that these articles are missing from the rightful possession of the owner, my lords.
Your name is,
My lords, Abbas Ali.
and your house was searched.
Yes, and nothing was found. Your lordship may kindly come to the seizure list, my lord. Yes, my lord. At page number 25. Yes,
On arriving at the rented house of so and so,
at Panchari.
he was found absconding.
Yes, he was
I
not.
searched the rented house in presence of 2 witnesses. And
In a, I
during the
searched
search, I found descriptive items so and so, so and so. You are saying not recovered from your house, sir?
Yes. So let's these items were recovered from Sahidul. These items are not recovered from Abbas Ali's house, residence, my lords.
Whose house?
Your lordship may kindly come to page number 30. Your lordship will find here. The police first searched the residence of the applicant. They found nothing, and then they proceeded to the house of the co-accused. I, so and so, hereby reach a search and seizure at the rented house of Muhammad Sahidul Islam. And from here, these articles were recovered. From here, these articles were recovered. So, the previous document that your lordship has just produced, there it is clearly mentioned by the police that they first searched my house, they found nothing, and then they proceeded to my brother-in-law's house, and it is there that they found all these items, and then they seized it, and then they remanded it to their custody, my lords. Secondly, I was also not there, my lords. Nothing was found from me.
Seizure list says something else, FIR says something else.
That is, he first searched his house, nothing, first searched his house, found nothing, and then from the rented house. So, now the
He is giving the house on rent to someone.
Sahidul Islam, who is residing in rented house. Who is rented house, my lord?
Apprehended.
Maybe he is the owner of the house.
Oh, if we go by the tenant committing an offense and you pick up the owner of the house, sir, so many people would be running for their lives. And what is this sonography? Something was found in the stomach also.
My wife is pregnant with it. So I'm just putting it before your lordship.
I will allow him to appear, sir.
Yes, please.
When the recovery is not from his residence and only from his tenanted premises.
Secret information was received that it will be in Abbas Ali's house.
The tenant may not be well known by name. So people know the owner of the house. Omukor ghorat ase. Are kabata ghor pale? We'll allow him to appear. Heard, Mr.
A. Sahul. A. Sahul.
A. Sahul, learned counsel appearing for the petitioner, also heard the learned APP. Mr. K.K. Parashar, full stop. Then at page 1, you'll take application 482, Dibrugarh PS case number so and so. Learned counsel for the petitioner has submitted that as per the FIR, upon a search being made in the premises of the petitioner, certain items alleged to be stolen items were recovered, full stop. He has, however, again drawn our attention to the search and seizure list, according to which the entire suspected stolen articles had been recovered from one of his tenants' residence, full stop. He accordingly submits that the petitioner is not connected with any stolen items, and the petitioner is willing and ready to participate and cooperate in the investigation process, and therefore he may be allowed an opportunity to appear before the investigating officer, full stop. Call for the case diary list again on
25th.
of September 2026, it is provided that in the meantime, the petitioner shall appear before the investigating officer of the case on or before the 8th of September 2026 to participate and cooperate in the investigation process. Full stop. In the event of the arrest of the petitioner prior to the next list of listing, he shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the IO/AO. Full stop.
So grateful.
May I plead your lordship? FIR page lordship, 12 lordship.
We understand you carrying cows. Why were you carrying teeth? Why you are carrying cow teeth?
Lordship, I am the owner of the vehicle, lordship. Actually, driver and the handyman was arrested and they're sent to judicial custody, lordship. Police call me, lordship. Lordship, I will cooperate.
Did you appear?
No, lordship. I will, police call me, lordship.
Then?
I will cooperate with the investigation, lordship.
They've called you over phone?
Yes, lordship. I'm owner of the vehicle, lordship. Kindly turn to page, lordship, 17, lordship. I'm the registered owner of the vehicle, lordship. Already, cattle has been seized by the concerned police station. And my
You do
driver
not know
took
what
the
is being
vehicle.
carried in your vehicle.
My driver take the vehicle, lordship.
You don't know where your vehicle goes around.
No, lordship.
You buy the vehicle and forget about it, giving it to the driver.
No, lordship, driver, sometimes.
You did not take the rent for the vehicle.
Yes, lordship.
Did you take the rent or not?
Yes,
For the vehicle you took, you knew there were cows inside. You did not ask for the papers.
I have no knowledge, lordship.
About what?
About that incident, lordship.
About the cows.
Yes, lordship.
So what did you give the vehicle for?
Lordship, police call me, so let me appear, lordship. I will cooperate with the investigation.
Your name?
Bobidul Islam, lordship. Bobidul Ali, lordship.
Heard Mr. Bobidul Ali.
No, lordship. My name is Hawk, lordship.
Heard Mr. S. Hawk, learned counsel appearing for the petitioner. Also heard Mr. K.K. Parasar, learned APP, full stop. The decision made application number 482, Kusugaon PS case number so-and-so. Learned counsel for the petitioner submitted that his car had, and that the car of the petitioner, that the vehicle of the petitioner had been taken on hire. And the driver and the what? Driver and?
Driver
Helper.
and handyman, lordship.
Driver and handyman
Already arrested.
were taken into custody on the allegation that they were carrying stolen cattle inside the said vehicle. Full stop. The learned counsel for the petitioner submitted that the petitioner would be the petitioner, who is the owner of the pickup vehicle, would be ready to participate and cooperate in the investigation given an opportunity. Full stop. Call for the case diary list again on the 25th of September 2026. Full stop. It is provided that in the meantime, the petitioner shall appear before the investigating officer of the case on or before the 9th of September 2026 to participate and cooperate in the investigation process. In the event of his arrest prior to the next date of listing, he shall be released on bail, furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the arresting authority.
Deeply obliged.
60.
May it please your lordship.
Yes, sir.
Pre-arrest bail, my lord. Lordship, my lord, kindly have a look at page 16 for a once, my lord.
16.
16, my lord. So the first line, my lord. May I read, my lord? I conducted a search of the vehicle. During thorough search of the truck, it was observed that one secret chamber have been fabricated inside the right side so-and-so panel of the vehicle. The chamber was concealed with an iron plate fastened with 2 screws. On opening the concealed chamber, one green color rope was recovered. My lord, from that chamber, my lord, 671.5 grams of heroin and 22,000 of yaba tablet have been recovered. And the driver of the vehicle has been arrested. Now, your lordship may kindly have a look at page 22, my lord. 22, my lord, the last line, my lord. The entire search and seizure process was conducted under videography and the photography to ensure transparency and legal compliance. After completion of the operation, the accused along with the seized articles were brought to Howley Police Station at 8:40 p.m. and the case property was deposited in the Malkhana for the safe custody.
Okay.
The accused, Akas Ali, reportedly disclosed that during interrogation, the contraband had been transported for illegal sale and distribution. The accused person are requested registration of the case under relevant provision of the NDPS Act, and the accused and the unknown owner of the vehicle bearing vehicle number so and so. Lordship will find the unknown owner of the vehicle. Now the owner of the vehicle is one Ismail Hussain, my lord, and he had a garage, my lord. And earlier, my lord, I worked in that garage, my lord. So now a 67 notice has been served upon me that your lordship will find at page 27, my lord. The last page, my lord. Whereas information have been received and enquiries are being conducted regarding the above mentioned case involving offences under the Narcotic Drugs and Psychotropic Substances Act 95, it appears that you are in possession of information, my lord, and information relevant to the investigation. I may be allowed to appear before the IO, my lord. Till then, my lord. Admittedly, my lord, I work under Ismail Hussain, the owner of the vehicle.
And when did you leave work? Are you still working on?
No, I am working in another garage, but I have a own garage.
As a what?
I had a garage, man.
As a what? You were working as a what?
No, I had a garage. I am having a garage.
You worked under that person
As a
as a
mechanic,
what?
as a mechanic, my lord. As a mechanic.
What kind of a mechanic? If you are someone
Huh?
who's
Oh, sorry, my
a
lord.
welder and all.
My lord, my friend is as a manager, my lord.
Huh?
As a manager, my lord. I have categorically stated in paragraph 2, my lord.
You've given him a notice to appear, let him appear, bring on materials on record that he's involved.
My lord.
Otherwise,
Will consider recalling, huh?
regarding owner of the vehicle also, but
He is giving the name of the owner of the vehicle.
name has been given, but
We'll record it in the order, no
Yes,
problem. Huh? Given him a notice, he has received it. When should he have appeared?
Within a week.
15/8, okay. Heard. Mr. Angelotto, learned counsel appearing for the petitioner, also heard Mr. K.K. Parashar, learned APP, full stop. Petition under so-and-so in connection with Howley PS case number so-and-so under 21C, 22C, 25 and 29 NDPS Act, full stop. The learned counsel for the petitioner has submitted that the petitioner earlier used to work in a garage which was owned by the owner of the vehicle in which some contraband substances have been recovered, full stop. The learned counsel for the petitioner has submitted that the petitioner had stopped working in the aforesaid garage and now he owns his own garage. Now he owns his own garage, full stop. Earlier he was working as a manager in the aforesaid under the owner of the vehicle in which the contraband had been found, full stop. The learned counsel has submitted that the petitioner has received a notice under section 67 of the NDPS Act and although willing to appear and participate in the investigative process, he apprehends that he may be arrested on his appearance, full stop. Accordingly, he prays that given an opportunity, the petitioner will appear before the investigating officer as required on a date fixed by the court if so required and participate in the investigation process, full stop. Although the provisions of section 22C are reflected in the registration of the case, since the petitioner has been issued a notice under section 67 and further, since the petitioner, it has been submitted that the petitioner is not associated in any manner with the with either the owner of the vehicle or the vehicle itself, I am of the considered opinion that the petitioner can be allowed to appear and appear in response to the notice under section 7 of the NDPS Act on 25th. No, he'll appear on 9th. On the 9th of September 2026 before the investigating officer and participate in the investigation process, full stop. This is only an interim, no. In the event of his arrest, before the next date of listing, the petitioner shall be released on bail on furnishing a bond of rupees 10,000 with 2 sureties of the like amount to the satisfaction of the arresting authority. Full stop. It is made clear that this is only an interim measure which will be reconsidered on receipt of the case diary to be produced by the learned PP on 25th of September 2026. Full stop.
I'm obliged. One more
Please
point.
take it on 25th.
Whether the notice was issued by a sub-inspector, whether he is empowered under the act.
That we will do on the
Yes,
next date.
I'm
Right,
obliged.
right now, the ICU.
My lord. I'm obliged.
Physiotherapy will come later, sir.
My lord.
Yes. 17.
May I please, your lordship? Lordship, 482 application and FIR is at page number 8. Allegations, sir, lordship, under section 89, 69 and 351(1). Lordship, the allegation is that the petitioner had established physical relationship with the informant, lordship, with a false promise of employment and marriage, lordship. And the incident FIR itself does not maintainable, lordship, since the incident took place in the year 2021, lordship. And FIR has been lodged now, lordship, in the year 26, lordship.
Hmm.
And section 69 also does not attract, lordship. He is not the employer, lordship.
69 is there.
Yes,
Well, he is the
but
main,
he is not the
he
employer.
is the main person, is there.
He is the main person. To do what? Kindly read ahead. What has he done? We believe the FIR. Yes, Mr. Parashar, we'll believe the FIR. She gets a job by that means. What does she do to the office?
She is a major girl, lordship. Major girl
Once-
consenting.
Why did she go with him? Offer of a job. And what will happen to the office that she joins for a promotion? Heard. You are Miss Deka.
G deck.
Miss G. Deka, learned counsel, appearing for the petitioner. Also heard Mr. K.K. Parashar, learned APP. Full stop. The present is a bill petition under section 482 of the BNSS seeking pre-arrest bail in connection with Gorchuk PS case number so and so. Full stop. The learned counsel for the petitioner has submitted that the allegations leveled in the FIR dated 8/8/2026 relate to the year 2021. And the FIR also indicates that the informant had allowed establishment of physical relationship on false promises of being arrangements being done for her employment. Full stop. The learned counsel for the petitioner has submitted that all the allegations are false and even if believed to be true are more than 5 years old. Full stop. She therefore submits that the petitioner may be allowed the privilege of an interim bail to appear before the investigating officer and participate in the investigation. Full stop. Call for the case diary. List again on 24th of September 2026. It is provided that the petitioner shall appear before the investigating officer on or before the 8th of September 2026 to participate in the investigation process. In the event of his arrest prior to the next date of listing, so and so 10,000 rupees with 1 surety of the like amount.
Nowadays, by deceitful means or promise to marry, deceitful means, these are around 69 up to 10 years. Earlier it is not there in 376 into not there. Now separate section 69 is there. There. Assurance of marriage, that is there also there.
Assurance is always there.
Yeah.
Now this assurance of marriage, I don't know, morally, culturally, legally, or even or in all senses, if you get a appointment letter, you don't say people I have been appointed. Once you join, you say I have joined. Is it not?
That is there. That is
An offer of appointment is not the joining letter. You don't draw salary before that. Why take steps before the promise is validated? Yes, ma'am. Thank you.
Obliged.
76.
73 this happening.
May I plead your lordship? Lordship, this is a 482 application, my lord. On 14 laws before this judicial magistrate, my lord.
73. Yes.
This is a 482 application, my lord. Last date of appearance is, my lord, 7/9, my lord. Judicial magistrate, Kasa Shilpar, my lord.
Title suit.
No, no, my lord, I have annexed this order, my lord. Actually, my lord, this is a long dispute between this, both the parties, my lord. And,
Tell us the
my lord.
huh?
False FIR laws, my lord, page 19, my lord.
Page 19.
19, my lord.
What is it?
Complainant filed this FIR, my lord. FIR and said he's dueling houses, my lord.
You used firearms.
Yes, my lord. Actually, this is false, my lord, falsely, my lord.
You set the house on fire.
Yes.
2024.
That is also a complaint case, not an FIR.
Now, my lord, appearance, someone was issued and next date of appearance is 7/9, my lord.
Complaint to.
No, you were supposed to appear on 27.
That petitioner was absent, my lord.
Why? Then what happened?
Now, my lord, next date is fixed on 7/9, my lord.
And what is this revision?
Yes, my lord, notice was issued, my lord, on this.
In criminal petition.
Yes, my lord.
Interim prayer was not granted because of.
Huh?
Interim prayer was not granted in the criminal petition, that's why now.
Relegated. Sent here. Go and file a proper application. Now, NBW is issued.
Yes, my lord.
NBW is issued.
No, my lord, only someone issued, my lord.
You did not appear on that day.
No,
What
my
is the order of that day?
Another date fixed, my lord.
Summons if received.
7/9, my lord, fixed.
No, summons if received. What has happened thereafter?
Available warrant, don't know. my lord.
What has happened?
I only heard that the next
Find
date is
out,
fixed,
find
my
out. It is available mostly in the CIS system and all that.
Yes.
my lord. On
Find out what is the order on 27 and the later orders.
my
If
lord.
there is an NBW, then I will not be entertaining a anticipatory bill petition, okay?
That also, my lord,
If it is not an NBW but something else, then I may rethink.
that order, my lord, showing that the petitioners are present and.
Petitioners,
Yes, my lord. Next date is fixed on 7/9, my lord.
Present.
What about the notice part? You have received the summons when?
If someone is, my lord, 27 to 26, my lord. Page 25, my lord.
Give us the orders of CR case number 40 of 2024.
My lord.
Dated.
What has been passed on 27/2026 and any date thereafter.
Sometimes I'm
Give us those orders at 2 o'clock, 3 o'clock, 4 o'clock.
after sometimes, my lord.
After some time, whenever you want. Get us the orders.
Hey, praise the Lordship. Lordship, here is bill application, Lordship.
Corrected?
Lordship, correct. Allegation is this, Lordship, on Hanif Ali on the pretext of cutting wood, Lordship, took his wife to a Rangamati hill and killed her and concealed her body, Lordship. He also disclosed before the police that he had murdered his wife, Lordship. That Hanif Ali is not the petitioner hearing, Lordship. Petitioner number 1 and 2 is the brother of said Hanif Ali, and 3 is the sister-in-law of the Hanif Ali.
Any allegations against them in the FIR?
That instruction of the accused petitioner, Hanif Ali took her to heal, Lordship. That
This, the brother and the sister-in-law, they asked Hanif Ali to take and cut her into pieces like that.
That only instruction, on the instruction of that is written in the FIR, Lordship. Moreover, Lordship, on the day of occurrence.
Just a minute. My informant's sister who accused Hanif Ali. Accused Hanif Ali continues to instigation of the co-accused Amir Hamza, Mughal Sheikh, and Amir Hamza, Mughal Sheikh. Yes, sir. They instigated and he did everything he had to do. They can go and appear. Heard, Miss?
F in does, Lordship.
Learned counsel appearing for the petitioner. Also heard Mr. K.K. Parashar, learned counsel, learned APP, full stop. Petition under 482 in connection with Bagribari PS case number 36, full stop. The learned counsel for the petitioner has submitted that as per the FIR, it was at the instigation and advice of the present petitioners that the prime accused had allegedly caused the death of his wife. Full stop. The learned counsel for the petitioner submitted that the petitioners are not involved in any instigation and they would readily appear before the investigating officer to participate in the investigation process. Full stop. Call for the case diary list again on 25th of September. 28th. 28th of September 2026. Full stop. It is provided that in the meantime, the petitioner shall appear before the investigating authority on or before 7th of September 2026 to participate and cooperate. In the event of their arrest prior to the next date of listing, 10,000 each with one local surety of the like amount each to the satisfaction of the IO.
How less than?
26.
Uh, 26.
26, my lord, it's a bail cancellation, my lord.
None appears for the petitioner on
Not
call.
a bail.
None appears for the petitioner on call list again on 18th of September 2026. Mr. Goswami, learned APP is present. Miss A. Muzumdar, learned counsel representing. Respondent number 2 is also present.
27. 27.
May I please, your lordship. My lord, here in this present case, lordship, the petitioner was arrested on 16/1/2026.
13/7/2026. What it was referred to? It was referred for.
Referred from.
What happened after that?
Thereafter, that 36, lordship.
36 and 48, huh?
36, lordship, the honorable division bench has passed the order merely because of the violation of section 36 would not entitle the petitioner to be released on bail. There should be some other
aspects
ground.
also.
Yes.
Okay.
My lord,
What is the other ground?
Lordship, other ground is, lordship, page number 17.
Page number 7.
36 is there, that is admitted. And then page number 17, the FIR.
36 violation is admitted.
Admitted.
Now page number 17.
Section 50, lordship. Page number 70. Second paragraph. At about 6:20 p.m., we reached near Poamara bypass near the so-and-so dhaba, and as instructed by Honorable S.P. Bhumi Madam, Deputy SP Border, Shri Manas Pratim Chaudhary sir is also arrived at the spot to assist me. Meanwhile, at about 6:25 p.m., two numbers of suspected persons were seen carrying a polythene bag and floating on the side of the road of NH08 near so-and-so dhaba. Seeing police, both the persons tried to escape. However, with the help of the accompanied PS, I managed to intercept them and both of them were detained. Thereafter, I called two witnesses. These are the list of witnesses. Next page, next paragraph. Before starting the search process, a body search of me and other accompanied staff with
No, show us the violation quickly.
Lordship, my lord may kindly come to the next page. I serve notice under section 50 to the detained persons for conducting their body search in presence of Deputy SP border search and independent witnesses. So Lordship, so far as this Deputy SP border, he was a part of the raiding team. Second paragraph, second line. Lordship, this is the violation, Lordship.
No, he
Yeah.
was not a part of the raiding.
Yes,
team.
Lordship.
He was there to assist you.
You are there to assist.
Huh?
Meaning thereby he was connected. to the
Gazetted
raid.
officer to allow the
No,
conduct
no,
of the search.
Before we were there, Lordship, he was there.
Could be.
He should not be connected anyway with the raiding team. That is what the Honorable Apex Court has said.
He is not connected.
He is connected.
Where?
My lord, that second paragraph, may I read one second?
He,
Only two
as
lines.
instructed by so and so,
So and so at
also
6:20 p.m.
arrived at the spot to
at
assist.
6:20 p.m. My lord, at 6:20 p.m. Honorable SSP Shivbhumi, Madam Deputy SP Border Shri so and so also arrived at the spot to assist me in raiding.
Yes.
And
That by itself may not be a, my lord, violation.
So
And
36 gone,
36 gone.
according to you, 50 gone.
50 gone and 50 are another thing, my lord. Regarding 50, lord, may kindly come to the next paragraph, my lord, in page 18, my lord.
Page 20.
Page 18, my lord.
Uh,
During search, from where I want to rely on, my lord, where the contraband, where from it is recovered, my lord. That is what I want to say, my lord. During search, the detained person we recovered such and such brown color package wrapped with plastic and rubber band, and inside brown color, black color pouches in each containing 200 numbers are suspected to be Ava tablets, and such number which was kept concealed in a black color polythene bag inside a orange color polythene bag that were carrying with them in presence of the independent witness. It was from the, it is the.
they were carrying with them.
Carrying with them, man. If it is with bag, man, it cannot be, it is not a body search, man. Not
But did you body search them or not?
that from FIR, it cannot be.
There was a body search.
FIR
In the
cannot be
presence
taken.
of whom?
My lord,
In the presence of whom?
presence of the
Member of the raiding team.
member, one of the members, right?
So 36 alone not enough.
I don't know.
So the arrest, whether it was proper or not, one part. On top of that, body search not being done in the presence of the raiding team,
Yes.
without there being any independent, 50 gun.
Yes.
36 plus 50, what happens now?
50, my lord, whether.
Once you search the
My
body,
lord. Sorry.
once you search the
My
body,
lord.
the search is wrong.
Yes, my lord. It was kept.
You
my lord.
did not have any witness for the arrest.
Yes,
You did not search it according to law.
lost.
Can the recovery be believed for the purposes of consideration of bail?
Yes, my lord, recovery is a major part, man.
Now
It is
he
not-
says that there is a Supreme Court law which says that it cannot be a part of the raiding team. You are not disputing that.
that I have not gone through that.
He will give you the copy, you will go through it.
I'm not.
Also, you will have to tell us 36 plus 50. Any more violations? So 36 plus 50 would also not be enough.
50
Show us something that 36 plus 50 not enough.
Yes.
Show us that.
And
You body
also-
searched
Lost it.
in the absence of a gazetted officer,
Lost it.
presuming it is the same kind of notice,
Lost.
without giving him the option to refuse.
Yes. That part I will satisfy.
At 2. Man is behind bars, sir.
They are.
At 4.
as last item.
They were carrying the, my lord, that is not, cannot be a dispute, my lord. They were carrying, my lord.
Why not?
600.
That is the
6,000
whole
numbers of-
dispute. My arrest is not seen by anybody, number one.
6,000 numbers of tablets.
My arrest is not seen by anybody. And what you say recovered is not a recovery in law, in accordance with the law. If that happens, neither was I arrested there, nor anything recovered from me. If these two things are not proved, what remains, whatever be the quantity?
Yeah.
Whatever be the quantity, when you cannot show it connected
No.
due to absence of those two provisions of law, violation of those two provisions of law, then what happens? Tell us. We do not want this, we do not want even 1 gram roaming around in the city for sale, or in the nation for sale. We don't want 1 gram roaming around.
Not so.
Have you seen the manner in which this, how he has collected the independent witness, the language he has used? 2 persons were seen loitering around and we caught him and brought them as independent witness. Loiterers are not brought.
No, in my lord,
But look at it.
yes,
It's not our language.
Yes, it's there.
I have, thereafter I called 2 numbers of independent witnesses who were loitering in the nearby area.
Okay, what my lord, I cannot do that, but because nowadays my lord, witnesses are also hard to find, my lord. They will not, because it's lucky, my lord, they have at least got 2 independent witnesses, my lord. At least, my lord. Well,
See, he has brought in 36 and 50.
yes, okay.
Tell us that if the both are also present, still we can take a different view.
Monday, my lord, if it, my lord.
Yeah.
Monday, my lord.
Kindly take up it as a last item. If I'm insisting only in this case, Lord, if otherwise.
You were on 36 and 48. Now suddenly you crop up 50.
10:50, my lord.
Even after filing the bail petition, he gets 1 day notice before it
Let
is
it come
listed.
Monday.
Monday. At the
And-
request of Mr. Goswami, learned counsel, appearing for the petitioner who has submitted that, who would make submissions on the issue as to whether when provisions of both section 36 and section 50 are violated,
I want to do some more research on section 50, that is. My lord.
who would like to do some more research on section 50 of the NDPS Act and its violation, and its violation, if any, with regard to the entitlement of bail.
Bill, my lord. I'm deeply obliged.
List again on Monday. Let us stress this out.
Yes, yes. I will even give the.
Give him the judgment. And any other judgment, don't come up with a fresh ground on Monday.
No,
Also, my lord,
again. Only on these 2 grounds.
all also today only.
Only on these 2 grounds. Highly object.
Date regarding my lord,
WT message.
48 mile and WT message. My contention before this honorable court, my lord, it was never been served. 28 to 28. My lord, page 19 is the 48 notice. My lord.
Do you have the instructions, sir?
Well, 48 notices were, when I served, my lord, that is 2 notice were given, my lord.
To whom?
One, my lord, Abdul Qadir. It was received by my lord on Miley Begum,
Who is the
who is the my lord mother,
of the accused?
accused, my lord.
Okay, and
And another, my lord.
Jahidul.
Yes, my lord. One is the my lord brother of the second accused, Zahidul.
My lord, kindly have a look, page 19, my lord.
19.
19, my lord.
19.
Yes, sir.
Yes, sir.
My lord, with due respect, my lord, these are procured subsequently, my lord. This is page 19 is obtained on 4/5/2026. Now, my lord, this 48 notice, there is no signature, my lord. It is a fact, my lord, these were not.
They were not there.
No, it was not served, my lord. Subsequently, my lord, during pendency of this petition, most probably.
When? Served when, sir?
Not sir.
Any date?
Not sir. And her mother was, when she was called for, my lord, the mother arrived and she was given the 40th.
Any date there? No.
It is not specified, my lord.
Okay, and?
Because it is, and my lord, father, my lord.
With due respect, my lord.
Can we have?
Mother, my lord, it was around 23/4, 4:40 o'clock. In regarding the brother of the Zahidul.
Can we have a look at the documents, sir?
No, sir.
On 23/4.
On 23, one is my lord, on 23/4. And so WhatsApp on 23/4.
Okay. If we can have a look at it.
Because in middle portion, madam.
When were they produced?
Produced on 23rd, it was forwarding report page 10. 23/4.
Forwarded.
for-
Page 17 is the forwarding report, ma'am.
Hmm?
Page 17 is the forwarding report, ma'am. And my lord, at 18, last paragraph, ma'am, prior to last paragraph. The ground of arrest communicated to the arrested person by issuing arrest memo, sanctioned as per guidelines, and after medically examining, the arrested persons did not make any complaint regarding any illness and have no injury. The guardians of the accused persons were also informed by sending a WT message to concerned persons. Also notice has been sent through WhatsApp to their family members and informed over phone. regarding
Here the mother, the Smiley Begum, the mother of the one of the accused.
No, my lord, she's Jarina Khatun.
Huh? No. Sorry, Laili Begum. Who is Laili Begum?
I don't know, my lord, with due
You don't know who is Laili Begum?
No,
Then why did you nominate her?
no, my lord, with due respect, my lord, when
With all respect to you, sir,
my lord,
can you tell us who is Laili Begum?
He came to meet the
Abdul Qadir is the son of Sunahar Ali. Laili Begum is the wife of Sunahar Ali.
mother, my lord.
So Laili Begum gives a signature saying that I have received it when I came to meet him.
My lord, due respect, my lord, on last occasion when matter was posted before this honorable court, the contention of the learned PP was that, my lord, they have sent through WhatsApp message.
That is on the basis of whatever was there here before him.
My lord,
Now they have now when we have asked him to verify from records, this record has come.
my lord, I have procured certified copies from the
Of
my lord 48 notice, my lord. Page 19 onwards, my lord. Subsequently also I have obtained 48 notice, my lord. There is no such signature, my lord.
So is it manipulated, sir?
It will be
Is it manufactured later
because
on?
Later on, my lord.
Very specifically written, when she came, the notice was served out.
You gave an address, you gave Sri Bhumi Karimganj and all that.
My lord.
They sent it by WT there to your nominated person.
My lord.
Already your nominated person, after being informed, intimated, is on the bus route to here.
Yes.
She arrives here in the morning, it is handed over in the morning.
Now, my lord.
Can they run after the bus to serve 48 notice?
Now, my lord, the thing is that, my lord, the lordship, these.
There has to be an end to technicality, sir.
Oh, my lord.
When the computer breaks down.
My lord, with due
AI
respect,
fails.
my lord, when last occasion the submission was that your WhatsApp message was sent, my lord. Then
No, that
I
is
prayed.
At that time, WhatsApp message was sent. Your mother rushed
No, my lord.
on the way.
It was before this honorable court, my lord. Before this honorable court, submission was that, my lord, WhatsApp message was sent, my lord, which was duly received, my lord.
Page 18, that is there.
My
That
lord.
is why it was.
When it was posted before this honorable court, before Honorable Justice, my lord, Sanjeev Sharma, my lord. And on that day, my lord, their contention is that WhatsApp message was sent, my lord. Now, my lord, only to fill up the lacuna, my lord, these things are done, my lord.
You
Now
go
I-
and lodge an FIR.
My lord.
Go and lodge an FIR that they are manipulating
Now, my
official
help this
records.
person, my lord, this is an admitted position, my lord. It was not served, my lord. Subsequently, my lord, during this bail petition, my lord, all these things may have been done, my lord. Now, my lord, if that is at all there, my lord, page 19, it was obtained on, my lord. This certified copy was on 4/5/2026, my lord. 4/5/26, my lord. If on 23 itself it was furnished to them, my lord, that should be there, my lord, in my bail petition, my lord. Page 19 onwards, my lord. If it was at all furnished to her on 23rd, my lord, I procured it on 4/5/2026, my lord. Lordship, kindly page 19, my lord.
19, we have seen.
My lord, there is no such signature, my lord.
There is no such.
Even in arrest memo also, my lord. The person name, my lord, whose address also not mentioned, my lord. Arrest memo, my lord.
That we have dealt with.
My lord, page 23, my lord. Signature of witness, my lord.
I think that is settled.
This settlement.
Only absence of signatures is not helping you.
Fortunately, there is a name in the witness column, man.
Where?
In the witness column, page
Hey, Herik Matokson.
23.
No.
Only the address is not given, but the name is given.
Just a name, my lord.
We cannot say that this is, and it's a signature of that person.
Who is that person?
The law does not say that the signature has to be with address. Does it say so? Doesn't say so. Signature with address, does it say so?
No.
No, it says to be witnessed by someone.
Witnessed by someone.
Just come back in 2 minutes, sir.
Right.
It is a settled position in law that a violation in the arrest memo would not in itself be sufficient to entitle the petitioners to the privilege of bail. Addressing the allegation of non-service of the notice under section 48 of the BNSS, the learned APP has submitted that initially the mother of the petitioner number number two and the brother of the petitioner number one had been informed through WhatsApp and simultaneously WT message had been sent to the concerned police station having jurisdiction over the residences of the petitioners to inform the family or friend and relative of the petitioners, full stop. The documents produced by the learned APP shows that the notice under section 48 of the BNSS served sent through WT was served on the mother of the petitioner number 2 on 24/4/2026 when she appeared at the police station to meet her son during the remand period. Full stop. The learned APP has submitted that while the WT message had been sent to where was your home? To Shribhumi, Karimganj on 23/7/2026, and she had also been informed through the WhatsApp, through the WhatsApp sent to the cousin brother of the petitioner number 2 herein, the mother of the petitioner had already left for Gauhati, for Harangajao. Is it? Harangajao to meet her son, and on her arrival at the police station, the notice under section 48 of the BNSS had been served upon the mother. So, the learned APP further submits that the cousin brother of the petitioner, petitioner number 1, thereafter arrived on 27/4/2026 and received the notice under section 48 of the BNSS full stop. The cousin brother had already been informed through WhatsApp on 23/4/2026 before production of the on 23/4/2026 full stop. Having regard to the facts and circumstances of the case when the intimation of the arrest had been given to the family of the petitioner at the time of their arrest, and further due to the circumstances already explained by the learned APP, the notices under section 48 would be served upon the family, friends or relatives only upon their arrival, since they were in the meantime in transit, I do not find that there has been any violation. I do not find the violation alleged under in serving the notice under section 48 of the BNSS to be of the extent where the petitioners would be entitled to the privilege of bail only on the technical issue. Stop. Therefore, the prayer for grant of bail to the petitioners on the ground of violation of the provisions of section 48 of the BNSS and coupled with the absence of an address of the witness in the arrest memo is rejected. Stop. The learned counsel for the petitioner has submitted that in the certified copies made available to the petitioner did not contain the endorsements now being shown before this court on the notices under section 8 of the BNSS, and he has further alleged that such endorsements had been made later on during the pendency of this bail petition in order to have the bail petition rejected. Full stop. The matter would be placed before the concerned superintendent of police, of which Mahasau, to cause an inquiry to find out if such manipulation of records has been resorted to by either the arresting or the investigating authority. In the event any manipulation is found, the appropriate actions would be initiated thereunder. Full stop. In the event there is no manipulation found in the records, then what happens?
No, my lord.
What happens?
With due respect, my lord.
You are with accepting all respect.
No, my lord.
You have made allegations on.
One thing, my lord. Frequently, they are changing their stand, my lord. In the bail petition itself, initially said 48 foot.
The learned counsel for the petition has submitted that the investigating authority had been frequently changing their stance before this court.
No, my lord. I am submitting, my lord. When bail petition was filed on 5/6/2026, my lord. After, my lord, when the case diary was produced before this honorable court, stand was that, my lord, 40 word notice could not be served. That's why WT message was sent. Then said that, my lord, the WhatsApp message was sent. Subsequently, my lord, when I denied all these things, my lord, I was asked to file an additional affidavit. I have filed, my lord. And on last occasion, when the matter was posted before your lordship, they said that it was sent through WT message, my lord. And that contents, my lord, asked them to show the court.
The more you dig, the bigger the grave.
Now, my lord, only thing is, my lord, I have obtained certified copy on 4/5/2026, my lord. If this signature was
that is what we have directed the SP to make an inquiry if there has been any manipulation.
No, my lord, that's the same. The main thing is that, my lord, even though inquiry is made, my lord,
also add one sentence. In the event any manipulation of records is detected by during the inquiry to be made by the SP of the district, the same shall be intimated to this court through the registry. Yes, we'll take up appropriate actions. If there is a manipulation.
My lord, primary record shows, man.
I'll tell you what happened.
My lord.
During the production, whatever documents they gave, till that point of time, these signatures were not there. We have recorded that it was given on 24th. Yes?
Right.
So whatever records are in the court will remain in the court.
Right.
Done? So when you took the certified copies, the endorsements will not be there. Thereafter, when the CD was sent to them, they looked at the first copy that was granted to given to the court. It was not with them. They said yes, by because the 48 notice says that it is sent by WT and WhatsApp. That is the submission they made. This document has now come up, showing the signatures. Yes. So it is not always a manipulation, sir. It is also lack of immediate communication. Because everything is not up to date immediately. This investigating officer is running another business also. He would give the CD and say, send this. This is the CD, send it, I'm going. Yes, one document remains. What happens? Next, disposed of. Yes, sir.
Yes, in this case, there was called for, my lord. FI, you will also find at page 8, Annexure 1. On Dipali Das lodged in FI, my lord. Her daughter aged about 13 years. While walking back from school for Boromana English School, forcibly took her to a secluded place near accused for the residence and beat her with hands, bad act with her.
This was lodged on? Lodged when? Why does the certified trusted copy doesn't contain any date? Hmm?
There also
Section 6 will not.
Where is the date in the FIR? Joa 29. When was it reported?
it was actually reported on 3/7, my lord.
Hmm?
Because there was a community.
Where is the date given by her?
Date is not there, my lord.
Then?
But it was registered on 3/7. Most probably there was a community meeting was there. So there was delay in lodging of the FIR. That they have stated, my lord. Rajwa Mel.
So what is your ground otherwise?
Otherwise, my lord, there is no such incident as well as CR on our own went with me, my lord. And thereafter,
13 years.
as she was detected and she was brought back to the police station and that
3 months.
What is the age?
age,
Of the
age
petitioner?
it has been stated in the FIR, it was 13 years. my lord.
Yes, sir.
Yes, 27/12/2013 is the date of birth. 13 years. My parents are 183 only.
And
Satya.
any medical reports, otherwise the medical examination?
My parents 183. Medical is not required.
Medical report 9 years.
Rap is not there. Shashik is very conservative. English of 18. Option 1, option 1, 8 of English. As per 183, malad, perhaps 6 will not come at the time of Shashik, 8 may come, malad. 8 will come. Definitely.
Bed testing.
No, 5.
That's it is
Right.
Yes, madam, what do you say?
Your Lordship, the investigation will be completed because, Your Lordship, the girl was 12 years, 6 months, Your Lordship, at the date of alleged incident. And the boy is 23 years.
23 years.
As a case of bed touch, my lord, Section 8 will come, my lord. Up to
Still it will be covered under
The
less than 3 years, my lord.
no, he had made attempts to go beyond that. Statement is he had made attempts to go beyond that. He failed,
Yes.
and reasons are obvious.
Oh, my lord. At base, it can be a case of section 6, my lord, 7, my lord. If it is 7, my lord, punishment is maybe more than, not less than 3 years, may extend to 5 years.
Not less than?
Say, not less than 3 years, may extend to 5 years, my lord. I'm all.
Not at this stage, sir. Let the investigation be completed.
I am already in custody for more than 66 days, my lord. 54 days, my lord.
Could be.
So my release at this stage will not cause any inconvenience to police
The
investigation.
investigation is going on. She has already made a statement.
Because 60 days is then it is.
The sooner we send it back, we can have it. The sooner we send back the CD.
Present it is on FOXO 6. Until and unless such it's submitted.
Privacy from the materials you are available. It is a case of bad touch, my lord.
22-year-old running after 13-year-old and we releasing him on bail would really put her to threat. At this stage, she's a school-going child. We don't know.
Last November.
And I understand, my lord. It is a case of, since it is a case of bad touch, my lord, there is a section 7.
No, it is not a case of bad touch on the run. It is a case of bad touch first by getting the acquaintance, then entering a room, locking the door. That is the extent.
I understand, but that is there. But after that, since no such meditation has taken place, my lord.
Not today, sir. Not today. Heard Mr. P. Kotoki, learned senior counsel, appearing with the assistance of also heard the learned APP and Miss M.K. Brown, learned amicus, appearing in the matter. The case diary has been produced before this court. I have gone through the contents of the investigation conducted till now. Stop. The learned amicus has submitted that the petitioner may not be granted the privilege of a bail, at least till the completion of the investigation. Stop. In view of the circumstances revealed in the case diary and also keeping in view that the victim was aged about 12.5 years and the investigation is progressing, I am not of the opinion that the petitioner can be granted the privilege of a bail at this stage. Stop. Accordingly, the bail petition is dismissed at this stage. At this stage, let some more investigation be done.
My pleasure, Lordship. There are two ladies before your Lordship, my lord. Mother, son, and daughter-in-law, my lord. The GST summon notice were issued under section 35(3), my lord. Two notices, my lord. And thereafter, my lord, last occasion it came up before your Lordship, my lord. Lordship asked them to take instruction whether, my lord, arrest is
whether
arrest is, my lord, necessary, my lord. In this case.
We'll allow them to appear with whatever records are there. Give us an updated CD that further custodial interrogation may be necessary.
Lordship, basically now only for collection of evidence and to take.
So let them go and appear. Bring back the updated CD if you want to. If you so desire, we can keep it for bringing back the updated CD. And in case their arrest is required to.
Lordship, as per the act, the detail to, because only after.
They all have to be given.
Collection of the material, the commissioner will make the assessment.
And supply them a copy of that order.
Grounds of arrest.
So till their appearance, we give them.
My lord.
Once the grounds of arrest comes in, we will say that the AB will not be operative. Once they're supplied with the grounds of arrest once the grounds of arrest are.
Then, Lordship may fix a date for their appearance.
Oh, yes. What date?
Within 15 days, my lord.
We'll grant you till 15th of September.
My lord.
They'll appear on or before 15th of September with prior intimation too, or should they directly go?
I will inform them, they would give another invitation and accordingly they may.
Okay.
Still protected, my
Till your appearance, you are protected. But if they give you the grounds of arrest, the commissioner forms the grounds of arrest and all, they give you a communication, you'd come back in an appropriate application.
My lord.
Yes?
My lord.
Heard Mr. So-and-so learned counsel appearing for the petitioner, also heard Mr. B. Chaudhary, learned additional public prosecutor, Assam. No, you are the special counsel, GST. Stop. The instructions produced by the learned counsel for the GST does not reflect an immediate apprehension of arrest to the petitioners. Full stop. He has submitted that in the event such a requirement arises, the same has to be in accordance with the provisions of the GST Act, where the petitioners would be intimated about the grounds of arrest, about the reasons for requiring their arrest. Full stop. In such view of the matter, this court directs that the petitioners should appear before the investigating authority who had issued the notice under section 35(3) of the BNSS 2023 to the petitioners on or before the 15th of September, on intimation being supplied for such appearance again to the petitioners. Full stop. On their appearance, the petitioners shall participate and cooperate in the investigation process in the event of their arrest without being intimated the grounds of requirement of such arrest, the petitioners shall be released on bail on furnishing a bond of rupees 10,000 with 2 sureties of the like amount each to the satisfaction of the investigating authority. Full stop.
Will be it's the apex court decision. Until they are handed over the bills to believe order.
No, we will say that it is only on their apprehension we are granting them the pre-arrest bail till they are intimated the reasons. Once they are intimated, we will cut it down.
Orders.
We have to reject the AB.
Their right to claim for PRS will not arise at this stage.
Well, then why?
Then we'll say no coercive action till the grounds are intimated to them.
Well,
So, I can look for that judgment also. Similarly, in Bombay losses, by the background of this case, the person appeared, he didn't appear for twice before the authorities. Then he came for PRS.
Okay. And cut out the last portion that in case of the appearance, you cut out that portion. They shall they shall appear on intimation. Full stop. The apex court in 2026 SCC on in Union of India versus Sunil Biani reported in 2026 SCC online SC 1544 has observed that till the time the petitioners are communicated the order under section 69 of the GST Act to the petitioners in the manner indicated in paragraph 21 of the aforesaid judgment, the question of arrest without such communication will not arise. AB accordingly closed. Unless they give you the grounds, the question of your arrest is not there.
So far I understand, my lord, grounds of arrest, my lord, that communicated after arrest, my lord, as per section 48 and 47.
You go and understand better in connection with section 69 of the
69 of
GST Act. Go and understand better. If there is something wrong, come back for a review. We'll allow it.
My lord.
Go through section 69 and the judgment that has been quoted.
Not supplied.
I have recorded it in the order for your convenience.
My lord.
Okay.
Item 30.
My lord, in this case, lordship, case diary was called for. And
Ha, 19.
I'm directly, lordship, I'm coming on the ground, lordship, under which I'm seeking bail, lordship. There is, lordship, non-compliance of section 50.
Ha,
Non-compliance, lordship, up to the extent that, lordship, no option was given, even notice under section 50 was not issued.
you go. Yes, sir. No notice under section 50.
Notice issued. Notice is there, my lord.
It is
Lord-
issued,
Lordship.
it is signed.
He signed. And here, my lord, one line, my lord, I am reading, my lord, that first line is therefore your personal search is to be conducted by the undersigned. If so, you desire, such search will be conducted in presence of a gazetted, that is there. Now, I have been informed and have understood the notice in personal search section under section 50 of NDPS Act. I have been understood. That line is there. I do not require that my personal search. So, my lord,
He has agreed
if understood, then my lord,
and agreed.
and agree. Then my lord.
Page number 18, my lord.
1/8.
One.
Okay.
I'm making my
This letter part is only for your satisfaction. Yes.
last
Page 18.
page number 18, lordship, the FIR itself, the last part.
Ah.
Then one independent witness, namely so and so, so and so, so and
Your
so.
each page contains 2 or 3 page numbers.
My lord, page number
Page
8.
18 also contains page number 6.
Oh, that is the internal page number. I'm sorry, lordship. Page number 18.
Ah, I have the honor. Yes.
Last part, last 7 line. Then it's lordship.
One of the independent witnesses.
Yes, lordship.
Hmm.
Independent witness, namely so and so, so and so, so and so, came out and conducted self-search of our police team as per so and so. After self-search, I have conducted research of so and so, so and so.
Hmm.
Yes.
So, lordship, so far my instructions are
Most of the birth certificates do not contain a sentence saying that after marriage of so and so, this person is born.
No,
That
lordship,
is something preceding.
If lordship section.
Similarly, sections 50 notice given, not recorded here.
My lord, if section 50 notice is given at all, and if it is lordship as per law, lordship, then I do not have any other count.
Have a look. He is going to show you that. He is going to show you that. If it is a section 50 notice or not.
Because in other cases, my lord, that line is not there.
No. My lord may take up after some time. After some time, lordship.
After some time. Why peruse now? Yes, madam.
NBW not issued, my lord. Then next
What
date
are the
of
orders?
appearance on 7/9, my lord.
Do you have the orders or just the status report?
Yes, my lord.
But I don't know, my lord, if he is not present and represented by the advocate, but it is mentioned, all the accused are present. If personally present and represented by advocate, it is not mentioned.
By whomsoever.
My lord,
At least he is trying to participate.
again, appearance, only for appearance.
So
No available, nothing is possible.
why do you want an anticipatory bail? I forgot. Why?
My lord, the non-believable section is there, my lord. Section, my lord.
No, this is civil judge junior division.
My lord.
That is chief judicial magistrate. You are asking for anticipatory bail.
My lord.
Huh?
All the petitioners are senior citizens, my lord. And if they
We are not on that, madam. Summons to the accused. Judicial Magistrate First Class. CR case number 40 of 2024. So you apprehend that you will be taken in on when you appear, huh? But you have burned the house, you have done so many things, you remain.
Actually, this is a false case. That's why, my lord, I have annexed this copy of this plaint, my lord. Petitioners file in this 170 of 23, my lord. Thereafter, my lord, 114, if complainant, they have burned this house, my lord. If this is a, my lord, serious case, so why police is not register my complaint case, my lord? That's why, my lord, they are one representation filed to the superintendent of police, Kasar, my lord. And thereafter, my lord, they had complaint petition filed, my lord.
They have filed a representation
Oh, yes, my lord.
To the
FIR
SP.
not registered, my
to
lord.
the SP where? Huh?
Page 19, my lord.
This is on 5/1. This is when? February. Will allow it. Yes. Age, huh? Heard. Miss
Tell Wajid, my lord.
L. Wajid, the learned counsel appearing for the petitioner, also heard the learned APP Mr. K.K. Parashar, application under 482 in connection with CR case number so and so. Stop. The petitioners had received summons to appear as accused in the connected case to appear on 27/2026 at 10 AM. Full stop. The learned counsel has submitted that the petitioners failed to appear. Had failed to appear for good reasons, and the petitioners are aged about 65 years, 60 years and 57 years respectively. Full stop. The learned counsel has submitted that the next date fixed for appearance of the petitioners is on 7/9/2026, and they apprehend that they may be arrested to face the trial in the aforesaid CR case. Full stop. Having regard to the age of the petitioners and also the undertaking given by the petitioners through their counsel that they would appear and contest the accusations made against them during the trial without fail, the court is of the considered opinion that the petitioners can be granted the privilege of a pre-arrest bail in the aforesaid matter. Full stop. Accordingly, on their appearance and in the event of their arrest in regard to the aforesaid case, the petitioner shall be released on bail on each furnishing 10,000 two sureties of the like amount, satisfaction of the judicial magistrate first class, what place?
Kasar, my lord.
Pacha.
Oblige, your lordship.
A be disposed of.
Oblige.
Lordship, POXO matter,
Service
service was awaited, but we have instructions that service has been completed.
They would
The
come up with that.
OC as
Yes.
well as the-
Service on the respondent number 2 is complete. The scanned copy of the trial court record has been received. Full stop. None appears for the respondent number 2. In these circumstances, this court appoints Miss Parashar. She's here.
Lordship, we have instructions that it has been completed, but there is informant, Lordship, not
Oh.
from the PPs.
Can you find out? At 2?
Lordship, or otherwise we are requesting that a short date may be fixed on second or third. The Lordship may give us liberty
Take it
to
like this.
check the.
Learned counsel is paying for the petitioner has submitted that his under instructions that the respondent number 2 has been served with the notices. However, the learned APP has sought for accommodation to have a report on the same full stop. Accordingly, list this matter again on the 2nd of September
Lordship, we can
2026.
also be given liberty to take the track consignment number and produce that.
Let him come back with
That will be expedite, my.
on the 2nd of September, allowing the learned APP to have his instructions regarding the service of notice. Full stop. The learned counsel for the petitioner shall be at liberty to produce the track consignments of the notice sent to the respondent number 2 on the next day first.
I'm obliged.
Thirty-four, my lord, search sheet file.
Lordship, possible for the timings.
Time being, when were you arrested? Anything?
Arrested on 4/7.
4/7.
Lordship.
Allegations are under POCSO. Any report on the service of notice?
Service is not there, no, but a report of search sheet has come. On 25/7.
She's praying for after some time. Let us see. Kindly inform your senior. Inform your senior, charge sheet has been submitted. Does he want to pursue it here?
May I please, your lordship? Regular bail application, my lord, petitioner behind the bar 117 days. Intermediate quantities is charge-sheeted case, my lord. During trial, my lord, the seizure witness and as well as the informant has been examined, my lord. .269 gram of ganja has been recovered as per the FIR, my lord. FIR at page number 13.
Have you gone through the TCR, sir?
I've not gone through, but I've gone through the POTPW 1 to. It is there in the page 30, my lord, PWs, my lord.
I have annexed the witness, my lord.
1, 2, 3, 4.
How many?
Otherwise, my lord, it is seized from the. During inquiry, conscious possession of the petitioner, my lord, 8.26 gram, my lord, the kg of suspected ganja.
The conscious possession was not supported by the seizure witness, my lord. And kindly, my lord, kindly see the cross part of the informant. For section 42 also not complied, my lord.
Section
42. The informant, my lord, cross part page number 35, my lord. May I read, my lord? Page number 35 cross last bottom, my lord. It is a fact that no GD entry was made on the date of receipt of information. Then, my lord, it is a fact that in the GD entry exhibit 3, P3, the suspected NDPS substance was stated to be heroin, whereas in the FIR exhibit 6, it is mentioned as ganja. Then, my lord,
yes, page 36, number 17.
36, page number 17. Point number 7, and it is a fact that I had not provided the copy of GD entry to my superior officer. So clear violation of 42, my lord. And also, my lord, point number 16, it is a fact that I have not mentioned
in my MCD, the reason of my belief. Reason of belief, it should be recorded on the receipt of information, then it should be sent to the superior officer
Yes,
immediately.
sir.
These are all, my lord, facts, my reason of belief and everything, this will come, my lord. But Lordship, may I kindly say page 34, my lord, from the evidence of PW3. The
He is the OC.
point number 3, OC.
He is the OC.
OC.
Yeah. Now,
OC calculation.
Now
they
come
had
to page
gotten
number 30.
Information and draft
now
was
page number
prepared.
30.
34, my lord.
Page number 31. 31, Caesar witness.
Caesar witness. 31, my lord, this is my
Top.
Caesar witness, my lord. Now, what my learned friend is saying regarding the.
So that we are not concerned with. We are only
ABCD
concerned
and
with the overall
Yes,
aspect, whether we can
Yes,
grant a bail or not. Technical defaults one side.
yes, yes.
It was closed, not opened. Police told me, I have not seen anything.
No. Caesar,
Page number 33. Police entered without me. I have not seen the basta.
Page number 38 also. It is not a fact that no bhang was recovered.
Arrested when?
Arrested, my lord, forwarding is page number 18.
How many witnesses remain?
4 witnesses examined out of 9, my lord. In the listed witnesses 9. All the independent witnesses has been examined. The rest are the official, my lord.
Huh?
The rest are officials.
Any more witnesses?
After recess? After recess, go through it in the recess. After recess. Order দিব পাৰা কেইটা পটাপট কৰিব।
I'm sorry, I'm lagging another court.
Huh?
I'm sorry, my lagging another court.
No issues. বলো। Charge sheeted.
The city, man. Approach the land.
Learned counsel for the petitioner has submitted that
Yeah.
since the learned APP has stated that the investigation has culminated in charge sheet number
218/26 dated 25/7/26.
he would seek the liberty to approach the learned trial court. And this present bail application may be closed. With the liberty paid for, the bail application is closed. 36. Hmm.
36 also succeeded now.
The TCR may be called.
Scan copy of the TCR. Heard Mr. BP Boyle, learned counsel paying for the petitioner. The learned APP has submitted that the investigation is culminated in charge sheet number
Succeed number 14/26 dated 30/7/26.
call for the scan copy of the TCR list again on 15th of September. Which ending?
Which ending?
No, but it has not caused any loss of life.
Sufficient
No,
material.
just the allegation. We just
Sufficient.
we just wanted to see them. Yes, next. 37.
May I please, my lord? It's a regular bail application. The offense is under the Wildlife Protection Act, my lord. Lordship may kindly turn to page number 12, my lord. The complaint is at page number 12, my lord. May I read the complaint, my lord?
Is it special PP wildlife or would you do? Mr.
My lord, we go going.
Huh?
Give maybe with the Google, my lord.
Maybe.
Maybe not with me, my lord.
Huh?
Well, kindly at two, my lord.
When were you arrested?
My lord, I was arrested on 25th of July.
And was the meat as per the seizure?
My,
Or is it something else?
the fact is that, my lord, actually, the forest official, they went to a patrolling at night on 23rd of July. And then what happened? They found some monitor lizard, dry meat in the forest at night.
In the forest?
In the forest, Raimana National Park, my lord. So after that, what happened? They asked the villagers, the forest official asked the villagers, if anyone went to the forest, that Raimana National Park, because the village to which these accused persons belong is adjacent to the national park, my lord.
Okay.
So they used to go evening time or morning time sometime. So according to that, the villagers told them, 5 of our villagers, they went to the national park on that day. So on that basis, the forest official called them to their office. Accordingly, they came. And when they came, they were detained on 24th July, my lord. 24th July, but they were shown as arrested as 25th at 2 o'clock. But no notice was served upon the family members of the accused person, my lord. That is the case, my lord.
After recess, let Mr. Gogoi be here. We have understood your part.
Obliged, my lord.
48 notice not given immediately after the arrest, and the meat was found elsewhere. They were arrested later. Meat not seized from them.
Yes.
Whether you still need them in custody? Yes, sir.
May please, your lordship, on the page 17 is the FIR, my lord. On the last occasion, last Monday, the matter came up for motion, nothing was fixed on Friday, my lord. Lordship might have remembered, my lord. Then Friday case diary was not there, my lord. Lordship was given last chance, my lord. Forward, here, my some suspected.
I want another last chance till Monday, my lord.
My lordship may kindly see, my lord. Lordship may kindly see, my lord. Here, my lord, in the affair was lost in the month of May. That suspected cows were found. Now I am arrested on 1/8, my lord. Here also suspicion, 28 days in custody. The cattle which were suspected to be stolen already seized by the investigating agency, my lord. No, the father custody.
But why did they arrest you?
My lord, it was done in front of my house. That's why, I've stated, my lord,
The loading unloading was going on in front of your
yes,
house.
and I deal in cattle business, my lord. My lord, now we have to, my lord, mention, my lord, that now whether the cattle has been recovered, 28 days in custody. Lordship has given them a last chance on the last Friday, my lord. So my lord, further custody may not be required, my lord. And my lord, because now after, my lord, so many days, my lord, and from the nobody has claimed the ownership of the cattle. They have stated themselves, my lord, till now.
Till now we don't know.
Oh yes,
The CD is not here.
No, my lord, it is written, my lord.
That is on the time of arrest.
Yes, at the time of arrest, at the time of affair also. At the time of arrest, at the time of affair also. Page 20, my lord, it is strongly suspected now, my lord. But from May, my lord, suspicion, now the suspicion, my lord. 28 days in custody, my lord. The further custody may not be required, your lordship.
Today, my CD do not have, my lord. If the lordship will permit us to produce on Monday, my lord. Otherwise,
If you look at page 20,
20.
fourth line from the
Lordship.
top,
Lordship.
is not 28 days enough?
No. I leave it to lordship.
Heard learned counsel appearing.
Record that the CD they have not produced.
Oh yes, we will be. Heard learned counsel appearing for the petition. Also heard the learned APP full stop. The CD had been called for on 17/8/2026, fixing the matter for 21st of August, and on 21st of August, a further date till today had been granted for production of the CD. Full stop. Learned counsel for the
CD.
Huh?
I'm praying for the
The
CD.
learned PP has submitted that the CD can be produced on Monday. Full stop. The learned counsel for the petitioner has submitted that the petitioners had been arrested on a suspicion that the accused persons had stolen the said cattle from somewhere for illegal transportation and trade. Full stop. he has submitted that the petitioners have suffered 28 days in custody only on the suspicion of the arresting authority, full stop. In the facts and circumstances, I am of the considered opinion that the petitioners can be granted the privilege of bail till the time the till the time the investigating authority produces the CD before this court, full stop. Accordingly, the petitioner shall be released on the petitioner. How many?
One.
That the petitioner, who claims to be what? To be unconnected with
No,
the
unconnected man.
unconnected with the cattle shall be released on bail on furnishing a bond of rupees 15,000 with one surety of the like amount to the satisfaction of
Land SDGM Koliabor Nogam.
Learned SDGM
Koliabor
Koliabor,
Nagaon.
Nagaon. Full stop. You want still to produce a CD or should we close the matter as such? Tell us. You want the CD to be produced? Tell us, it's your choice.
28 days in custody or nothing. Boru recovered.
Just a minute, huh?
20, that is there, my lord, 20 days in custody, my lord. Regarding other parts, my lord, we do not know.
Cattle also recovered, my lord. See,
No, you tell us you want to produce the CD or we can close it.
Lordship may call for the CD then. I have to
Okay.
say, because I cannot.
The list the matter again on 28th of September, allowing sufficient time to the investigating authority to complete their investigation
Hello.
and produce the CD before this court. List.
Yes.
We'll give him sufficient time.
Yeah, please about it. The main bail petition is pending and it is fixed on 17th September. And now in the meanwhile, I filed this IA for the reason that the brother of the present accused, he expired on 21st and he wants to attend the last rites of his brother. Only for that reason, I filed the present IA, Your Lordship. So he may be granted interim bail because the Shraddha ceremony is on 31st of this month, on Monday.
This is against the CBI. Where is the counsel for CBI?
We have even tried to furnish a copy. They have refused to accept the copy. Today also, we have informed them, but they say that since our matters are not listed, we will not be attending the court.
On 21st, he expired.
He expired on 21st of August. 21st of August. The death certificate is at page number 7 of my IA. And actually A7. 21st August 2026.
Their absence, how can you do it? You can have it listed on Monday.
Your Worship, the problem is the Shraddha ceremony is on Monday, Your Worship. Your Worship, notice may go, Your Worship, in the meanwhile, if Your Worship
You're
permit.
looking at the allegations or when you have not been considered for bail on the
Yes, Your Worship.
thing.
Your Worship, may I submit one small point, Your Worship? On 31st is a Shraddha ceremony. If he may be produced from the jail, allow him to attend the ceremony and he can be taken back to the jail, Your Worship. Only that.
Where is he?
He is in the Manipur Central Jail, Your Lordship. This is a Manipur violence case, Your Lordship. He was arrested in connection with the Manipur violence case. He is at Manipur, Your Lordship. The ceremony is to be held in Manipur itself. So he may be produced from the jail, allow him to attend the ceremony and taken back to the jail, Your Lordship. The ceremony is on Monday, Your Lordship. And by the time the course is on Monday, it will be at 10:30. By that time, Your Lordship, the ceremony will be over. Because the Shraddha ceremony in Manipur, it starts somewhere around at 7 o'clock in the morning, Your Lordship. So it can be fixed.
Anyway, he will not reach it around 7. Even if you give an order,
Yes, sir.
how would he reach it 7? And then if he creates a ruckus there, it will be so difficult. Hmm? Who are the standing counsels on CBI?
Your Worship, Manorama Kumari.
And
She was the one.
only the single, this is only the single list.
May I please, Lordship, I've tried to solve the copy yesterday. I've called them, they were busy in a meeting. No one was present in the office of the CBI in the Gauhati High Court premises. I tried to contact the clerk. He told me without consent, he cannot take the copy.
We have even given an
And
undertaking.
did you try to contact the council?
Yes, Lordship, I have her contact number. I have,
You have contacted, she refused.
she refused. She said she is in a meeting and this is not the way she can. I even told her I will give her a scan copy in the WhatsApp, and in the meanwhile, when she appears in the court, I'll give her the hard copy. But she refused. And therefore, we went to the registrar, we took a undertaking, and then we filed this case.
Even today morning, also my honored brother, he tried to contact them and saying that we have made a mentioning for unlisted. But they said that since today none of our cases are listed, we are not going to appear before the court.
Take it out sometime. There you go. Take it up after some time.
Yes, sir.
Go for it. Hello, take it.
37, my lord, I'll seek some accommodation for today. CD has not been available. And the other part, my lord, I have just given the court master print out of a bail order. My lord, these wildlife offences are now punishments are amended and to be treated as far as similar with section 37 of NDPS. Twin conditions have been inserted by amendment of 2009. And the punishment has been enhanced from 7 to 10. So BNSS 187 comes into play. We have 90 days to file a charge sheet.
That is okay. Have you seen the
Let's see. So I pray for a limited accommodation. My lord, Tuesday, my lord will keep it. I can bring it.
May I play, my lord? One small thing, my lord. My brother is correct regarding the encumbrance of section 51A, which is similar to section 37 of the NDPS Act. But my brother is partially incorrect to the point that if the accused person has been previously convicted.
It is
In
independent.
that case only,
No, no,
in
it
that
is
case only,
independent.
it is clear from
It's
the
independent.
section
Well, my
51.
lordship has held this, order is there, my lordship has held.
And moreover, my lord,
Second.
wait, 51.
No, it-
Moreover, my lord, lordship may kindly turn to page number 45, my lord.
Hmm?
Page number 45, my lord. At page number 45, my lord,
It states Union Amendment.
page number 45, my lord, the signature of addressee, my lord. Here,
That arrest memo, errors in arrest memo, these are not grounds for.
yes, my lord, this section 48 notice was not given to any of the family members, my lord. Here, the addressee himself is the investigating officer, my lord. Rajiv Bodgwari, Forester 2, he is the addressee in the notice served under section 48. So no notice was served to any of the family members, my lord. So there is clear violation of section 48.
The case records, when I am handicapped. If he has a case, I'll concede on Tuesday, my lord.
And moreover, my lord, nothing was seized from them. They were called from the village because they were living in an adjacent village, and they came to the forest office. There they were arrested. That is the case, your lordship. And they are behind the bar for last 35 days. And there is some irregularities even in complaint, my lord. In the complaint, they have stated that one person was seen fleeing from the spot. But when they were served with the notice under section 47, they have stated that 5 persons were seen fleeing from the spot. That there is irregularities even on the face of their record, my lord.
You are Mr.
A. Basumatari, my lord.
Mr. A. Basumatari, Leonard Counsel, appearing for the petitioner. Also heard Mr. D. Gogoi, Leonard Standing Counsel, Wildlife, the Special PP Wildlife, Special PP Wildlife. Stop. The Leonard Counsel for the petitioner has submitted that the arrest of the petitioner is not in accordance with law, in as much as the notices under section 48 of the BNSS were not served to any
Yes,
of the
my lord.
family members of the petitioners herein, full stop. He has further submitted that as per the 48 notice available on record, the same were addressed to the arresting officer himself. Mr. Gogoi, Learned Counsel, Learned Special PP has prayed that the matter may be taken up on Tuesday, on which day he would either have the CD to be placed before this court or have specific instructions on the service of notice under section 48 BNSS upon the family members of the arrested persons. Tuesday is a holiday, so when do you want it?
Wednesday.
Yes.
Here in this case, Lordship, for quantity involved here is small quantity, Lordship, but they have registered the case under section 21B and 27A. Now, I have, Lordship, filed this bail application long back, and your Lordship also granted them sufficient opportunity to show that 27A is attracted in the present case. If,
Long back is around 8 days ago.
That is there, but he is in custody for almost 43 days, Lordship. So that is there, and
Yes, sir, what do you say? True, but you are also required to have your instruction as to why section 27A has been inserted when a small quantity has been recovered.
And just I am relying on one Supreme Court judgment, Lordship, which says that it has to be seen along with the contraband recovered in absence of any other material also. From the FIR and forwarding report, there is no material to show that other contraband is also involved.
No. From the forwarding report, no.
Lordship.
From the FIR,
Lordship.
it is apparent
Lordship.
that you were carrying 7 numbers of empty plastic vials, 2 numbers of syringe,
Lordship.
cash amounting to 25,000,
Lordship.
and 2 mobile phones.
That is there, Lordship, that, that
So these
quantity.
vials, so
Lordship.
these vials
Lordship.
are for transporting
Oh, perhaps he was, Lordship,
and not transporting
consumer.
at one go. 7 vials would require 7 different transports.
That is a quantity 0.6 gram, Lordship.
Why the vials? So therefore, without
Only small quantity, so otherwise it is available, Lordship.
otherwise the quantity is small. Why should he
That
behind?
otherwise
Why
it
should
is
he be
available.
behind bars?
In absence of 27, it is available, and for 27, Lordship, they were granted time to show that other materials are there to show that it was an intermediate or commercial quantity. That is not there. 43 days in custody, Lordship, and no previous antecedent is disclosed in the forwarding report also.
Nine 9.33 grams, including weight of plastic vials.
Right. And that inventory I have annexed that page 15. Exam file. .6 gram. Considering the quantity and the length of detention, Lordship, I am paying for doing that.
Monday, learned counsel for the petitioner submitted that the recovery of that there is a recovery of
0.6 gram.
0.6 grams of heroin allegedly from the petitioner. Full stop. The earlier order of this court on 19/8/2026 reflects that the insertion of section 27A may not have been called for as per the submission of the learned counsel for the petitioner. Full stop. The learned APP has submitted that the case diary is yet awaited. Full stop. List again on 31st of August. This court notes that the quantity recovered is small quantity and the petitioner has been behind bars for
last 43 days.
43 days.
Obliged. Here, Lordship, already that dealt with the co-accused bail application, Lordship. So that regarding 48 notice. I'm just handing over the Lordship's order.
Where is the 48 notice?
48 notice here, Lordship will find at page 48. It was addressed to OC, Lordship, and subsequently one report was also produced where, Lordship, it is said that intimation of arrest was given to the family members. That is. I have handed over the co-accused bail order, Lordship, that paragraph 8, Lordship will find. I am on similar footing, Lordship. That intimation of arrest was given to family members, not the grounds of arrest.
On whom was it served?
My lord, actually, almost similar, my lord. But my lord, that intimation was given to the father of the present petitioner.
Intimation of arrest.
Yeah.
Wait.
This is intimation.
You have the document?
My lord.
Intimation, how was it given?
Only, my lord, only intimation regarding the arrest of their son along with the 4 other 3. Your lordship order.
But you had sent it by the, you had sent it to the concerned officer in charge.
My lord.
He only intimated that he has been arrested. That could be done by this office also.
My lord.
On the same day, they were arrested, Lordship.
Hmm.
Only
We are
difference-
disposing this of then again.
My lord.
Only difference is that, Lordship, that notice was given to the father of the present petitioner. In
Father of
earlier
the
case,
Correction to it. Disposed of.
Pavla, Lordship.
বাইশ শ্লিপৰ সেইটো ক'ত আছিলে দুটা যে আছিলে একেলগে বাইশ শ্লিপ কৰি অনা কথা কোনকেইটা এইকেইটা হা
regarding the weight measurement device, my lord. So they have waited.
It was a matter of trial, sir. Today, now I stand here in bail to say that yes, the weight measuring was wrong, this measuring was wrong,
No,
that
my lord,
trial goes.
no, my lord, whole edifice of the case, my lord, regarding the commercial quantity or not, my lord. That depends upon the machine. So that machine they have procured from the local.
Have you not produced it before the this thing?
No, my lord, not at all. Kindly see, my lord, page 30. Page 30, my lord. These are the seized articles.
That has to be placed before a magistrate also. They have not placed it before a magistrate. He has not weighed it. That you do not know. Huh?
And one more thing, my lord.
This is not like a shop. You go to the shop and you say 1 kilo of atta, you take home the 1 kilo of atta, whether it is right or wrong, you think it is 1 kilo of atta.
Yes, well, that's correct.
There is some process after that.
Yes.
Before the magistrate, sitting down in a closed room full of heroin and ganja and everything, they sit down and they weigh. এখন দিয়ক TCR কল নাই হোৱা নেকি?
No, not, my lord, not received. Not received.
TCR not received?
Not received.
Huh?
Not received, my lord, not shown in the cause list, my lord.
Oof. Heard Mr. So-and-so learned counsel paying for the petitioner also heard learned APP call for the scanned copy of the case diary. List again on 11th of September 2026. We'll have to see that measurement. You are bringing everything on record, you are not bringing that on record. Wait. Dear. We start when I buy. AV when I started telling. Yes.
Here, Lordship will find FIR at page 15, start from page 15. In the FIR, Lordship, there is nothing against the present petitioner, Lordship. And it was the quantity was recovered from some other persons. Accordingly, they were apprehended. FIR was lodged against them. Now, after Lordship, 3 months, he was present.
Item কিমান? সেইটোৱে আছিলে এটা উইথড্ৰ হৈছিলে সেইটো ভুলকে কৰিছিলে কোনটো উইথড্ৰ ভুলকে কৰিছিলে 75 ৰ কোনটো আছিল 76 তো ক'ত গ'ল এইটো 76 ইয়াত তো নাই 10690 দিছে Yes.
Lordship, thereafter, Lordship, I was arrested from Bangalore. I was in Bangalore. After 3 months, I was arrested from Bangalore, and that forwarding report, your Lordship will find at page 20. So here in the forwarding report, they say, Lordship, that during interrogation, that the arrested persons informed that on my on instruction of the present petitioner, they have taken the contraband from Tripura to from West Bengal to Tripura. Now here, Lordship will find that at page 24, If may I kindly see,
Ah,
this is application of the IO filed by the file before the special judge. I am referring to page 25, serial number 6, Lordship. How my name came up. The accused person has been
you
found to
use the
be.
same handset by changing
That
the.
only that is the allegation, Lordship. But now, Lordship will see that the phone was initially used by SK Nazrul Islam. He is not an FIR in the accused in the present charge sheet, Lordship. If he is not an accused in the present charge sheet, so if I am
Those
using
are
the
matter of trial.
Lordship. And
Those are
apart
matter of trial. This is 22C.
22C. And apart from
Convince us on the other part.
so that is there, Lordship. Apart from that, there is no material. And in fact, Lordship, this honorable court and honorable apex court also said that if phone call details are there without producing the actual conversation, that cannot be, Lordship.
Trial.
Lordship. And other thing is there, Lordship, that the GST invoice, which was in the name of Lordship, Ranjit Saha, he was granted bail, Lordship. That coordinate was granted bail, that also I am producing. Because articles were in a consignment was packed. So what was inside there, whether this present petitioner had no knowledge or not.
Your present petitioner was not even related to this entire consignment according to you.
Yes.
Number one. Number two, the driver and the handyman say that you were the person who had asked him to take the consignment by whatever means.
Lord.
So what was inside, what was outside, that will come in the trial.
For bail also, Lordship, that is perhaps relevant because for attracting section 37 or to show my involvement, they have to show that I was having the knowledge.
When the recovery is of commercial quantity, then sitting here, I have to be convinced that you may be granted an acquittal, number one. And number two, that you would not indulge in similar offences. Now, you'd be granted an acquittal is not coming up.
Now, Lordship, may I kindly see,
On a prima facie view, not on a full argument. Hmm?
Paragraph 10 of the judgment, Lordship, may I kindly see.
Huh?
Paragraph 10 of the judgment, Lordship, which says, Lordship, that if telephonic conversation is there, that is matter of trial, Lordship. That Lordship,
So when it is a matter of trial, why am I considering it now?
because in that case, Lordship, a bail was granted considering that aspect.
Huh?
Considering that aspect, bail was granted. So initially, High Court granted bail. That, Lordship, they challenged the order before the Honorable Apex Court. That paragraph 10 finding, Lordship. It has been.
Heard Mr. A. Ahmed and counsel appearing for the petitioner, also heard Mr. Sharma, learned counsel, learned APP, full stop. This is an application under section 483 of the BNSS, praying for grant of bail to the petitioner who is in custody since 28/1/2025 in connection with special NDPS case number 13 of 2026. The learned counsel for the petitioner has submitted that the petitioner had been arrested since since investigation revealed that the persons from whom the contraband had been recovered had revealed his name, and thereafter it was also found that the petitioner had used the handset
Belonging to one SK Nazrul Islam.
Belonging to one of the middlemen, full stop. The learned counsel for the petitioner has submitted that the aforesaid middleman has not been named as an accused in the charge sheet.
In the charge sheet, he is not there.
The learned counsel for the petitioner has also submitted that
Original conversation of that
the
recording.
original conversation of the between the two parties, between the accused, have not been yet. Have not been put in as part of evidence in the charge sheet. The learned counsel has further submitted that for the person who had, in whose name the GST certificates had been obtained or the consignment, has been granted bail by this person, by this court. Stop. The said bail was granted due to non-compliance of the provisions of section 48 of the BNSS. The learned APP has submitted that. Yes. Do you have the
My lord, I have gone through, my lord, only my lord, it is
the same FIR?
my,
No.
112, my lord.
And what do you say? Learned APP has submitted?
Then my lord, trial is in just for production only, my lord.
Ha.
And my lord,
That the trial
PW
is at the initial stage, awaiting production of the accused.
my lord.
Stop. Awaiting appearance of the accused.
No, all are granted bail.
Charges yet not framed, my
All
lord.
are granted bail. Charges are already framed. Charges framed.
Where the charges have been, the learned council, the learned APP has submitted that the charges have already been framed. And
On 6/3,
on
2020.
2026, who has been granted bail?
All are, the arrested accused person who were there in the vehicle, the initial two accused person. Subsequently, the person in whose name that GST bill was there, he was also granted bail.
GST was there. GST we have got. The other one.
Other I have included. That page 46.
Page
46.
He is whom? These are who?
Driver and handyman.
That was on 48.
48.
The basis of 48. ভুল করলো ইয়ার আগে যে বিল টু ডিসেবল করলো তাতে আন্ডার সেকশন 48 ভায়োলেশন অফ 48 কাটি দিও
এটা আহাদুল তো বিষয় আহাদুল তো বিষয় আহাদুল ভালো সবার কাছে ব্যাকগ্রাউন্ড করতে চিন্তা মিলতে হয়েছে এগুলো ছিল
সেইটোত লিখিব was granted bail on the ground that this court was satisfied that satisfied to believe that the petitioner in BA number 911 of 2026 may not be guilty of the offences which he has been charged with. And furthermore, there was no material to show that if granted bail, the petitioner was likely to involve himself in offences of a similar nature. The other co-accused who were apprehended along with the contraband had been granted bail in bail application number 1069 of 2026 on the ground of non-compliance of the provisions, non-compliance with the provisions of section 48 of the BNSS. I have heard the learned counsel for the petition for the parties, and I have also gone through the materials available in this scanned copy of the TCR full stuff. At the present stage, I am not of the opinion that the petitioner would secure acquittal in the trial and in the trial full stop. Accordingly, keeping in view the rigors of section 37 of the NDPS Act, the bail petition of the petitioner is rejected at this stage.
All right.
Changes here. 2128 to disposable লাগিছিল 218 দিয়াছ 2128 ডেট আছিল অলপ আগতে কোনটো মাতিলে আপুনি 75 টো মাতিলে 75 টো 2128 ডেট হৈছিল এই এডভোকেট জনক মাতিছিল There has been a mistake on the earlier order. We'll have to correct that also. Item 75 what likho. Item 75. Tar agot likhibo. Tar agot add koribo tapar. By the order dated 26/8/2026, this court had recorded that the present bail petition was closed on withdrawal. the said withdrawal does not appear to be with relation to this case. Therefore, the order date 26/8/2026 is withdrawn. Stop তাৰপিছত ইটো লিখি দিব হ'ব আৰু item number 66 you are there in 66 also.
No, I mean 75.
66
Supply 75.
huh এটুত কোন এপিয়াৰ আছিলে ইয়াত এডভোকেট কোন
75.
মিস্টাৰ এন হাসান এটুত লিখক 66 লিখক 66 উকিলজন আহিবতো লিষ্টত আছে কোনবাটো আহিব আচ্ছা তেতিয়াহ'লে আপুনি এই তেতিয়াহ'লে এইটো স্পকেনটোত আনিব নহ'ল নহয় এইটো স্পকেনটোত আনিব লাগিব এডভোকেট হেজ টু বি টোল্ড মই ইয়াতে বহি হাৱাত কৰি দিব নোৱাৰিম উইথ আহিছে নেকি এইটো তেতিয়া লিখি দিব পাৰে হা 66 মানে এইটোত PA number 746 of 2026 huh? By order dated 26/8/2026 it was recorded that the matter should be listed again on 28/8/2026 at the request of the learned APP full stop. It has come to notice that on 26/8/2026 the learned counsel for the petitioner had prayed for withdrawal of this matter full stop. Accordingly, the order dated 26/8/2026 is modified to the extent that the present bill petition number 764 of 2026 is allowed to be withdrawn. Is closed on withdrawal. Is closed on withdrawal.
Otherwise, date is same. Always.
Rest of it will remain same.
Yeah, please go. Here, after appraisal of the matter, also it is found that matter, altogether 6 witnesses, till now it has been taken up. So far, my lord, witnesses are concerned, my lord, after 5, 6, they have implicated that they, on that day, my lord, they went for the search, and thereafter from the house of one of the petitioner and other also present, recovered this quantity of ganja, my lord. That is the statement.
Intermediate quantity, my lord. So 37 will not come in this case. The petitioner is behind about 117 days. So, my lord, considering the length of detention, my lord, and all the material witness has been examined.
Material witness is examined.
3 witnesses yet to be examined, madam.
They would be official
They are
witnesses
official.
end of the day.
Official.
Heard, Mr.
It's a
Learned counsel appearing for the petitioner also heard. Mr. Goswami, learned APP full stop. The scan copy of the TCR call for has been received. 6 out of the 9 witnesses have been examined. The quantity which has been allegedly recovered is of intermediate range and therefore intermediate range full stop. The learned counsel for the petitioner has submitted that the petitioners would participate in the trial proceedings without fail. Full stop. Accordingly, he has prayed for consideration of bail for the petitioners full stop. In these circumstances, I am of the considered opinion that the petitioners can be allowed the privilege of bail subject to furnishing a bond of rupees 25,000 with 2 sureties of the like amount to the satisfaction of the learned trial court. Full stop. Learned trial court shall be at liberty to impose such other conditions as may be required to ensure the participation of the petitioners in the trial proceedings. Bail application disposed of.
All right.
45.
Can you please answer my CV?
Hmm?
Right, my lord. Allegation is regarding misappropriate of money when the loan, sanctioning of loan, my lord.
And my lord, he was then the branch manager of that branch manager. 45, item number 45, my lord. And he cannot sanction, the sanctioning power is of the chief manager or the RBO. He have not done anything regarding that loan, my lord, loan files and all this. And out of the 5 accounts that named in the FIR, 2 numbers of accounts has been closed, my lord. And the three remaining, they're still paying the EMIs, my lord, as for the information from the client, my lord.
You don't need you don't need the loan to be sanctioned because the money never went to those accounts.
But it was an afterthought, my lord, after 2 years of.
Could be, that is when the things are caught.
Yes, after 2 years, and the co-accused has been, who was the main person who has been granted bail, my lord.
Who was granted bail?
The co-accused in the FIR.
What ground?
You have nothing to do with the witnesses and all this. Yes. It is. It is 27/7. Now for all these allegations, my lord, he have been demoted to, my lord, he is now working as support officer. Support officer in other branch for all these allegations, my lord.
For this,
He will cooperate with the investigation, my lord. He will cooperate, my lord, anything.
He's available in the bank. He's working in the bank. You have not arrested him till now. Please don't tell me that because of this anticipatory bail petition, you want to arrest him now. Huh? He's a bank official. He's not running away.
No.
You never arrested him. Yes.
2 years.
Apparently, custody is not required. He can explain. Heard Ms. Gogoi Leonard consider paying for the petitioner. Also heard Mr. Goswami Leonard APP full stop. Ms. Gogoi has submitted that. Ms. Gogoi Leonard counsel has submitted that the petitioner is working in the bank.
Yes, my lord. As support
But has, however, not been arrested till date. However, he apprehends that the arrest may follow. And accordingly, she has submitted that the petitioner would cooperate with the investigation. Full stop. Call for the case diary list again on.
Is there receipt?
Case there is.
What do you see?
It is stated, my lord, as per the complainant, my lord, there is some irregularities that has been found in the accounts of victims, my lord. So he was then the manager, my lord, and he, along with the one person, my lord, that 1 crore of money, my lord, they, my lord, took some signatures on the bank checks and the money never went to them. That is the allegation against them.
The case diary as called for has been received. Full stop. Has he been interrogated once also? Even once?
My lord, no, this statement is not here because.
The petitioner shall appear before the investigating officer to cooperate with the investigation on or before the 11th of September 2026, full stop. Upon his appearance, comma, in the event of his arrest, the petitioner shall be released on bail on furnishing a bond of rupees 10,000 with one surety of the like amount to the satisfaction of the investigating officer, full stop. Bail petition is accordingly disposed of. It is made clear that the protection grant has been granted to the petitioner only on the condition that he appears on or before the 11th of September, and on his failure to appear, the privilege granted today shall stand recalled automatically.
Highly obliged.
Did not receive, my lord. None appears.
None appears for the petitioner on call. CD is yet to be received. List again on. Yes, give us.
We are for 43, my lord.
My lord, I am for 42.
Now, in this case, my lord, one, my lord, humble prayer before your lordship. Personal appearance of the concerned I may kindly be, my lord, called for, because lordship kindly see this order sheet. How many times, my lord, CD was called for, my lord? There not showing any response to the, my lord, honorable court.
Hmm. Yes, sir.
Like seventh, my lord.
CD giver corporation.
They are also given interim, my lord.
They are on interim. So
Yeah.
therefore, no further investigation in the matter.
26, my lord, they were.
So no further investigation required.
My lord,
Is that the stand?
no, my lord, no, my lord. On 7, my lord. That is, my lord.
Have you seen the allegations?
No,
List again on 31st of August 2026
31st.
for product Monday for production of the case diary. Full stop. In the absence of the case diary on Monday, the concerned IO shall remain present before this court to explain the reasons why the case diary had not been forwarded to the court, despite the fact that the petitioners have been put on interim relief and there are repeated orders calling for the case diary.
Yes.
Interim order passed earlier continues.
Deep lawless.
My lord, as per your lordship's direction on 17/7, I appeared, my lord, on 23rd at 11 AM, enabling the IO to record my statement. 17/7, there is an order, my lord.
What was the allegation?
In fact, the case is registered under.
That case where the charge sheet was given
Yes, that case.
without your name,
Yes, that case.
leave was supposed. Yes, sir.
But you are asked to appear, my lord.
Ah.
That instruction, my lord, I have to bring, my lord.
Today you will have a rain of orders
No,
saying that the IOs are not apparently cooperating with the
17/7.
77, 11 AM.
11.
Direction of payment appear person.
yes.
My lord, on my lord, 3rd, my lord.
Huh?
3rd, my lord.
It is noticed that the instructions sought for by the order dated 31/7/2026 are yet not supplied to the learned APP. Full stop. List again on the 31st of August 2026 and in the failure of instructions as sought for by this court, comma,
My lord, kindly 3rd, my lord.
3rd of September, and in the failure of the instructions being made available to this court through the learned APP, comma, the IO shall be called to be personally present before this court to explain the circumstances for such lapses.
Obligation.
46.
I think you will need an umbrella, sir. Mr. Goswami, you will need an umbrella.
Lordship.
This type of order is now going to come like rain.
Also in outside also, my here also.
46. None appears for the petitioner on call. Yes, so received.
My lord, my scan copy is there, my lord, and my learned file also appears for the.
What is the allegation?
My lord, the sheet was laid down, my lord. For
It submitted.
kidnapping and my lord for POCSO, my lord.
That is why the scan copy of the
Yes,
TCR.
my lord, it has come, my lord. And allegations are there in the, my lord, in the medical report as well as my lord 180 statement.
There are allegations.
Yes,
None
in
appears to represent the petitioner on call. Full stop. Scan copy of the TCR is available. Learned APP has submitted that there are incriminating materials. Stop. List on 2nd of September. 2nd of September.
47.
47 at those, my lord.
বেলেগ কিবা পঠিয়াই দিলে নেকি? 48 পঠিয়াই দিলে নে 27 পঠিয়াই দিলে এতিয়া হা
Matlab, sorry to interrupt. Item 44 matlab interim may continue. I'm sorry, matlab.
interim may continue. Yes.
My pleasure.
Hmm.
The anticipatory bail application, my lord. So petitioners were granted interim protection, my lord. Thereafter, the petitioners have appeared and the statements perhaps has been recorded, my lord. Statements have also been recorded. The petitioners were, my lord, whistleblowers. They filed a complaint before the CM Special Vigilance Cell, my lord, against the DFO and some other persons alleging that they were running a racket, my lord, of illegal.
Then another vehicle was caught. That is the
No,
vehicle.
no, no. We filed a complaint before the CM as well as the CM Special Vigilance Cell, my lord, alleging that the DFO who was posted there, along with two other persons, had been running a racket of illegal sand mining. Now, after we lost the FIR, or lost the complaint and inquiry is initiated, we are called to the office of the CM Special Vigilance, our statements get recorded. In the meantime, now the forester lodges an FIR against us, the whistleblowers.
Saying that another vehicle was caught and you had that one?
No, that we are the ones who were running the illegal sand mining racket, my lord.
Oh. Yes, sir.
My lord, they are, my lord, accused of, my lord, running a sand, my lord, illegal sand, my lord. And thereafter, inquiry was conducted, my lord. So it has been found that, that 7-8 persons, my lord, petitioners, my lord, are doing this, my lord. But nobody came to, my lord, give witness against them, my lord. For the.
What has happened to the CM vigilance case?
You see,
Your lordship will find it.
He must have noted somewhere. He must have noted somewhere.
Because as far as our instruction goes, in fact, the DFO was also called, my lord. And the CM vigilance team also went to Hailakandi for the purpose of perhaps a regular
But
inquiry.
Mr. Nawaz Learned Counsel is paying for the petitioner also. We are making it absolute. Nawaz, Mr. Learned Counsel is paying for the petitioner also had the learned APT full stop. Case diary called for has been received. Although during the inquiry, an opinion has been expressed that the petitioners may be involved in illegal sand mining, there is no evidence recorded to the same full stop. Accordingly, at this stage, I am of the considered opinion that the custodial interrogation of the petitioners would not be necessary and therefore the interim bail granted on the earlier occasion is hereby made absolute.
I'm deeply obliged, my lord.
49.
My lord, notice has been served, my lord, sorry, the case on CD is called for.
9 my lord, CD in office with 49.
He was granted an interim.
My lord.
What did you do?
There's a love relations, my lord, thereafter a case has been registered.
Sasikia nai na? No. Agoto diya nai na? I was granted interim, I have appeared, my lord.
And how much have you influenced the victim now? That is what the CD will say. Huh? You are the father.
Yes.
You are the father. Have you talked to the victim? Have you talked to the victim, you personally? No.
Not, but we have received instruction that the communication, they're still trying to communicate.
Yes, why? You cancel it.
Has been charge sheeted, that is also ongoing.
Huh?
Another prior case,
The same fellow.
kidnapping charges for the same victim.
I have annexed everything, my lord, in this petition.
Charge sheet not annexed of the prior.
So CD may be, my lord.
Why?
My lord.
There also POCSO has been added, that is also going in the special.
I have annexed everything in my petition, my lord.
I have the chart.
না আগৰ কেছে সব গাঠিছো মই ট্ৰায়াল চলি আছে বুলি ষ্টেটমেন্টত আছে I have stated, my lord, trial is going on. Same party, my lord, love relation, there are love relation. Same party, my lord, victim is the same.
Even in that case, even when the trial is going on.
Trial is going on, my lord. I have annexed everything and I have stated, my lord, in my petition.
Key case.
More than 17 years, my lord, and the prior is also, my lord, 21 years. CD may be come up, my lord. It will reveal everything.
Why two persons are going around?
My lord.
Duta case ke CI case.
Earlier lordship, the prior case 272 of 2025, that is of the incident where a kidnapping had happened, that the accused person along with one other person had taken the victim to a place chapel.
Some other victim.
No, same victim.
Huh.
Same victim. They are taken
Oh.
and they were recovered by the police. Based on that, the FIR.
You are repeatedly after her. Why?
Same victim.
Earlier love relations.
Why are you after her? You know she's a minor. You have a POCSO running after you. Why are you running after the victim time and again?
Love relationship.
Why? All the love we understand.
No, my lord.
We will support you the moment she becomes a major. If you come to the court of law, we will allow the marriage and we will protect you. When you know she is a minor, why?
Now let the CD maybe come up, my lord.
CD has not come.
No,
He has not come back.
That's right.
49,
And lordship, just want.
Why has the CD not come from 29/7/2026?
29/7, man.
Yes?
That is also, man.
Huh?
I can only pray, man.
So her statement is required to be, my
I
lord.
can only pray, madam, to next.
Her statement is nothing, sir. Her statement is nothing. You know she is a minor. And you keep repeatedly going after that lady.
My lord, she.
When you are facing one trial.
No, my lord. You also call me in Instagram, my lord.
Say no.
My lord.
Say no, you are a minor. Shut the door till she's 18.
I have told it, my lord. She
Then
pressurized.
why this allegation of finding her again with you? You going somewhere with her?
My lord. She was not.
Prior affair.
What is the now affair?
That is the Fox case, that is 240.
Page number?
Recent
22.
affair is, my lord.
Ah,
24, no?
16 is the present affair, my lord.
either she has to be locked up in a room or you have to be locked up in a room.
And lordship,
Otherwise, you will face actual POCSO charges. For your safety, you should be locked up.
the annexure 5 in the bill application, that is not proof of love relationship or any communication lordship. This is a profile that can be made by any person.
We are not happy. Once there is already a POCSO case against you, with the same minor victim, you are having another round of.
Only my prayer is, my lord.
Is it so deep?
CD may be come up, my lord. Her statement may be looked after by your lordship, my lord. Thereafter, a decision may be taken up, my lord. Because there is many things, my lord, in this case, my lord.
Heard MEI Hussain, the counsel appearing for the petitioner, also heard Mr. Goswami,
No.
learned APP. You are appearing as amicus or respondent number 2? The counsel appears for the respondent number 2. Full stop. It is noticed that the petitioner had been granted an interim protection on 29/7/2026 by this court while calling for the case diary. Full stop. The learned counsel appearing for the respondent number 2 has submitted that the petitioner is already facing a trial with regard to similar allegations. And this is the second FIR that had to be lodged to since the minor victim had again been enticed away. Stop. The learned APP has submitted that the case diary is awaited.
No.
List the matter again on 23, we'll have it on 7th of September 2026.
No.
On which date, in the absence of the case diary, the investigating officers shall remain present before this court on 8th of September 2026.
Interim may be continue, my lord.
Huh?
Interim may be continue.
The interim order passed earlier is continued.
Hello.
You see, you are bringing in allegations of him being twice involved, and you don't produce the CD.
No, twice involved. No.
Not done. What is the allegation?
But here only issues regarding that section 50.
Huh?
Only ground is section 50. Other 36, 47, 48 all combined.
So what do you say on section 50? Have you not read Baldev? You have not read Baldev Singh?
Yes. To negate to that, but
To
Here
negate
I
to
have-
what? Have you read Baldev? Practically yes or no?
No.
Truth. No, please read it. We'll have it again after half an hour. এই মোৰ টেবুলৰ ওপৰত হেৰি এখন আছে প্লাষ্টিকৰ এটা হেৰি আছে কি বুলি কয় এইটো ফল্ডাৰ টাইপ তাতে জাজমেণ্ট কেইটামান ভৰাই থোৱা আছে লৈ আছো Nine বুলি we need your assistance sir. Need your assistance yes
So, my lord, this is my lord, section POX, so section 8 is there, my lord. No, though, my lord, section POX.
section
Section 8 of POX, my lord.
hmm.
But, my lord, there
Scan
are no
copy of
explicit-
TCR yes when were you arrested sir
No, my lord, AP, my lord.
you were not arrested at all
No, my lord.
yes এখন দি দিয়ক পৰাশৰক দি দিয়ক এখন হৈ গ'ল দিয়ক yes
The case is seated, my lord, but
we had
yes,
called
but
for the scan copy of the TCR what is the allegation sir
My lord, allegation is that, my lord, page 10, my lord, that on the date of the incident, my lord, petitioner tried to obstruct the victim, my lord.
obstruct
Yes, my lord. That is, my lord, rested
yes
in the road and caught her hand and tried to forcibly take her to the house of the polling agent. So, my lord, FIR was registered under section, my lord, 126(2), my lord, whereas punishment is 1 month, my lord, 296, my lord, obsessive act and songs, my lord, 3 month punishment, my lord, section 74, my lord, which is punishment of 1 year to 5 years, my lord. Then, my lord, subsequently added, my lord, section 8, my lord. So, my lord, as per, my lord, prima facie of the FIR, my lord, there is the section 8 may not be attacked, my lord, in this case, my lord.
but what about the evidence that has
I
been
go through, my lord, and scan copy of the TCR, my lord, though she stated that, my lord, she touched her breast,
body
my lord, but, my lord, another lady, my lord, another girl, my lord, who is a classmate of her, my lord, she is also present at the time of the, but she only said she prone her, only take her to patta, my lord. Only that much. She was
But,
present, my lord. Two
my-
different
my
statements
lord,
by the two.
my
but
one
victim say
statement.
differently, my lord. 164 statement, my lord.
understood
In her
Second,
statement,
my
she
lord.
is implicated, my lord. And other, my lord, other who happen to be the eyewitness, my lord. Else, what else, my lord, she could say, my lord? They came in a bike, 2 person came in a bike, they fool her, my lord, torn off the dupatta, then what else, my lord, has to be said, my lord, by the eyewitness?
yes madam
That is,
Gone to the TCR. Also, the petition also I received a little while back.
so, my lord,
we'll take it up after some time see two things 26-year-old boy disturbing a
My lord.
what is the age of the victim
minor, my lord,
16, my lord.
16 years.
My lord, that my lord, birth certificate also, my lord, there is a problem is that, my lord.
it could have been instead of the dupatta it could have been a chain
Yeah.
which would have cut the entire throat
My lord, said birth certificate.
after
also
some
showed
time let her go
my
to the TC
lordship. My lord. Okay.
yes sir
May I please, your lordship? So far as lordship, section 50 notice is concerned, lordship, I have seen that, lordship.
which what have you seen the 50 notice
Yes, lordship. It's there. So, lordship, my only prayer here in this case, lordship, lordship, after this Sanam Raghuvansh's judgment, lordship, any subsequent ground is very difficult. May I pray for a short accommodation next week, lordship, Wednesday, lordship? If
at the
anything
request
is
of the
there.
learned counsel for the petitioner list again on Wednesday.
Hello.
Wednesday. Do it. Homework, sir. Homework.
Please, your lordship. My lord, CD along with medical report are called for, my lord.
What did you do?
My lord, the allegation page, my lord, 11.
First tell us what you have done, then we will
My
say
lord,
what is the CD
the
about.
petitioner is the mother of the accused number 1, and the 2 is the, my lord, co-villager. My lord, allegation is the, my lord, the petitioners, my lord, help the accused number 1 to establish a physical relationship with the minor daughter of the informant. And thereafter, my lord, the informant could learn that her daughter was 1 month pregnant.
You are
And-
accused number 2 and accused number 3.
Yes, your lordship. 2 and 3, my lord.
What happened to 1?
2 is,
What happened to 1?
my lord, 1 arrested, my lord. He is in the jail, my lord.
Anybody
Last time appeared, my lord.
case diary, sir?
Here, my search sheet laid down, my lord.
My lord, scan,
No arrest.
scan maybe call.
No arrest.
No interim is there, my lord.
So no arrest.
No.
Already charge sheet laid
No
down.
arrest, but-
You will not be arrested. Pay for bail there
My lord.
as you receive summons.
My lord, some observation may be given, my lord. Otherwise, my lord, is a POCSO matter.
Mr. Hazarika,
My lord,
after the charge sheet is laid down,
my lord.
can the IU arrest?
I cannot.
I cannot, but she, but she need to.
Why not try that,
If they receive summon, do not appear, then some NBW and all that.
my lord, that CGM court may, my lord, may not
Remand.
grant bail
So
because.
the moment they receive a summon, they can be back. But
Yes.
should we keep this AB pending? No, no. This can be closed.
Yes.
Not from our side, from his side,
Yeah.
from your side.
Scan copy may be called for, my lord.
Why?
My lord, so that, my lord,
We'll ask you in any case to go and appear before the trial court as and when you receive the summon. Either which ways.
no. My lord,
Whether-
after all, my lord, she needs to appear, my lord, after summon. But after summon, when she appeared, my lord, my lord, there is a chance of remanding, my lord, because if it is, my lord,
So the moment you receive a summon, rush to us. We'll
if the
try to
case,
see.
if the case, my lord, pending before the, my lord, CGM court or is a, my lord, POCSO matter, my lord, CGM court has no power to, my lord, grant bail.
Grant bill, true.
So, my
Come
lord,
with-
that is why,
huh?
my lord,
Then come with a petition.
my
We
lord,
don't even know whether you put up for trial or not. Maybe
I'll-
somebody else is.
my lord, I leave it to you.
Because it is your mother, you are the mother.
Yes, your lordship.
If it had been 1, you could have apprehended. But 2 and 3, we don't know
Yes,
whether you
sir.
put up for trial or not. Have a look. The heard Mr. M. Islam under counsel appearing for the petitioner who submits that the petitioners herein are the mother and
Mother and co-villager, my lord.
co-villager of the
The accused
accused
number
number 1
1,
who had established
my lord.
physical relationship with a minor victim. Full stop.
lord.
The learned counsel has submitted that the petitioners being ladies, aged ladies, comma, may be granted the privilege of a pre-arrest bail. The learned APP has submitted that the investigation has culminated in a charge sheet
My lord.
being CS number
CS number, my lord, 82/26 dated 31/7/26.
full stop. The learned counsel for the petitioner has submitted that the petitioners would appear before the learned trial court in the event the summons are received by them. Full stop. Observing that after the submission of a charge sheet, comma, there remains no apprehension of arrest by the investigating authority, comma, this anticipatory bail petition is closed, allowing the petitioners to appear before the learned courts as and when summons are received by them and pray for appropriate relief. You pray it here, there?
Highly obliged, your lordship.
Yes, sir. Contractual dues.
To be very frank, today, my lord, we have not yet completed the city, my lord, there is an interim, maybe another day.
We need some time to go through the CD.
Today, not possible, my lord.
My lord, otherwise co-accused were allowed to go on bail.
My lord, there is an
Same
interim.
footing, my lord. I don't otherwise oppose, my lord, because
Let him go
Yeah.
through it. Let him. Although the case diary has been received, comma, learned APP,
See, on
6 and 6 accommodation to go through the voluminous CD.
yes, my lord.
Accordingly,
last
list the
occasion-
matter again on 3rd of September 2026, interim orders passed earlier shall continue. On the last occasion, what? It was not continued.
So, my lord, my friends took time for going to the city. That is okay, my lord.
Right. On 3rd.
My job or time was.
Hmm.
Happiness. Thank you.
Mr. Hazarika does not say without something there being on record.
My lord.
Then
Deeply obliged, my lord.
54, my lord, my learned friend will confirm. As per instruction, perhaps, my lord, the charge sheet has been laid. Now, here is the case, my lord. The, my lord, informant was in relationship with the petitioner for about 4 years, from 22 to 26 months. Now, there is a breakup, and thereafter, in retaliation, my lord, this FIR has been lodged, saying that there was a promise on his part to marry. So, this is how, my lord, the...
We have not received instruction. my lord.
have you returned everything that you took from her? No. You should return those things.
That part, my lord, I find very strange, my lord. Only to iPhone, etc. my lord.
You should return the
She
iPhone.
willingly gave, my lord. These are briefs.
So give it back. This should not be kept. Once the relationship breaks, once the relationship breaks, everything should go back. These are very bad memories.
Correct.
List again on
The
14th of September 2026, awaiting the case diary, interim order passed earlier continues.
Obliged.
Yes, sir.
May I please, your lordship? Lordship,
Huh?
here in this case, lordship, this is charge sheeted case, lordship. Here in this case, lordship, the 23 kg of Yava tablet was recovered from the vehicle.
23 kg of?
23 of Yava tablets, lordship.
23 kgs?
Lordship.
Huh.
Lordship, here in this case, lordship, 3 persons was arrested, lordship, in this case, and subsequently they got bail, lordship. Lordship may kindly peruse, FIR will find page 19, lordship.
You have been sent up for trial.
Lordship.
And why did you know, why don't you appear there?
Lordship, here, lordship, the accused number 2, lordship. He is the son of the petitioner number 1, petitioner, lordship. And the vehicle, lordship, belongs to the mother, lordship. She is a mother, lordship, a mother of accused.
Only because the vehicle belongs to you.
Lordship will find, that will find.
57 years
lordship,
late. Yes, sir.
My lord, vehicle belongs to her, and from the vehicle, my lord, some 23 kg Yaga tablets were found. That is the allegation, lordship.
They are on bail, lordship.
Thing is, a lady of 67 years old, she cannot stop the son using the vehicle, can she?
That might be also. That's true. Otherwise, my lord, when some vehicle is involved, my lord, so her, if we go in that way.
Vehicle is in her name, unfortunately.
Yeah, okay.
But anything in the TCR to indicate that
Nothing.
she had knowledge that her son was doing it.
Lordship, nothing is there, lordship.
It is not there.
Page 37, lordship.
It is like taking a vehicle on hire and
Already on bail. They are already on bail. Others already on bail, lordship. I have annexed the orders.
Father.
Other 3 persons, lordship. Son and other 2 accused, already on bail, lordship.
Heard?
They are on regular bill.
Huh?
They are on regular after PM.
Heard learned counsel appearing for the petitioner. Also heard Mr. Goswami learned APP full stop. The learned counsel for the petitioner has submitted that the petitioner, who is aged about 67, has been entangled in this entangled in the trial only on the ground that her vehicle had been found in the possession of her son, who was allegedly involved in the business of contraband. Full stop. The learned counsel has submitted that merely being the owner of the vehicle would not have and cannot implicate the petitioner in any manner. Full stop. He has further submitted that the other co-accused, that is her son and
Other 2 accused persons.
and 2 other accused persons have been granted regular bail by the court. Full stop. However, due to the old age of the petitioner, she has not been able to she apprehends that on her that on her appearance before the learned trial court, she may be taken into custody, full stop. Accordingly, he has prayed for grant of a pre-arrest bail to the petitioner to
He
participate in the,
Yeah, man.
huh?
He appeared, my lord, he has paid for time, my lord, so only summon issued, my lord.
Someone issued, Lordship. Next date on
As
10
a, as a accused, no?
Lordship, as an accused.
As a accused.
In the charge sheet, Lordship, she is told as absconder, Lordship.
67-year-old absconding from the police who are trying to catch NDPS. Is it possible?
I'm not saying, my lord, but your lordship will find, my lord, in some record, my lord.
70-year-old, 80-year-old.
Whole my lord, family is in the business, my lord. My lord. It is not very, very impossible. My lord.
Having regard to the fact that the petitioner is a 67-year-old lady, who has also entered appearance through her counsel in the trial proceedings, and also having regard to the fact that the petitioner hearing has been implicated in the case only on the ground that the vehicle conveying the alleged contraband was registered in his name, I am of the considered opinion that the rigors of 37 have been fulfilled to the extent that prima facie the petitioner may score an acquittal in the trial proceedings, and there is nothing on material to show that she had earlier been or would in the future be involved in similar transactions, full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 50,000 with one surety of the like amount to the satisfaction of the learned trial court on her appearance before the learned trial court on
Next date is on 10/9/26.
10/9/26.
Next date, Lordship.
In the event of any default on the part of the petitioner to participate in the trial, the learned trial court would be at liberty to consider the reasons and also consider recalling of the bail granted by this court.
Kindly-
A be disposed of.
One line objection.
The learned PP has submitted that
Commercial quantity.
since it is commercial quantity, the rigors of section 37 are not fulfilled in the present case and the bail may not be granted. Petition. Yes.
Give to
57.
Lordship 57, Lordship CD was called for, Lordship. And in this case, Lordship, my senior's presence is required, Lordship.
Why?
57, Lordship. I can.
5 and 6, you are already on bail.
Lordship, already on bail.
They have appeared.
They have appeared, Lordship.
Regarding the other, the injury report is recorded, injury report is not yet received. But kindly peruse the photograph. Along with the speaking, injury report.
You are giving us sleepless nights. Yesterday also some photographs were shown to us. Huh? We get very bad.
All are head injury.
Yes, I have seen. I have seen that will do. I can see it from there.
But
And Lordship may peruse page 32, Lordship.
No, I'm
My
going by photographs.
maybe both side.
Both sides.
That is another case, cross case. But here, injury, you have to, they are seeking bail in this case.
You want it when? Today? You said some senior is required?
HRA Chaudhary, Lordship.
So when?
Lordship.
When do you want the matter?
Next week, any date, Lordship. Only for date, Lordship.
List a matter again on the 3rd of September at the request.
Also call the medical report, which is not available. Medical report is not available because of that.
On 12th of September 2026, allowing the learned APP to call for the medical report. The interim protection granted to the petitioner number 5 and 6 shall continue till then.
Lordship. Deeply, Lordship.
12th September. 77.
In this case, report was called for, whether any.
Here, one earlier there is a mistake. We have sent from Borpeta PS.
Borpeta Road PS.
Borpeta Road PS. Now in Borpeta Road PS also no case is.
But whose personal searching, only some observation.
Saying that what? Unless and until a case is registered, they should not search for you.
Yes.
They are searching for you to give you a medal. You don't know.
Well,
Maybe some,
any other case.
maybe some yojana benefits,
This may be kept
scheme
on record.
benefits.
This may be kept on record.
But my lord, they are repeatedly searching, even my house, when presently I am working somewhere else, my lord, they are visiting, my lord.
Heard Mr. A. Hassan, learned counsel for the petitioner, also Mr. K.K. Parasar, learned additional public prosecutor appearing for the state. The learned APP has submitted that there is no case pending against the petitioner in the Borpetta Road Police Station, and therefore the apprehension of the petitioner is wholly unfounded. The petitioner has submitted that the police personnel of the aforesaid police station are constantly searching for him. Full stop. Since there is no case on record
Right.
against the petitioner, comma, the AB is closed. However, it is also observed that the petitioner shall not be disturbed without there being any
Lord.
formal case lodged against the petitioner.
Deeply obvious, deeply.
May I please, your lordship. And in this case, regarding some additional documents, I have my lord, filed an additional affidavit to bring it on record, my lord. FIR
We
is,
also not taking one.
is actually a motion matter, my lord. My lord,
POCSO.
my lord, but POCSO is not attracted me, my lord. It's
Why?
my lord, accused number 1.
Why?
My lord, kindly see page 15. Is a
1
small
5.
affair.
1 5.
1 5. My lord, is a small affair, my lord. Page 1 5. Petitioner is the accused number 2, Harun Ali. My lord, the petitioner's allegation against the petitioner is, my lord, only ill advice. Accused number 1, acting on the ill advice of the accused number 2 and 3, trespass into my house without my consent, induce my minor daughter, namely so and so.
And now you have received summons as
Yes, your lordship, yes.
accused.
The charge-sheeted case, my lord.
Huh?
Charge-sheeted case. Charge-sheet already.
So you have received the summons.
Yes, your lordship, but someone was served to my father, not me, my lord. Due to my lack of knowledge of my father, he was an illiterate person. So, my lord, he could not communicate the same to me. As a result, my lord.
Your name is?
My lord, my name is Harun Ali.
Okay. Yes.
Harun Ali. So, my lord, petitioner engaged some counsels to take a step, but due to the paucity of my lord, his fund, he could not pay the professional fees, and ultimately the counsel did not appear and took further steps. And even he did not inform the present status of the case to the petitioner. As a result, my lord, now the petitioner is ready to cooperate with the proceeding. He recently engaged advocate in the trial court, and as far as the present bail is filed, my lord. And the case is pending before the additional chief judicial magistrate. If I am appeared, my lord, he has no jurisdiction to, my lord, release bail, grant my bail, my lord. Because
it is pending before whom?
Before the additional chief judicial magistrate.
At page 51.
Page 51.
Who has signed it?
Page 51, before the, my lord, additional.
Affidavit, who has signed it?
Oh, sorry, my lord, it's a special.
Who has signed it?
Special, my lord, sorry.
So
my
he
lord.
has the authority, he has the power to grant you the bail.
But my lord, POCSO is attracted, accused number 1, he already arrested. So, my lord, for me, my lord, only ill advice, my lord. But there is no, my lord, the affair does not suggest that what type of ill advice I, my lord.
He will not be arrested.
So, my lord, I am ready to cooperate with the, my lord, case.
But now since there is an NBWA against you.
Yes, your lord.
Can I do it in an anticipatory bail petition? We are giving you all the time in the world. We are allowing everybody time. We have all their say. You are not coming to the point of law. When there is an NBWA against you, may I grant you anticipatory bail? NBWA will remain.
My lord, if your lordship in the similar cases, my lord, already similar, my lord, bench here, and even your lordship also granted bail, my lord, during the NBWA.
But,
my lord,
but that
not the
order will
proper
remain.
procedure.
That order will remain, my lord. But the NBW order will remain.
Several orders, my lord.
Where is the hurry, my lord? They have to come another 528, my lord. Proper application.
When there is an NBWA, there is some hurry, sir. A little hurry will be there. So many orders.
My lord, Shahjahan is your lordship's, my lord, order. And Masood Sheikh, my lord, bail granted after NBW issue, my lord, for speedy trial.
Where does it state?
My lord, for Masood, my lord, can you see para 7? And para 7, my lord, for speedy trial, my lord, the grant bail, my lord. And NBW mentioned is para 4.
In this case, PNA also issued.
I am ready to cooperate, my lord.
Fine, what will you do with those orders?
My lord,
What will you do with those orders? They will not vanish into thin air.
in AB, my lord.
They will vanish into thin air, no.
No, my lord.
So NBW will remain. That warrant will remain.
Since my lord already granted, my lord, in bail in other cases, my lord. So similar order may be passed, my lord. And in Magdum Bhava, my lord, Honorable Supreme Court also, my lord, said that if, my lord, there is a, my lord, chance of, my lord, remanding, my lord.
Then you will
And
go.
the FIR laws in a, my lord, belated stage, afterthought, my lord.
That is all done, all good grounds. But there is also a judgment of this court where when one did not appear on receipt of summons
My lord,
and NBWAs were issued,
my lord.
the prayer for anticipatory bail was rejected, then the revision petition asking for recalling of the NBWA was rejected.
My lord, I have stated the reason why I could not appear, my lord, para 12, my lord, in
Your father received it. Can we set aside that NBWA?
even without set aside, your lordship can grant bail, my lord.
That order will remain.
My lord, in other benches also granted, my lord.
Okay. Heard, Mr. It is to his peril what to do.
My lord.
It is to his peril.
And that order will remain.
That will remain if he is arrested. Heard, Mr. Hem Islam Learned Council paying for the petitioner also heard. Miss the learned APP full stop. The learned counsel for the petitioner has submitted that the petition that the summons had been served upon the father of the petitioner, and the father, being an illiterate person, did not inform the petitioner about the pending trial against him. Full stop. In such circumstances, he could not appear before the learned trial court on any of the occasions when the matter had been taken up.
My lord.
Full stop. He has submitted that due to his absence, non-bailable warrant of arrest has been issued. Issued on the basis of the service of summon on the father of the petitioner. Full stop. The learned counsel has submitted that at a later date, PNA had also been issued. Full stop. The order dated 26/5/2026 reflects that the NBW was required to be again issued at proper addresses. Full stop. Having regard to the circumstances placed before this court, I am of the considered opinion that the appearance of the petitioner before the learned trial court would help in the early disposal of the trial. So accordingly, it is directed that the petitioner, on his appearance before the learned trial court, on or before
Next description 10/9.
10/9/2026, the petitioner shall be released on bail on furnishing a bond of rupees 15,000 with 2 sureties of the like amount to the satisfaction of the learned trial court. Full stop. This court has also considered the submission of the learned counsel for the petitioner that the only allegation level against him in the FIR is that due to his ill advice, the accused number 1 had committed acts which are punishable under the POCSO.
My lord.
So the learned counsel for the learned APP has submitted that even if the non-bailable warrants, even if the anticipatory bail is granted by this court at this stage, the non-bailable warrants would remain in existence since they cannot be interfered with in a bail petition. Full stop. We leave it to the petitioner to take such remedial measures as may be available to him in law with regard to the non-bailable warrants and PNA declared against him. Yes. Dispose. Go and do what you want to do.
Highly obliged, your lordship.
Ah,
Yes, Your Lordship, I've gone through the PCR. Your Lordship, so the victim as well as her friends who are the witnesses, they have implicated. But my primary objection lies on the basis that, Your Lordship, the accused, he has been shown as absconder in the charge sheet, Your Lordship. So he did not cooperate with the investigation. So at this point of time, Your Lordship, his conduct speaks volume. Your Lordship, so if he is granted bail at this point, Your Lordship, then there's every possibility that he will not appear, Your Lordship.
My lord, during the pendency of this petition, my lord, the charge sheet wasn't filed, my lord.
huh?
Even during the pendency of this very petition, my lord, charge sheet been filed, my lord. And my lord, another thing is that, my lord, in her statement, my lord, of the victim, my lord, she categorically stated about
If the charge sheet has been filed, go and appear as and when you receive summons. We will record that since the investigation is over, there is no fear of your being arrested by the investigating authority.
But my lord, where on my appearance, my lord, NBW was issued, my lord, also. my lord.
On your appearance, when you are called to appear, then we will
Some
see.
protection may given, my lord, I will appear, my lord, definitely I will cooperate. my lord.
Appear where?
Before the trial court, my lord.
Why? Trial court has not summoned you till now.
No, but it's still
Why should
someone
you
not been
appear?
served, my lord, to me, my lord.
Why should you serve? Why should you apprehend?
Well, someone not served to me, my lord, till date.
Once it is served, come back.
But my lord,
We can write the learned court of the CJM outside, only for the purpose of granting anticipatory bail prior to receipt of summons. Should we do that?
no, no,
Should we burden ourselves?
no. no. As
Heard
well as-
Mr. So-and-so learned counsel appearing for the petitioner. Also heard the learned APP. Full stop. Ms. Brown appears as the learned amicus to learned amicus. Full stop. The learned PP has submitted, APP has submitted that the case, that the charge sheet, no, it was already recorded in the earlier order that the charge sheet has been submitted. Full stop. TCR had been called for. I don't want to make observations on the TCR. You'll be entitled.
My lord,
Learned
my
counsel.
only submission is that
The
my
petitioner
petition is
has
allowed,
not
my lord.
received
I will
summons.
appear before the trial court, my lord.
Hmm?
On the next date, my lord. But otherwise, my lord, I put behind the bar, my lord.
The
Investigation will say he did not cooperate, Your Lordship.
My
Because
lord,
that's
even my lord, 35 notice not been served to me, my lord.
Learned-
That is the below under 7 years, my lord, punishment, my lord. 35 notice should have been served to me, my lord. That is also not been served, my lord, by the police, my lord. That means, my lord, the police need not to take my statement, my lord, record my statement, police, my lord. Need not make custodial detention, may not be required, my lord. So, my lord, that 35 notice not been served to me, my lord.
Since the investigation has culminated in a charge sheet, there does not appear to be any apprehension for the arrest of the petitioner by the investigating authority. Full stop. Learned counsel for the petitioner has submitted that the petitioner may be arrested on his appearance before
Before the court is still not been fixed, my lord. It is, my lord, District Morigaon, my lord. Special Morigaon.
on his appearance before whom you apprehend arrest where
Well, special just Morigaon, my lord. Pox.
on his appearance before the special judge Morigaon. Full stop. The petitioner is yet to receive summons to appear before the learned trial court. Full stop. It is since there is no apprehension of arrest of the petitioner by the investigative authority now, this court grants the liberty to the petitioner to approach the appropriate forum in case of receipt of summons to face trial. Full stop. A be accordingly disposed of. When you receive your summons, you can approach this court also. You have recorded that.
Obvious, my
You
lord.
will not become the court of the CJM or the.
My lord, obvious.
You can move the sessions court also. Huh?
Hey, please, Your Honor.
Hmm.
My lord, in this case, this is a petition under section 482, my lord, seeking quashing of a complaint case, my lord. My lord, petitioner before your lordship belongs to same family, my lord.
Who made the complaint?
Respondent number 2, my lord.
Has he been served? Has he been
Yes,
served?
yes, my lord.
He has
not
appeared.
entered. Not, my lord. He has not entered, my lord.
He has served, but he is not a.
Appeared.
What do you say?
Look, petitioners belongs to same family, my lord.
Huh?
And respondent number 2 is their cousin, my lord. Their paternal grandfather, my lord, namely Ponendra Roy, my lord, left some property at the Bigod town, my lord.
which was inherited by the father of the petitioner as well as by father of the respondent number 2, my lord. By execution, a partition deed, my lord. Thereafter, my lord, the father of the respondent number 2, my lord, enforced some portion of land, my lord, for which the father of the petitioner filed a title suit, my lord. Kindly see the operative part of the decree, my lord. Page 20, my lord.
Page 20.
Page 20, my lord.
Yes, PP, have you gone through the records or anything?
CR case, my lord. Private respondents.
So whether the complaint should be quashed
Hmm.
or there should be no any submissions on the legal ground, nothing.
My lord,
Heard, admit.
My lord, my humble prayer, no stay was granted, my lord. So, my lord, matter may be proceeding may be stayed, my lord, in the meantime, my lord. Otherwise, it is a civil dispute, my lord. And even kindly see the operative part of the complaint.
Placed again on 15th of, no, 25th of September 2026, allowing the respondent number 2 to enter appearance till such time the proceedings in the trial court shall remain stayed.
My lord. Well, proceeding number, my lord,
Proceedings in
CR case number 38 of
CR case number 38 of
2023, pending
22.
in the court of learned judicial magistrate first class degree court.
details খিনি 1 number page উপর দি দিব. Yes, deep level.
Lordship, on behalf of Mr. S.C. Rishat, I'm praying for the timing. He's moving before court number 21, Lordship.
Another date, Lordship. Otherwise, I have one more matter.
Are you on interim?
Hi,
You have
interim order
interim?
is there.
Huh?
Interim order is there, Lordship. It's a transfer
We'll
process.
admit it and we'll.
Yes, after some time, Lordship.
Huh?
It's a transfer case, Lordship.
Oh,
And the stage there, I am suffering, Lordship. I am the respondent, Lordship, number 2, and I have issue, the petitioner issue.
after some time she has paid
Lordship.
for after.
Lordship.
Yeah.
Right, please, Your Lordship. But here in this case, two criminal cases started against same date of occurrence. So, my lord, my humble submission before your lordship, that this first case will run, but this second case on the same facts cannot run. So second case may be quashed.
No, Lordship, what under section
My
2106.
my submission is very clear submission, but there is no.
Let him finish. So under section 210 of the CRPC, Lordship, there is a provision, Lordship, and I'm relying on this judgment. There is a
Where is the first FIR?
My lord,
First FIR.
First FIR, your lordship would get in criminal petition 101/25, my lord. 101/25. At page, my lord, at page 12 to 17. Just your lordship will see the date of occurrence.
No, it is.
Here it is on 14/1/2023, my lord. Page 16.
Where is the other FIR?
Other FIR. Other FIR, I'm giving, my lord.
Complaint case.
That is at,
Complaint case.
my lord, that is a complaint case, my lord. 60. Page 39, my lord. Page 39. 39 to 46. Same date of occurrence, my lord. Your lordship will turn to page 40.
No, 41.
Page 40, my lord. Page 40, date of occurrence. 14/1/2023. Same occurrence, my lord. So, my lord, my humble submission before your lordship, I am not telling that there is no materials. If in the first case materials is there, that will proceed. How the second case will lie? On the same occurrence, same is the fact. Second case cannot run, my lord. That is my humble submission before your lordship. Same occurrence, same facts. Nothing, no deviation, nothing of the sort.
It is my.
Same thing.
In the judgment, Lordship.
Same thing, my lord.
Is from paragraph 8, paragraph 7, 8 and onwards. how to deal if one is the complaint case and other is FIR
No, my lord.
on the same set of facts.
Complaint case, FIR case, but thing is this, my lord, offense is one, occurrence is one, facts is one. How two cases will parallelly run? Cannot be. Cannot be, my lord.
210 CRPC. Subsection 1. It is relied on Kapila Girl versus Sanjay Sharma, 2021, 5 SCC. That's 101 is 2 like this. 101 FIR 2 like that. Oh, yeah, that's it. 101 FIR 2 like that. It's a joint chat.
My lord, it is squarely covered case, my lord. Same is the allegation, same is the date of occurrence.
Paragraph 9 is the conclusion.
Yes, sir, they'll be taken up together as per 210.
My lord.
As per provisions of
210 CRPC.
CRPC 210, they'll be taken up together.
Together. Joint.
Join one trial.
But my humble submission before your lordship, whether the second FIR.
Where is the second FIR in this case? There are no two FIRs, sir. If there are two FIRs,
Then
the
what?
second will become a statement.
Yes.
CR case, my lord. CR case, I can file FIR, my lord, before the police. I can approach the
Save
CBI.
us some time, sir. Kindly go through your 2021 5 SCC 524.
Let me copy supply, my lord.
Who will supply you copies?
My lord.
No, he will not. You have got a library here. You can also go
Yes,
through
but
2010 10 SCC 123.
Citation to Lolo.
2021 5 SCC 524
1 minute, hello.
and 2010 10 SCC 123.
2000.
21
2021.
5 SCC 524 and another one is 2010 10 SCC 123.
Finding is this parallelly will run.
Parallelly will not run, jointly will run.
Jointly will run.
If there is a
Let
complaint,
it run jointly, my lord.
the
Let
magistrate,
your lordship gone through.
the magistrate will
Not
look
getting this
into the
update,
circumstances.
this proceeding run jointly.
No, we will not say to run jointly.
Hello.
The magistrate has to take a call
Hello.
that there is a complaint case and there is a charge sheet.
In light of that decision, my lord, the case may be disposed of. My lord, we are taking time, no, will not go.
Heard, Mr. M.S. Sheikh, Learned Counsel appearing for the petitioner. Also heard, Mr. U. Dr. Learned Counsel for the respondent. The present case, the present,
My lord,
the present is
with
an
your lordship permission, I am leaving, my lord.
the present is an application under section 528 of the BNSS for quashing of the criminal proceedings in CR case number 67 of 2024 under section. Full stop. Yeah, bruh. The learned counsel for the petitioner has submitted that an FIR had been lodged by the opposite party number 2 herein on 15/1/2023 at Moirabari Police Station alleging inter alia that on 14/10/2023 the petitioner along with 6 other named accused had entered into the shop and assaulted the informant and his other family members. Full stop. The said FIR was registered as Moirabari PS case number 11 of 2023 under section 447, 427, 379, 325, 506 and 34 of the IPC. Full stop. A charge sheet being charge sheet number 22 of 2023 dated 28/2/2023 had been submitted giving arise to PRC number 305 of 2023 under section 447, 352, 506, 34 IPC. Full stop. The learned counsel for the petitioner has submitted that the opposite party number 2 then filed a CR case being filed a complaint case registered as CR case number 69 of 2023 in the court of the Chief Judicial Magistrate Morigaon under section 354 within bracket capital B oblique 323, 340, 294, 448 oblique 34 IPC. Full stop. The said complaint petition had been dismissed for non-prosecution on 12/1/2024. Full stop. Subsequently, another CR case number 67 of 2024 had been initiated by the opposite party number 2, which is now pending adjudication. Full stop. The learned counsel for the petitioner has submitted that 2 parallel proceedings may not be allowed to proceed regarding the same
Transaction.
same set of incidents.
Yes.
Full stop. He has accordingly prayed that the proceedings in CR case number 67 of 2024 be quashed. Full stop. Mr. Yudoto, learned counsel appearing for the respondent, has submitted that as per provisions of section
210.
210
Yes.
of the CRPC, the learned magistrate has to conduct an inquiry, and if the has to conduct an inquiry and may decide to try together the complaint case and the case arising out of the FIR, as if both the cases were instituted on the basis of the FIR. Full stop. He has accordingly prayed that the quashing of the complaint case will not be required in the present facts and circumstances, and the matter may be remanded back to the learned trial court to take a decision in accordance with the provisions of section 210 of the CRPC. Full stop. This court has noticed that in the case of Kapil Agarwal versus Sanjay Sharma, reported in 2020, 5 SCC 524, the apex court had held as under a judgment to page 3. Further, in the case of Pal versus State of UP, reported in 2010 within bracket 10 SCC 123, the apex court had held as under page 4 full stop. Accordingly, the present petition is closed, allowing the petitioner the liberty to approach the learned trial court with an application, with an appropriate application, praying for exercise of powers under section 210 of the CRPC by the learned trial court and come to a just finding. Full stop. Depending upon the petitioners shall be at liberty to come to a just finding. Full stop. Accordingly, the criminal petition is disposed of. Go and make an application there. Doesn't it? Video of my judgment to this, huh? Both the application, Dukhana Sini.
Both. No, it is already merged because
Both the
In
petition.
one, you seek the quashing of the FIR, in the other, you sought the quashing of the
Complaint.
complaint. If you allow both, you go home happy, huh? দুইটা এটা অর্ডারে দুইটা ডিসপোজ করব মই কারেকশনস খিনি কৰি দিম অ্যাডজাস্টমেন্ট
In this case, after order of this honorable court, I have been provided with the certified copy, Lordship. I have prepared my objection, Lordship. I will be filing by next week. I will file.
This is regarding acha
162.
145 proceeding has been drawn in.
huh
And against that order, I have come up with it.
no issues. He is going to file his objection by next week. We'll take it up after that. At the request of Mr. Ahmad, Land Council appealing for the respondent. Sorry,
Record has been come probably, Your Lordship.
a record of what?
The proceeding, Your Lordship. Proceeding,
Original records have come.
Lordship.
Why?
That may be kept in the record is required.
That will be required.
That is as good as a stay.
Yeah, probably it will be required because Lordship, they have filed, initially I filed one application under section 164 for that proceeding, Lordship. That was wrong. They have filed their WS, written statement. So for vacating that order, ex parte order. So what order passed, if that order is passed, they have to challenge the subsequent order, not the initial ex parte.
Why should we keep the original records here? We can ask the registry to make a scan copy.
That-
Send back the original records.
Lordship.
Whatever is here is here. That is all we need. At the request of Mr. Ahmad Learned Council appealing for the respondent number. Respondent number
Number 2, Lordship.
2, comma, list the matter again on 17th of
Respondent
September.
number 3 and 4. I'm sorry.
Respondent number 3 and 4. List the matter again on the 17th of September. Full stop. The respondent number 3 and 4 shall file their affidavits, file their response on or before the 9th of September 2026.
Or they can keep the record, Lordship, in government office, Lordship.
Well,
GS something.
it is submitted that the records, original records have been received. Full stop. The same be retained till the next date of listing.
Lordship, definitely.
PCR এখন report of scan copy রাখিলো ভাই। কি জানি,
Wait,
চাপা হয়ে গেছে।
My lord,
Yes, sir.
by this application, my lord, I am challenging the FIR, my lord,
Hmm.
which has been lost against us. On the 2 grounds, my lords. You are going to the FIR, my lord, I just pointed out the brief facts of this is that the petitioner before your lordship are the director of my lord, Zalinga, my lord, tea company, my lord. And 2 tea state by the Assam Tea Corporation has leased out to us by, my lord, thereafter, my lord. One, there's a problem with the labor as well as my lord, the factory also, my lord. So we have given up the lease. That is at page 30. So we have written to this, your lordship, before going to the, my lord, FIR, my lord, just pointed out that 30 further with heavy heart, we have decided last part, my lord, that we cannot continue with the Saikota tea state, can only take Nagarajan tea states if we got prompt lease transfer arrangement back to the limited so and so, so and so. So we have, so far, this is concerned, while we have permanently taken, there is with Assam Tea Corporations, my lord, we have stated that these are the things which has to be repaired. Accordingly, my lord, there's 6 machineries has been repaired through tree putty engineering, my lord. And as we have leased, we said that you just raise the bill to the Assam Tea Corporation, my lord. Instead of these things, they have my lord,
Laws and FIR.
laws and FIR stating 420 and 406. My lord, your lordship, kindly see our letter to them, my lord. Your lordship, first, my lord, then your lordship will get to know about that. Page 33, my lord. Tirupati engine going back to the FIR, my lord, I just said that. 33, my lord, your lordship will kindly see 2424. You are aware that we took Sayakota Tea State on operation and management of the tea in the month of 2023 from the owner of the tea state.
Page number?
page number 33, my lord.
Ah,
Our letter to Tirupati, my lord.
that we have seen. Who has lost this FIR?
That Tirupati Engineering, my lord, whose manat bill has not been cleared.
Where is that FIR?
That is, your lordship will find at page 38 onwards. Lordship will informant Raju Rai. and
He is the
accused us in-
proprietor.
Right.
He is the
Now,
proprietor.
What is it? With above that, I beg to inform
Yes,
you.
where
that-
is the,
Here, respondent number two also.
respondent number two not served?
No,
Not-
sir, they appeared.
They appeared. Who appeared?
They appeared also, my lord. Your lordship will kindly see, there's 420 and 406, my lord. There are two judgments, my lord, of Delhi Race Club. Your lordship will know about that.
Ah.
Delhi Race Club is absolutely fitted in this case, my lord. And thereafter, my lord, there's another, recently, my lord, your lordship will kindly see, that is a judgment which has been rendered recently by the Apex Court in the case of by Honorable Justice Nagatra and Mr. Ujjwal Bhuiya regarding 420 and 406. Entire thing has been that if the commercial transaction is there,
Ah,
while, my lord, this is the judgment, my lord, this is a new judgment, where NEPC, there's, because in the judgment of NEPC versus Indian Oil, it says the civil, my lord, there can be a parallel proceeding of on the civil side as well as a criminal side also, subject to the subject that is also discussed in this case also. Now here your lordship will find that is a civil dispute, my lord. If the bill has not been paid to that, where is the question of 420 and 406? That cannot go together, my lord. 420 is a pre-minded and 406 is a post-minded.
yes, we are staying the further proceedings in the FIR, further investigation or proceeding state. Let them appear. They are not appearing after filing.
No, we appeared, my lord.
They are not appearing. Respondent number two.
But no, they have already filed Ukalat number last time also. Their name has been shown, my lord.
Yes, and
Amal Pandya, Amal Sodial. The advocate's name should be.
this is for,
Admission, my lord.
Admission, question, item 25.
we'll stay the further proceedings in connection with the FIR.
My lord,
We'll admit the petition
my lord,
and we'll let them appear.
my lord.
Then the argument Heard.
In that case, my lord, the CD, we have, my lord, but.
goes back.
Oh, my lord.
Because you have stayed the proceedings, you keep it, you send it back, matter remains the same. Heard Mr. P. Leonard, senior counsel assisted by
Case I can.
Case Saikya.
Number so on.
Counsel appearing for the petitioner, full stop, Mr. K. Parashar, Leonard. APP is present, full stop. The case diary call for has been received, full stop. We have heard I have heard the Leonard senior counsel who has submitted that the offences under section 420
406.
406 are not made out in the present case, full stop. In the earlier order dated 24/7/2026, a similar view had been taken by this court, full stop. Today, none appears for the respondents, although their names are reflected in the it's there in the
Yes. Reflected in the court.
is reflected in the cause list, full stop. Admit the petition list for hearing in its own turn, full stop. The further proceedings in connection with the further investigation and proceedings in connection with
It's my lord, Jokhala Banda PS, my lord,
Jokhalabanda PS case number
98/2024.
shall remain stayed until further orders.
Much obligation. It's absolutely contract, just make it to civil to a criminal, my lord. This
Ah.
is nothing, my lord. My lord, he can at the best file a suit.
This is of when?
This is latest, my lord.
Day before yesterday also something.
This is, no, that is about a man back. It's a man back. It was reportable, but has not been.
There is one day before yesterday also.
Same.
Civil proceedings should not be turned into a criminal trial.
Yes, my lord, that is, that.
On its own turn, list on its own turn.
My lord, that was Delhi Race Club. That was, that has been very specifically also direction not to register any cases by the police as well as the court also. Paragraph 24, Delhi Race Club, 406 and 420, so for the commercial transaction is concerned, make it to a civil into a criminal.
He has alleged that you told him that we'll pay you for it. Please repair it. You repair. After he repaired, you said, no, you go and give the bill to so and so. That is his allegation.
That is
It was for him to find out whether the bills will be paid or not. We don't know.
obliged, my lord.
Yes. An affidavit showing service of notice by Dusty has been filed by the petitioner.
My lord,
Yes, filed it.
my lord, on the previous date, the affidavit for the dusty services were not filed. We have filed the affidavit for dusty services on 26th 8.
Who is this? Who is this an Islam? Hmm. What is this? Will it suffice? Do you have a copy of the Dusty notice?
No.
Some Mr. N Islam has received it for the ACP. We don't even have a seal. Who is N Islam?
And Islam is a home guard, I guess.
Some home guard will receive it for the ACP.
He received on
Where is
behalf
the
of the
seal?
ACP.
Where is the seal? Where is the receipt number? Do you know how official documents are received?
It has to be to that person, my lord.
No, even if you say it is an official document, what has to be there?
My lord, the
Dark receipt number has to be there.
At the time of the offense, the ACP was posted in the Jalukbari. Now he is not in Jalukbari.
So you have served it in Jalukbari.
We don't have the latest address of the respondent too.
Can you find out? Huh? An affidavit, Dusty service affidavit, disability, full stop.
Respondent two.
In the opinion of this court,
Respondent-
service of notice on the respondent number 2 is not complete. Since the notice has not been received by him and the designation of the person is also not on record. Again, please see page 40. Please see your page 40. Please see page 40. And the affidavits you are filing, we are going to dismiss this. In hand, you have written Mr. Konkon Mohant or something by hand. And you have given us this thing served on somebody else.
My lord, on the first date of this case, we have ordered to take step against the respondent two only. We did not directed to take steps against the respondent three.
Page 40 by handwritten, what is that? Whose name is that? He does not have a copy of the affidavit. You don't have a copy of the affidavit.
My lord.
Do you have a copy
My
of
lord,
the...
actually, my chamber was
petitioner-
recently
the
shifted, so some of my pages were lost, actually. I highly apologize for that. My sincere apology for that.
At the request of the learned counsel for the petitioner list again on 10th of September 2026. তেওঁ এখন দি দিব। তেওঁ এখন দি দিব চাবলৈ। Have a look, go through.
Chamber was shifted, so some of the pages get lost.
The notice says, the notice includes the name of Mr. Mohanto also. How can that be?
59.
For Mohanto, you are serving on Islam, who receives it on behalf of Mr. So-and-so. And you are saying it is Dusty Service Company.
My
Can
sincere
it be?
apology for that.
Yes.
59.
Highly obliged.
May I please, Your Honor? Lordship, I am for the petitioner.
Huh?
The restaurant number 2 earlier date short time to file objection.
You won't be filing. We'll admit this, fix it for hearing then.
One thing, madam, only two PWs have been examined till now.
There is a stay.
There is a stay, but it was
2026 till then, 2 PWDs were taken.
Thereafter, there is a stay. So we'll say that we are admitting it. You are not filing any written objections, but we are admitting it. And we'll list it for hearing on 23rd of September. Heard, Mr.
Maybe call for it.
Huh?
If needed, this PWDs may be called for scan copy, if needed.
Huh?
I'll leave it to your lordship.
Bring us the certified copies. Instead of us calling for scan copies, which is heard Mr. So-and-so learned counsel appearing for the petitioner, also heard the learned APP and Mr. Bhattacharjee appearing for the respondent number 2. Full stop. Who Mr. Bhattacharjee has submitted that he would not that the respondent number 2 would not be filing written objections and would be arguing the case on merits. Full stop. Admit the petition. List again on 23rd of September 2023 under the hearing column. The parties should be at liberty to produce the further proceedings and evidence led in the trial court prior to the stay order being passed. Interim order passed earlier continues.
Yes, this revision has been filed against the order of non-bailable warrant of arrestment. In this case, we have taken steps, but service report has shown that it is whited. On last occasion, it was directed to.
Why was NBW issued?
Lordship current on to page 19 . The case was for the first time come up for the trial court on 21/5/25. Then someone was issued fixing the date on 4/8/2025. On 4/8/2025, issue fresh summon, and it was fixed on 6/11/2025. In the meantime, someone was issued, that is base 21 million. And after received that summon, the petitioner page 22, he filed an application seeking time for his advocate. Sought some time.
You entered appearance by some means.
Yes.
Then what happened?
But on the next date, he could not appear due to his illness. Neither his advocate filed.
On 19/1/2026.
19.
Oh,
I will appear.
one day. No, it is not on the allegations that he is asking for bail. He is praying that the NBWA may be kept in abeyance. He would go enter his appearance and face the trial. Heard Mr. D.A. Karim, learned counsel appearing for the petitioner, also heard the learned PP full stop. The service report on the respondent number 2, as called for by this court through the additional public prosecutor, has not yet been received. Mr. Kayyum, learned counsel for the petitioner, should we appoint someone? Mr. Kayyum, learned counsel for the petitioner, has submitted that the petitioner is not seeking bail with regard to the on merit or with regard to any of the allegations leveled on the petitioner, but has challenged the order dated 19/1/2026, in which NBWA against the accused has been issued for his single date of appearance, single date of absence. Full stop. The learned counsel for the petitioner has submitted that on all previous occasions, after receipt of summon, the petitioner had entered appearance through his counsel. Full stop. The learned counsel for the petitioner has submitted that the petitioner would appear before the learned trial court and face his trial, given an opportunity. Full stop. The learned APP has submitted that the non-bailable warrants have been issued after due consideration by the learned trial court and does not require any interference of this court. Full stop. I have considered the submissions made. Since this is not a bail petition, the requirement of serving notice on the respondent number 2 for consideration of a non-bailable warrant of arrest issued against the petitioner due to his non-appearance on a single day comma, is not necessary, is in my opinion not, would only delay the trial
No.
proceedings, full stop. In such view of the matter, I am of the considered opinion that the petitioner shall appear before the learned trial court
Yes, my lord.
within a period of 15 days.
Hmm.
15 days to participate in the trial proceedings as and when required by the learned trial court, full stop, in such till in the event the petitioner appears before the learned trial court within a period of 15 days from today, comma, the petitioner shall be released on bail on furnishing a till the appearance of the petitioner, comma, the non-bailable warrant of arrest shall be kept in abeyance, full stop. Should we require him to pay for bail there, or?
Lordship में कल के ज्ञान बिल मिल रहा only 1 day, my lord.
It's a POCSO matter.
My lord.
What is the allegation against you? Just
That is my lord, page my lord 11 my lord. It was attempt my lord 11 and section 8.
Yes.
Relation is not also my lord serious, page 11 my lord.
What is your age?
Assamese को भी in page 13 my lord.
57.
6-year-old. So we'll keep it in abeyance. You go and pray for bail there.
No, no, as your lordship.
You shall appear before the
I also
trial court on within a period of 15 days from today. You will say 15 days. You give us a date.
On within 18 September.
Within 18th of September 2026, full stop. Till the date of his appearance on or before the 18th of September, comma, the non-bailable warrant of arrest issued against the petitioner shall be kept in shall remain in abeyance. On his appearance, the petitioner may pray for regular bail before the learned trial court to continue facing the trial, which application shall be considered on merits as to whether he is required to be taken into custody for facing the trial proceedings. Disposed of.
Published.
61.
May it please your lordship. Lordship, as per the last office note, the notice is returned unserved. So we may be allowed to take fresh steps.
DV case.
DV case, my lord.
What are you challenging?
Lordship, the trial court order was in our favor, but the appellate court had overturned it. So we're challenging the judgment of the appellate court.
You are challenging the judgment of the the counsel for the petitioner prays for an opportunity to take press steps on the respondent. Prayer is allowed, steps within 5 days. List on 18/9/2026 with service report.
Obligation.
62 and 63.
May I please, your lordship? Your lordship, in this present case, they have filed a come for quashing, your lordship. Thereby, this honorable court has stayed the proceedings of 2 different cases. One is the domestic violence case present before the learned JMFC Kamrup, and the other one is a PRC case, that is a FIR. They have come for FIR quashing and the charge sheet quashing, your lordship. So in both the cases, the honorable court has pleased to stay their proceedings, your lordship. Thereafter, we have filed an IA, your lordship, for stay evicting. Thereafter, they have filed a rejoinder against the IA, your lordship. That is the present status of the case, your lordship. Your lordship, with my humble submission, your lordship is well aware with my.
What is your ground? Why are you praying for a vacation of stay?
Yes, your lordship.
Or modification of the order?
Sir, your lordship, with my because
was there any fraud played on the court? Was any fraud played on the court while taking the stay order?
No, sir.
So it was done on merits, yes? on a prima facie view of the merits, yes?
Yes, my lord.
So why don't we take up the entire matter for hearing and finish it lock, stock and barrel
Yes, lordship.
instead of going in a piecemeal manner? Once he starts paying and end of the day, we want to quash it. Will you return the money? Or we'll have to take some bank guarantee from you? Don't want to do that. So we'll take it up for
I'll leave
hearing.
it to your lordship.
Yes?
Sure.
Are you prepared? Both are prepared?
Yes, lordship.
So when can we have it? At how soon? 24th or 29th of September for disposal?
29th of
29th.
The lordship, actually on the very first week of September, the case is next fixed for DV, your lordship.
There is a stay.
Your lordship, your lordship, with respect to in the DV case, only the parents of the petitioners, there is a stay, but there is no stay for the husband, your lordship.
Proceeds.
Yes, your lordship. So
He's proceeding. He has not asked for a stay against the
No,
petitioner.
your lordship, what has happened is that as there is stay for both the parents, the learned subordinate court is reluctant to proceed in the case.
So wait, another month.
Yes, sir.
Another month. We'll have it on 29th. We'll have the matter on 29th for final disposal. In the hearing, we are recording your consent that this IA may not be taken up. The matter may be taken up for disposal on 29th
My lord, IA is, my lord, currently.
for vacation.
Yes, my lord. But the matter, my lord, in the main matter, the respondents have not filed the affidavit in opposition, my lord.
To their peril, he has agreed that it will be taken up for hearing. We'll
Okay.
take it up for hearing
My lord.
as and when it comes up. It's a law point.
My lord,
We'll not argue on facts. We'll argue on whether it can, whether
For-
the.
so perhaps the IA would be taken up first, my lord, because they've.
So you have preferred the IA.
My lord,
I was preferred by.
I was filed by my senior friend, my lord. We are for the petitioner. They are the respondents, they filed the IA for vacation of the stay orders. That is why.
You want the IA to be argued first?
Yes, my lord.
Okay, start.
Your lordship, may I please, your lordship. Your lordship, with respect to the IA, your lordship, Your lordship, first coming to the IA criminal 599 of 26, your lordship. That is, it connected with criminal petition of 560 of 26, your lordship.
I have 532.
559, your lordship.
Do 559 can 559 can give. এটা আছে এটা কি নম্বর চলি আছে হোটেলের সাইট আছে কোন সাইটে এটা কি অর্ডার আছে অর্ডার আছে we'll take this up once we take up the other order items, otherwise they'll be waiting for nothing. বাকি কি জানবি we'll take it up after 2 minutes.
Yes, my lord.
Let us take up the other order matters.
Yes, my lord.
Oblige, your lordship.
64.
Your lordship,
Yes.
matter, service report is awaited.
No, address he left. Have you given a fresh address?
Your Honor, second time we have taken, as per office note dated 26/8, notice said that speed ADA has not returned.
26/8.
Office note dated 26.
List again on 10th of September. No, have it on 23rd of September 2026 awaiting service report.
Entry order.
The interim order passed earlier continues.
65. Your lordship, in this case, I was convicted under section 138 of the Negotiable Instrument Act for a period of 6 months and to pay a fine of rupees 7 lakhs. I had preferred an appeal, your lordship. The appeal was dismissed. Your lordship, there is a delay of 1,505 days, your lordship, while preferring the appeal, your lordship.
Appeal there or here?
Here, your lordship, the revision that I have filed, there is a delay of 1,505 days, your lordship. They have filed an objection, your lordship.
Okay, we have filed the objection to that today itself, lordship.
Let him complete.
Yes.
Maybe he'll give your points. Yes.
My only respectful submission, your lordship,
Ah.
is that I'm already arrested on, and I'm behind the bars for the last 70 days, your lordship. I was arrested on 26, 2026. So I'm only praying, your lordship, the delay may be condoned and the matter may be heard, your lordship.
You'd prefer to remain behind bars?
Your lordship, because the delay is not condoned, your lordship. The delay has to be condoned fast, your lordship. The delay of 5
awarded amount of 7 lakhs.
7 lakhs, your lordship. The check
Why
amount
not?
was 3,50,000, your lordship.
But have you paid 3 lakhs?
Yes, we have already paid 2,70,000, your lordship.
Out of the 7 lakhs?
Out of the 3,50,000, your
No,
lordship.
that they have said in the trial court not.
Out of the 7 lakhs, your lordship, I'm sorry.
Out of the 7 lakhs, you have paid 2 lakhs?
2 lakhs.
If he's inside, he will get nothing. The longer he remains inside and the criminal revision is pending, he will get nothing.
Lordship, as we have filed the objection today, your lordship may hear my senior on a next date, lordship. Any date your lordship prefers.
Oh, his objection is not on record.
It has not yet come.
You have filed it today?
Yes, your lordship.
7th?
7th.
Huh?
All right, lordship.
Or when?
Third, your lordship, my lordship, because I'm behind bars, your lordship.
Heard Mr. T. Dewey, Learned Counsel, appearing for the petitioner. Also heard Mr.
I Bhattacharya.
I. Bhattacharya, appearing for the respondent number
2 and 3.
2 and 3. The Learned Counsel for the respondent number 2 and 3 has submitted that an objection to the I has been filed today morning. However, the same is not on record. Accordingly, list the matter again on 3rd of September 2026, along with the objection filed. Yes.
I'm very grateful, your lordship.
Mr. Dewey has prayed for an early date since the petitioner is languishing behind bars. Accordingly, list the matter on 3rd of September.
I'm very grateful, your lordship.
Yes, sir.
May it please your lordship.
Yes.
Your lordship, on previous occasion, notices were issued against the respondent number 1 and service trial court records were called for. We have taken steps if trial court records are available, your lordship.
No, AD card is not available and trial court records are also not here.
In short, date may be fixed.
We'll take it up on the 17th of September.
Indeed, deeply obliged.
List again on the 17th of September, awaiting the service report and trial court records. Yes.
Lordship, Mr. Viswas is still moving before court number 21, Lordship. It's a transfer proceeding, Lordship. Interim order is there.
Staying in. Interim orders, they're saying what? NI case has been.
Negotiable Instrument Act case.
You are for the petitioner.
Lordship.
Have it on
Pending
the,
before the learned Chief Judicial Magistrate.
have it on the 10th? 10th of September?
Let the interim order be continued, Lordship.
Yes. Miss, your name?
Devasri Chakraborty.
Is present for the petitioner. Who was appearing for the respondent? Someone was appearing.
I don't know his name.
Mr. Islam Learned Counsel appears for the respondent number 2. Please the matter again on the 10th of September for further consideration, for consideration, as there is paucity of time today.
Grateful, Lordship.
We'll only direct the authorities to assess the security requirement, and then if it is possible, they will allow you to attend this ceremony.
Yes, your lordship. The only thing is that the Shraddha ceremony is on 31st. So he just want to attend, it is his older brother, he just want to attend it.
All that is possible, not the entire ceremony as such. We would say that if possible, they would arrange for a visit.
Pardon, your lordship.
Yes, Mr. Goswami, I know you are not the CBI counsel, but apparently his bail petition is pending. They did their level best to serve the councils. Councils refused to take a copy of the bail, of the IA. On a request made, they said we will not appear today in the IA. Elder brother has expired. He wants to attend the Shraddh. We can direct the jail authorities to assess the security aspect of his of allowing him to, or of providing him the opportunity to attend the Shraddh within their security circle and for whatever time possible, and then draw him back at their convenience. It may not be at 7 in the morning. It can be also at 10 in the morning and up to say 1 o'clock in the morning, to their convenience. And if it is not possible for them to assess the security or to be confirmed that yes, there is no security threat, it is only then they will do it. Because it has to be assessed there, sir.
Yes, sir.
The case in which he is behind bars is not a very small and subtle case, is it not?
There was a conflict. The conflict is still going on in Manipur, Your
We
Lordship.
understand that. That is why it is taking us so much of time. Had it been Gauhati here,
And Your Lordship, the thing
it
is
would have
that
been done now.
he has been in jails for the past 3 years, Your Lordship.
Doesn't matter.
Yes, sir. I agree, Your Lordship. I agree, Your Lordship. That will come at the time of the bail application. Right now,
They
it's
may even try
expired
for
with just
a,
one.
they may even try to allow him to attend it through VC. What to do? The moment we write in the, this is what is stopping us. The moment we write in the that it could be through VC, they will go for VC. They will not even attempt to take him physically. And that is what everybody would do. When the VC is the safest mode, let it be through that.
Your Lordship, through attending through VC, it will be.
I do not know the
not.
It has been brought upon himself. What can we do?
Yes, Your Lordship.
Getting entangled in those situations, he's bringing it on.
Your Lordship, the security, there are central security forces also present in the state of Manipur.
We can't have the entire system running because you want to attend something, sir.
Yes, Your Lordship. But since it is a death, someone have expired in his family, Your Lordship, and it is his older brother, and this is the last. It is the last right. It is the last time he is going to get anything to do for his brother. So if Your Lordship permits, the jail authority may assess the situation and they may produce him, let him attend, and they can bring him back to the jail. At the most, by around 1 o'clock, the whole ceremony will be over. At the maximum, Your Lordship, by 1 o'clock, the ceremony will be over.
Can you pass that on? No, that has to be assessed. If they find a threat, it will not be done. I cannot help it. I cannot help it. I can give them the liberty to do it. Heard, Mr.
Juno Rahman.
Council appealing for the petitioner. It has been submitted at the bar that although an undertaking had been punished before the registry, that the copy of this petition will be served upon the standing counsel CBI in the courtroom when the matter is taken up, upon a request made by the learned counsel for the petitioner, the learned counsel for the CBI, standing counsel for the CBI expressed inability to attend the court proceedings today. Stop. The learned counsel for the petitioner has submitted that the elder brother of the petitioner had expired on 21st August 2026, and on the 31st of August 2026, the Shraddh ceremony of the petition of the elder brother of the petitioner would be held. He has submitted that accordingly this petition has been prayed for allowing an opportunity to the petitioner to attend the last rites of his elder brother. The counsel for the petitioner has further submitted that the petitioner undertakes to make himself available to surrender Where did I read that sentence? That the petitioner shall willingly surrender before the jail authorities. In the event, the petitioner is allowed to attend the last rites of his brother. Full stop. I have considered the death certificate annexed to the petition and also the document declaring the dates of the last rites to be performed as per the customs. Full stop. In the present circumstances, I am not of the opinion that the present petitioner can be granted the protection of an interim bail for the period as sought for in the application. Full stop. However, keeping in view the fact that the elder brother of the petitioner has expired and the last trials would be concluded on the 31st day of August 2026, I deem it proper to direct the authorities, direct the whom?
Jail.
Direct the jail, direct the authorities in charge of which jail?
Manipur Central Jail, Sajiwa.
Manipur Central Jail,
Sajiwa.
to take into consideration the fact that the brother of the petitioner has expired, and in the event the authorities are of the opinion that there would be no threat of the petitioner trying to abscond or avoid further custody, the jail authorities may arrange for the petitioner to attend the last rites of his elder brother on the 31st of August, if necessary, for a very limited period of time under custody of the jail authorities themselves or with the assistance of the state security or central security forces, if possible. Full stop. This is not to say that the jail authorities are bound to allow the petitioner such a privilege, but the same may be considered with the human, but the same may be considered also keeping in view the security aspect of granting such privilege. Full stop. List this matter again. When is the other matter fixed?
17th September.
On the 17th of September, along with BA number 2189 of 2026, since early, as no, 2126. Full stop. What more to say? This is the best we can give you. The moment we say VC, it will only be VC.
Your Worship, the last rites consists of the Shraddh ceremony, and as per the Manipur custom, there's another ceremony which is to be solemnized after 30 days. At the expiry
That
we can consider
that we will see as and when it comes
Yes, Your Lordship.
in their presence.
Yes, Your Lordship. Yes, I agree, Your Lordship.
Directed to the jail authorities are directed. The jail authorities would be at liberty to consider the case of the petitioner. You have to leave it to them.
Yes, sir.
And you have to make an appropriate application there also.
Yes, Your Lordship.
That this is the order of the court and therefore allow us.
Yes, sir.
You have only tomorrow.
Yes, sir. I'll have to fly back tomorrow morning itself, Your Lordship.
Order to
or if Your Lordship may send a message to the jail authority from me, that will be.
No.
Because I'll have to get a certified copy of the.
certificate copy to Nepal in view of the paucity of time, since the matter has come up at the end of the board, and obtaining a certified copy at this stage may not be possible for the counsel for the petitioner, the counsel for the petitioner shall be supplied a copy of this order and the certificate of the court master. Certificate of the court master, this is an original copy boli apni khali ek line likhi dibo. True copy of order dated so and so likhi dibo. It is not a certified copy. True copy of the of this order attested by the court master for immediate use.
Deeply obliged.
Supply a copy of this order attested by the court master for immediate use. But নিদিলে তো একো লাভ নাই, মই যদি এনে অর্ডার লিখি থৈ দিওঁ how will it happen? মানডে ললে কি লাভ হ'ব? কাইলৈ খোলা আছে বাৰু। কাইলৈ ললে গৈ পাব কেতিয়া? তাত গৈ এপ্লিকেশ্যন কেতিয়া মুভ কৰিব? দেওবাৰে বন্ধ থাকিব। সোমবাৰে ৰাতিপুৱা 11টা বজাত যদি এপ্লিকেশ্যন প্ৰচেছ আৰম্ভ কৰে, চিকিউৰিটিটো কেতিয়া এছেছ কৰিব, তাত নিব কেতিয়া? ফিউটাইল অৰ্ডাৰ এটা হ'ব তেতিয়া। সেই পাৰ্টটো বাৰু ৰাখি দিয়কচোন, এই লাষ্টৰ পাৰ্টটো ৰাখি দিয়ক মানে learned counsel for the petitioner is permitted to download a copy of this order from the website and produce the same before the jail authorities due to paucity of time. I think that should work. That should work.
Deeply obliged.
Etu agote mari dibo. Ahile etu aji upload kore. Anything more?
Deeply obliged.
No more. Well, 62 and কোনখন আহে? এই কোনপাতি yes. বেলেগ এটা কৈছে, you want 559 to be taken up. 559 to be taken up.
Yes, Lordship.
IA 559. Yes.
May I please, Your Lordship? Present IA has been preferred by the applicant while seeking vacation of the interim stay order dated 23/4/26 passed by this honorable court in criminal petition number 560 of 26, Your Lordship, whereby the proceedings of the PRC case number 26 of 24 pending before the learned judicial magistrate first class Hajo Kamru Metro has been stayed, Your Lordship. Your Lordship, in brief, Your Lordship, the whole FIR alleges that, Your Lordship, it contains the Lordship, the sections of 498A, Lordship, 406. So, Lordship, in brief, Lordship, it states that she was being tortured by her husband and the family members, and thereby the Sridhan were being sold. So that is the basic allegation which is there in the FIR, and the same is being reproduced in the charge sheet, Your Lordship. The last charge sheet, prima facie, it establishes that Your Lordship, she was subjected to torture, and the
Tell us why you want a vacation
Your
of the
Lordship,
stay.
vacations, with my humble submission, why, Your Lordship, they have suppressed the fact, because now at present there is another FIR against the husband, because he being first of all, he being a government servant, Your Lordship, without dissolving the first marriage, he has again married, Your Lordship. Now,
There
Your
is no
Lordship, why the vacation is required at this stage?
Was the FIR which was stayed, the proceedings of which were stayed, is it the FIR that 612026 in 559 of 2026? Page 24 of your IA?
Your Lordship, that is a different FIR, Your Lordship, with why we.
Has it also been stayed? No.
No, Lordship.
This is not under stay.
That has not been stayed, Your Lordship.
This is
Which
a
is
fresh
the-
FIR,
Huh?
which, this is actual, may I, if I may sub.
Your Lordship,
This is his application, he will submit.
Lordship, that is a fresh FIR. Why we have annexed is that because, Your Lordship, because, Your Lordship,
Which is the FIR which has been stayed?
Your Lordship, the FIR is, Your Lordship.
My lord, page number 24 of the main petition, my lord. The entire case has been stayed, my lord, the PRC case. PRC case number 26 of 2024.
দিয়কচোন এখন 560
560, my lord.
criminal petition 560 criminal petition. I will. Yes, which is the FIR? Page 24.
Lordship, yes. 24 is the FIR, Your Lordship. No, Your Lordship, he has appeared before the Lane JMFC, and after he's entering his appearance, Your Lordship, they have come for a quashing. And thereafter, on the very first day, it was stayed, Your Lordship. Now, thereafter, we have filed an IF for the vacation of the stay, Your Lordship. So, Your Lordship, why we wanted to be vacated is, Lordship, is that because Lordship, it's been almost more than 6 months, Your Lordship. The complete proceedings of the PRC case pending before the Lane JMFC has been stayed, Your Lordship. And with that also, Your Lordship, that other matter which has been tagged up is a domestic violence, Lordship. So due to the stay of the parents of the present petitioner, the Lane subordinate court is not willing to proceed in the case. So as a result, Your Lordship, I am facing severe hardship, Your Lordship, because there is a plea of maintenance over there in the domestic violence also. So in a way, the whole subject of the proceedings which have been filed against the husband have been stayed, and it has not been able to proceed, Your Lordship. So as a result, Your Lordship, there's a I have a 4 years little son, Your Lordship, who is residing with me, Your Lordship, and I'm facing financial hardship, Your Lordship. I'm not able to proceed in the case.
Now, sir, in this particular FIR,
Yes, sir.
you want him convicted? Yes.
So,
Only
Your
his
Lordship,
conviction will.
that is a matter of trial, Your Lordship.
You want his conviction.
Yes, sir.
You want his conviction. I'm not saying he's going to get convicted. You want his conviction.
Yes.
The stay of that proceeding as of now, how is it causing any distress to you?
Your Lordship, with my humble submission, it is not causing any distress, Your Lordship.
Okay.
But the matter is being delayed, Your Lordship. Why, Your Lordship? Because there is another matter, because in the meantime, it is on the very nascent stage, initial stage, Your Lordship.
There are two things, sir. One thing is that you need a speedy trial because you are asking for some relief.
Yes, sir.
And there is one thing that when everything is stopped, how can this be?
Yes.
Please speed it up. There are two things. In this particular case, the allegations are that he has sold off your jewelry, he is demanding money from you, he is demanding that, demanding this, he has thrown you out of the house and all that.
Okay.
Now, this court, for some reason, on the first occasion, stays it. That don't proceed with that, we are listening to it. He must have some grounds made out. Now, that we propose to hear the final grounds on 24th of September. I think that is the date we said.
29th of September.
29th of September 2026, we would hear the entire petition. It is not about a stay, it is either it proceeds, it does not proceed. As of today, what other ground you have got for vacation of the interim order?
So my grounds are very.
Except that the trial should commence.
Yeah.
So that can be decided when the.
Final hearing.
Okay. This is one application. What
Yes.
is the other application about?
The other application, Your Lordship, relates to the DV proceedings, Your Lordship.
In the DV proceedings, what has happened?
Your Lordship.
In the DV proceedings, did you pray for any maintenance, alimony, anything?
Yes, Your
Even that maintenance part is stopped,
Yes, Your Lordship.
it is under stay.
No, Your Lordship, only the stay has been granted against the parents of the present petitioner. Now, what has happened, as there is a stay.
We will clarify in that petition that your claim for maintenance can yet be considered even though the proceedings under against the father and the mother is kept in abeyance by this court. Yes, that will do.
Yes.
May I kindly just interject for a moment to what my senior friend has stated? My lord, in the DV proceedings, if my lord would have the file for just 1 minute.
Yes, 1 minute. We have got 3 more minutes. Yes, dear.
DV case to do. Dada. Dada, DV case. Sorry, 5:30. Lordship, I'll just narrate the nutshell of the case, my lord. Here, my lord, actually the wife, my lord, she's actually having an illicit affair with another person, and
Fantastic.
because of that, because of that, my lord, she is filing all these frivolous cases. My lord, in one case, my lord, FC criminal case, my lord, she is already getting a maintenance from me, that is rupees 13,000. My salary is 46,000.
Sir, just tell us one thing.
Yes.
The order dated 8/4/2026 in criminal petition number 532 of 2026
Yes.
says that the proceedings against your mother and father
Yes.
would remain stayed.
Yes, ma'am.
There is no stay in the proceedings against you.
No.
Are we on the same
Yes.
page on that?
Yes.
Yes. We clarify that the stay is not against the proceedings against you. We do not say, please proceed, please come to a judgment, please. We do not say anything. We simply say that there is no stay of the proceedings against you. The proceedings against petition number 2 and 3 has been stayed by this court. And that is how it remains for the time being till the matter is heard. How can you have an objection to that?
No, I'm not having an objection.
Then
I just want to place one important
you
point.
are,
One important point. My lord, in the said DV case, they are seeking at page number 26 and 27, they are seeking monetary relief of 40,000 from me.
from you. The court has not stayed it on the first day.
But I'm earning 46,000.
Oh, you come and you pray for a stay to be granted to you also. A protection for yourself also. A protection taken for the parents
No, my lord,
will not protect you.
understand, my lord, but my difficulty is my salary is
You
46,000.
you move an appropriate application, you prove before the court that I've got 46,000, sir. I cannot pay 40,000.
My lord,
You contest it.
that is also a matter of trial. My lord, it is an admitted position of admitted by them, my
Sir,
lord.
we are not changing the order dated 8/4/2026. We are simply stating what 8/4/2026 said. How can you be in difficulty of that? You have been granted a stay against the petition number 2 and 3.
Yes, ma'am.
Proceedings against petition number 1 has also stopped.
My lord, why it has been
So we
stopped?
will clarify that it is not stopped.
My lord, perhaps my lord, the difficulty is if any observation is made today, my lord, monetary implications would also be there.
May
Because they are
come.
seeking monetary relief, protection, and everything.
Yes.
So, my lord, monetary, how will I give? My lord, 40,000 they are asking, 10,000 they are asking. My lord, my salary is 46,000. So
When you do not have a stay from this court for the petition number 1,
my lord,
how can the petitioner number 2, how can I stay on petition number 2 and 3?
my lord, it will have a direct bearing on my old and aging
That
parents.
is what
I
the court
pay for
intended.
their medicine, I look after
That is what the court intended. The court did not stay the proceedings against you. Why?
My lord, how
The court intended it to go ahead.
I understand, my
Then-
lord. But the difficulty is a person earning 46,000, how can he pay 40,000, my lord?
That is for you to convince the trial court or to convince us that please stay the proceedings against me also.
My lord, that will happen during the stage of evidence, my
No,
lord.
during my stage, you can move an application saying that now they are moving it.
No.
Please stay, please give me a protection. You are not doing that.
My lord, I want to. My lord, I want to
You
press
could
the
have.
matter. My lord, I want to argue the matter. My lord,
But-
today nothing may be done.
We said that we will take up the entire matter without passing orders anywhere.
My lord,
On 29th,
my lord, on
you
that,
insisted on a hearing. Now you would have an order.
my lord, on that day,
You have to understand what the court intends for the.
so my
If
lord, I thought,
if we are causing you any distress, then you point out that, sir, this will make a distress to me.
my lord, I thought,
When we are saying that we'll take up the entire matter, we'll not change anything. It was in your favor. It was to his disadvantage. You wanted a hearing today. No, I want the I heard now.
no, my
Done.
lord, I didn't want a hearing, my lord. I was on the,
You said so.
no, my lord, I was on the point that
Heard. Mr.
I
P.R.
should-
Sharma, learned counsel appearing for the petitioner, also heard.
Yes, Vishwas.
Learned counsel appearing for the respondent number 2, Mr. MP Goswami, the learned APP appears for the state. Full stop. It IA criminal 552 of 2026 or click here. So, huh? Oh, petitioner no hobo. You will have to write Mr. Biswas for the applicant. Hobo. Town it I can wrote to hobo, no? Mr. Biswas for the applicant. And Mr. Sharma for
my lord,
opposite party number 1, 2, and 3.
yes,
Goswami as the APP for State of Assam. The learned counsel for the petitioner has for the applicant has submitted that the interim order eight four two zero two six in criminal petition 532 of 2026 would require would require a modification from this court. Full stop. He has submitted that would require a modification from this court. Mr. Sharma, learned counsel appearing for the opposite parties oblique petitioners in the criminal petition has submitted that the objections with regard to the same has been filed. Full stop. Upon hearing the learned counsel for the parties and upon consideration of the materials on record, comma, this court notices that by the order dated actually 842026, this court had directed that the proceedings in DV case number 32 of 2025 pending in the court of the learned JMFC Hajo Kamrup be stayed in respect of the petitioner number 2 and 3 in the criminal petition, that is against the father and mother of the that is against the father and mother, father-in-law and mother-in-law of the complainant in the DV case. Full stop. We notice that there is no. Now, after hearing the learned counsel for the parties, we do not see any reason to modify the aforesaid order since the same would also have an effect on the final outcome of the criminal petition. Full stop. Accordingly, in the present application, instead of taking up the present application for disposal today, comma, it is directed that the criminal petition number 532 of 2026 be listed again on 29th of September 2026 for a final disposal. Full stop. Now, do you understand when you should force and you should not force?
No, my lord, I was actually in legs in another court. I didn't
Very
understand
well.
what happened.
Very well. Then when you enter a court, this is why we are saying this, because we have seen you performing the court, we'd like you to do better.
My lord,
Yes. So the next time you come into the court, find out what the court is trying to say, find out what is happening in the court, and then approach the case. Because you have got a sword in your hand, you cannot cut and charge at everybody in front of you. Someone may be trying to understand your problems. Yes. And we'll have it on September. In a month, we'll have your matter disposed.
Only with the observation, your lordship, so that it may, the learned subordinate court.
No, we will only say this much. A criminal petition to Likhibo. Today by an order passed in so-and-so, this petition has been directed to be fixed on 29th of September 2026 for final disposal. Parties are, learned counsel for the parties are requested to be prepared for a final disposal on that day. এইটোত লিখিব আই ক্ৰিমিনেলত ওপৰতো আই ক্ৰিমিনেলত লিখিব যে list this matter again on the 29th of September 2026, on which date an attempt would be made to dispose of, to finally hear the matters and dispose of the same. Full stop. Learned counsel for the parties are requested to be prepared for a disposal on that day.
Highly obliged.
Interim order. Interim order passed earlier, may continue in the other petition, my lord. Interim order passed earlier to.
Interim order passed earlier continues. আৰু ইটোত ইখনত লিখিব মডিফিকেশ্যন নাই কৰাটো ক্ৰিমিনেল পিটিশ্যন নম্বৰ কিমান সেইটো প্ৰথমতে যিটো অৰ্ডাৰ দিলো তাৰমানে 560 ক্ৰিমিনেল পিটিশ্যন 560 of 2026 দিব interim order passed earlier continues since no modification has been directed in the IA criminal.
Oblige.
May please. Yes. Are you prepared? Okay. What is this matter about?
Criminal revision.
Where is the other one? The opposite party?
Notices were served upon the respondent number 20, but no one is.
They have not appeared.
Yes.
What have you challenged?
The proceeding pending before the additional session judge, Gauhati, Your Lordship.
Regarding what?
Criminal revision petition, Your Lordship, arising out of an interlocutory order, Your Lordship.
Are you challenging page 40?
Yes.
Which is the page you are challenging? Tell us.
Yes, it's page 40. Your Lordship.
Mr. Goswami,
This
we
is
are
the
holding you at ransom at 450. But tell us, page 40 is
page 40
the original order?
Original order
Very well. This is an order passed
by the executive magistrate
on
on 37.
37/2024. Yes, under section 165 BNS.
Yes.
What is the lifetime of such an order? Hmm? Please. Let us go for some BNS is some What is the lifetime?
Your Lordship, it's subject to the extension, Your Lordship.
When? How many times?
1 year, Your Lordship.
At the maximum?
Maximum of 2 years, I think.
Huh?
2 years, I think.
Maximum of?
1 year is the provision, but there is an extension provision.
Oof. He may attach the dispute until a competent court has determined the rights of parties there to with regard to a person entitled in the provision so and so, so and so. (160)(5)(1). Competent court decides your rights.
Yes.
Have you approached the competent court?
No. I was the applicant in the original criminal proceeding, Your Lordship. Then the executive magistrate passed an attachment order. It was challenged by the respondent in the revision. Now the
Appellate court has vacated it.
Yes, vacated it.
Vacated it. Why don't you go to a competent civil court and get your rights and titles declared? And
No, it was an interlocutory order, Your Lordship. Interlocutory.
You want us to settle the law.
Yes, sir.
And give no relief to the clients.
Yes.
Will your clients get any relief?
Yes, Your Lordship. Immediately, when I was supposed to approach the civil court, Your Lordship, but deciding my rights, but immediately the revision was filed. It was not supposed to entertain the revision by the Court of Session, Your Lordship. Then
what happened?
The bar is there, Your Lordship.
What happened? Thereafter, what happened?
Therefore, immediately they have a vacate order was vacated.
Vacated. Then after the vacation, what happened?
After the vacated, Your Lordship, we both are at the same place, Your Lordship.
Where are they? Where are you?
In the disputed land, Your Lordship.
Are you in the possession? Yes.
We both
He is also in the possession.
Yes, Your Lordship.
Now we will say this revision was not supposed to be allowed.
Yes.
Then what happens?
No, we'll approach the.
Then what happens? Then the attachment will come into play. You both will be out. Where does it leave your client? This was correct in 2024, sir. Is it correct in 2026?
Yes, Your Lordship. But now,
operation successful, patient died. What is the use?
Understood, Your Lordship. Otherwise,
Getting it? Have you approached the civil court?
No, not yet, Lordship.
Not yet. You have got 2 years. You did not approach the civil court to get a interim.
Yes, sir.
Last time this matter was listed was in June 2025.
Yes.
No, it was first came up in April, then in June 2025, then it came up in 29th of January 2026. Now it is coming up on 28th of August 2026.
After making so many applications before the registry.
Your applications are available on record, sir. There is only one. There is one.
There is a mention memo, Your Lordship. That is a mention memo.
There is no other application.
Before the registry, Your Lordship. Anyways,
does this have any value today? Find out.
otherwise, Your Lordship,
Are we just
I'm challenged. Yes.
flogging a dead horse? Look, legally, you may be correct. Does it take you anywhere?
Now,
A Mercedes without a petrol.
yes, Your Lordship. Now we are at a situation that we both want to settle the matter amicably.
Please.
Yes, because I am the actual owner of the land.
You want it to be sent to the mediation?
No, not mediation.
And you want to settle it amicably? How?
The respondents, they are ready to.
There is no order now operating against any party?
No.
In the civil court, in the criminal court?
Now, yes, we cannot.
Why don't you sit down and settle it?
Yes, we are on to settle.
Then why are we hearing it?
We want to finish it off, Your Lordship.
To do what? To saying what?
I don't know, the revision is pending, Your Lordship.
I will close it.
Yes,
That
is all I want, Your Lordship.
If you say that you are coming for a settlement and this criminal revision need not be pursued, we'll close it right now.
All right, then.
Have your instructions. Why take the risk?
Yes, sir.
Otherwise, see, this is not taking you anywhere.
Yes,
it is only a burden on me at 5 o'clock in the
Yes.
Why I'm calling it a burden? No relief.
Yes.
A case where there is no relief.
Only that, Your Lordship, the order which was passed in the revision petition, it should not have been exercised.
Maybe.
That is the
Maybe,
only
but
thing.
has it not lost all its relevance?
Yes.
As of today.
Yes, as of today, yes.
After you had the opportunity to go to the civil court, after you had all the opportunities to do everything.
Yes.
Has it not become something?
Yes, I now I will, on the point that we'll approach the civil court. Yes, Your Lordship.
You have to do something about
Yes.
it, but not this.
Yes. Now, once this proceeding is ended,
Should I close it today or should I
Yeah,
say?
Your Lordship may close it today. Yes. Otherwise, this is unnecessarily pending, Your Lordship.
You are Mr.
Visitas.
We are not pressurizing you in any manner, are we?
I understand.
Huh?
I understand.
We don't want you to do it under pressure, but
Otherwise,
we want you to understand that the lesser the burden, the more we can concentrate.
Yes. But the legality of this order,
we will say that the
Yes.
legality of the order has not been decided upon.
That is.
Would remain open to be adjudged in a proper case. Huh? The heard Mr. Swensel and counsel paying for the petitioner.
And Lordship, one thing, Your Lordship, on the very next date, when the order was passed, the revision petition, I appeared before before the trial court in the revision. Even notice was not served upon me. They expertly passed the order in the revision. Notice was not served upon me, and I have appeared. I have stated everything, but the honorable trial court was not on the point.
At times it happens, but then you see when. You have to strike when the iron is hot.
Yes.
For many reasons, it may become cold,
Yes,
but
yes.
once it becomes cold.
Yes. Also, I indicated that this 438 cannot be exercised in an interlocutory order. But my prayer was not considered. But they again.
It should have been done on the first day.
Yes.
All this should have been come on the first day. Heard Mr. Swensel and counsel for the petitioner. Also heard Mr.
Only
MP Goswami, learned
that submission may be
public
recorded.
prosecutor. The learned counsel for the petitioner has submitted that the revisional powers exercised by the appellate powers exercised by the learned court of session in the by interfering with the order dated
31/8/2024.
37/2024 passed by the executive magistrate in case number 874 of 2024 was wholly uncalled for since since was only uncalled for since the order dated 37/2024 was an interlocutory order, and also it was, and the interference by the learned court of the sessions was without any notice to the petitioner's hearing or the counsel for the petitioner's
Respondent in the revision. I was the
public respondents in the revision petition. The learned counsel for the petitioner submitted that in view of such violation of the settled position of law, comma, this criminal petition had been initiated, full stop. The learned counsel for the petitioner has, however, fairly conceded to the fact that now, at this belated stage, comma, when both the parties are also contemplating to settle their disputes amicably, comma, an adjudication on merits of this criminal petition may not be called for. Accordingly, the learned counsel for the petitioner has submitted that this criminal petition may be closed, granting the liberty to both the parties to approach such forum of law or mediation, as the case may be, for settlement of their disputes, if any. Accordingly, this criminal petition is closed, leaving the parties the liberty to approach such forum of law or for mediation as they may decide.
Also, the revision petition, revision lordship, they may, this is no means of this revision petition, because the land is now vacated and we are both settling in the same land, your lordship. So there is no need of the pendency of this revision petition. So
since the counsel for the petitioner has submitted that the petition, both the contesting parties are now living on the same land in dispute amicably, comma.
It's a business place, not a residential place. They are running the two shops in the
They are running their individual shops in the disputed land without any dispute and differences amicably, comma. The proceedings before the learned session judge, additional session judge in criminal revision number?
Revision number 21 or 24.
Maybe also closed, full stop. The petitioner shall be at liberty to move such appropriate application before the additional session judge, along with a copy of this order passed today, praying for closure of the aforesaid revision petition before the learned additional session judge, Gauhati. You move an application there, they'll close it.
Deep level.
Thank you.